day in the USA, people find themselves in court.
All right. All right, now what was the one you were saying we need to take up, Mr. DeMoss? James Arnold DeMoss on page 3. We have Mr. DeMoss back there. Maybe I wasn't clear. While we're waiting on Mr. DeMoss to be brought out, on page 1, there's 2011 CR 755 State versus Joshua A. Adkins. Mr. Adkins, I'm showing he's here for a hearing. Do you have a lawyer, Mr. Adkins?
Kelly Jackson. I don't see her here today.
Will you retain Ms. Jackson Smith?
I paid her a consultant fee.
So I
Your
can,
motion to revoke bond is granted and the bond is revoked. All right, bring out Mr. DeMoss. All right, Mr. DeMoss, we're here again on your motions that you have filed in this case. So that I can understand better, I know that you have filed a motion to compel your lawyer to, or the public defender to file a motion for your post-conviction release, I think the way you have it styled. What exactly is it you're saying? And I understand before when we were here, my argument or my response to your argument was if you feel that there is an issue, then you need to have your lawyer file something. And I don't know whether or not the Public Defender's Office has looked into this at all. Mr. Talbot, can you address this issue with Mr. DeMoss? Let's go ahead and turn your microphone on there on the table, and let's let you deal with it there.
Yes, sir. Thank you, Your Honor. On this, my understanding is that first, the Public Defender's Office no longer represents Mr. DeMoss. And then second, with respect to his, I guess his goal here, all that the Public Defender was tasked with doing, I think by the court last time this was addressed, was to explore the possibility of whether an agreement could be reached on this for an agreed PCR, I think was the language. Mr. Mitchell explored that with the state. There was no agreement about resolving this to Mr. DeMoss's satisfaction, and therefore that concluded that effort.
Mr. DeMoss, what is it that you say is incorrect? Now, what I have attached to your motion is that you entered a plea of guilty back on March of 2024, March 12th, to a count 7 of an 8-count indictment, evading under TCA 3913-503, and you received a sentence of 2 years to serve in the Tennessee Department of Corrections, consecutive to a prior case of 2016 CR 346. And you were given credit for time served, and that credit was set out at March 17th, 2022 until September the 13th of 2022. Well, I'm not clear on what exactly is it that you're saying is incorrect or something that you believe that this court can address.
I'm gonna make it easy for all of us. I'll go home in 10 days off this case. So
Is that microphone on? All right, step up to the microphone.
I'll go home in 10 days anyways on this case. So I just wanna let you know that I've done 4 years on a 2-year sentence on this right here. And last time whenever we talked, Mr. Mitchell was supposed to do a post-conviction release that you told him to get with the DA, and he never did file. And whenever I went to court back in March or April in front of Wallace, he told him that it was denied. But whenever I asked him for a copy of it, he refused to give it to me. But that's fine. I go home in 10 days, so, you know, we don't even have to be here.
In 10 days, you're going to be released?
Yes, sir.
All right, well, let's just, good luck to you.
Thank you, sir.
All right, show whatever that motion was is dismissed. All right, if we have other inmates, let's go ahead and bring them out one at a time, please.
Thank you, Your Honor.
If we're ready on an inmate.
Good morning, Judge.
Good morning. All right, this is Juan Esteban Brooks, and this is a hearing on the violation of probation. You have previously been offered to have an attorney to represent you. Do you not wish to have a lawyer?
No, sir, I'm go pro se.
All right. Is the state ready on this hearing? You are here today because it's alleged that you were placed on probation on or about December the 4th, 2024 for the offense of failure to report, or I'm sorry, you were placed on probation.
It's all junked up, B-Dog. I had escaped from the Hope Center 11/21/23, and I got from Vind Engine, the sheriff had a release date of 11/25/24. So when I came into my plea with my elbow counsel, Matthew T. Mitchell, he gave me a suspended to probation, but it was, I had already did my 11/29. I had completed my sentence. So it was just a misunderstanding of paperwork. So I never showed up for probation, being that the sheriff gave me my 11, I was already serving 11/29. So it was just a misunderstanding. So when I got my case dismissed from a couple weeks ago, my theft of property from Judge Marshall, him and the DA came through for me and gave me a dismissal. So I just wanted to clear up today that so I could go home for my BOP already served on misappropriation of paperwork.
All right, well, listen to me as I explain
Yes,
this,
sir.
okay? What I have before me is a violation of probation warrant that was filed on April the 28th of 2025. It alleges that you were placed on probation for escape on December the 4th of 2024, and that you were for a period of 11 months and 29 days. And part of the grounds was that you had not reported since your release from jail on December the 23rd, 2024. That's one grounds. But listen,
Yes, sir.
on the last grounds, it says that you were arrested for theft of property in Dixon County on April the 22nd of 2025.
Amen.
That would also constitute a grounds for violation of probation.
Amen.
And what I want you to understand is that I understand your explanation for not reporting or whatever the situation
Yes,
may
sir.
be,
Yes,
but
sir.
that is a separate grounds that you were violated your probation by being arrested on a new offense.
I got it dismissed.
All right, so does the state have any input in this particular situation? I'm sorry, he pled to what?
whatever other charge he was serving in general sessions. So that's where the issue.
I just need y'all to let me go. It was just a misappropriation of paperwork. We just gonna cut them on loose.
His point is that he's given some explanation for why he didn't report, and he says that the new charge has been dismissed.
Judge, I'm familiar with the charge. My understanding is the victim or something along that line.
Snow.
And
You be quiet while she's talking.
Yes, sir.
I didn't handle that. Discretion is correct, at least it's not. One is no longer going to be a basis.
Snow.
At this point in time.
Thank you, Lord. Officer Snow, will you let the judge know that I got my dismissal last week? You didn't.
You're going to call him as a witness?
No, he let me know
I
last
understand,
week.
but you're winking at him and saying, would you let the judge know something? If you're going to let the judge know.
I'm sorry. It's only when I got the voucher for me when I got on the bus to go home. Snow had let me know. Snow, you would say that if I call you up here, you would let me know that I had a dismissal.
Who is this probation officer?
Ullery.
Come around.
Here we go.
What are you saying uh-oh about?
Leather boots.
All right. My understanding is that I'm just going to ask you some questions. I'm not calling you to testify just yet. Just stand right there. You don't have to go anywhere else. My understanding was that part of your original basis was that he failed to report.
Yes.
The second was that he had this new charge. I'm now being told by both him and the state that the new charge has been dismissed. It might be subject to reinstatement, to being brought again. Were there any other issues with his probation other than the fact he didn't report once he was released?
The fact that he did not report probation.
Okay. All right, thank you. You can go back over there if you want to. You don't have to testify. All right. Do you understand that you didn't ever report to probation? I understand your reasons why. Okay? So if I credit you for telling me the truth about that, then the only thing that I would be prepared to do today would be to reinstate you to probation and extend your probation for 11 months and 29 days but you would be released. Now, that new charge that you're talking about that got dismissed,
Right.
I don't have anything to do with that.
Okay.
You understand
And
that?
she's okay with it?
Well, she's not okay with it because she doesn't have anything to do with it either.
Yes, sir.
But what we'll have to see is whether or not that criminal charge comes back.
Got you.
But today, the only thing that I would have,
Send me home.
you know, that against you for your violation of probation would be the fact that you didn't report. Now,
Okay.
you, without testifying, gave me an explanation. So I'm going to ask you to raise your right hand, and I'm going to have you placed under oath.
Thank you. Yes, ma'am.
All right. Why did you not report when you pled out on that original charge of escape?
Thank you. Okay. 11/21/23. That's when the escape came. So I served from 4/23/24 to 11/23, from 4/23/24 to I was released on 12/23/24. I didn't report because it was a misappropriation paperwork. I had to serve 9 months. I had to serve 11/29 on an escape at 11 months. 29 at 75% is 9 months jail time. So when I went pro se, I had 48 days from 9/22/23, and then I served 8 months straight. So when I served my 8 months, I'm assuming when when Matthew T. Mitchell, my elbow counsel, when he said, I'll let you go on the vandalisms. I had got indicted for 2 vandalisms. So he said, I would let you go home. Contingent upon you signing that you
Your
would take.
lawyer said you could go home?
That's the only way I could go home is if I signed for her probation. So when I signed for her probation, it was a suspended sentence to probation. That makes sense. So I'd already served. In my mind, I'm thinking I'd already served the escape. So I didn't get 2 escapes. I only got 1 escape. So
All right, that's fine.
yes, sir.
Does the state have anything else to input in this?
Sign the probation.
So I had 8.
You be quiet. When
Yes,
she
sir.
talks,
I'm
you
so
be
sorry.
quiet.
Clearly isn't, or he admits he's never reported.
Well, Mr. Brooks, I'm going to give you a chance to report and see whether or not you do or don't.
Thank you, Judge.
I find that you are in guilty, technically a violation of your probation for failure to report. I understand what your explanation is. The new charge that was the basis for it obviously can't be considered because it's been dismissed, but you
Amen.
understand that could be brought back. I'm going to reinstate you to active probation, extend your probation for a period of 6 months, and I'm going to set a review date for this case in front of me on September the 29th.
So I get to come in regular clothes?
You're going to get regular clothes?
No, I'm saying, do I get out today?
Well, as far as I'm concerned, I'm releasing you back to probation. So
Okay.
you should be released as soon as the paperwork clears. And then, but you understand, see that lady over there?
I know
You have
exactly
got
where
to-
Mid-Cumberland is.
Okay. One thing that you're going to benefit from in the future, because I fully expect we're going to see you again, if
Yes,
not
sir.
before September. When you're in court and someone else is talking, you just wait till your turn, okay? It's like when you're a child and you're at the dinner table and you're told you want to speak over your parents. Well, in the court, it's the same way. You can't talk while I'm talking. You can't talk while the DA's talking. You wait your turn. You'll be given every opportunity to say what you want to say. But here's the reason that I'm doing this today is because I'm giving you an opportunity to see how you report. Once you report, and between now and September, if you do everything you're supposed to do, stay out of trouble, then we'll take a look at you on that September 29th day to see whether or not there's any need to keep you on the docket, okay? See her? You need to talk to him today? All right.
Amen. Thank
Yep.
you, Judge.
All right,
We done?
we're done. 2022 CR 390, State versus Josie Harrison.
Your Honor, for Ms. Harrison, she was furloughed pending sentencing to Mending Hearts. She successfully completed that program and has remained on furlough until today. The agreement to resolve this is for.
Judge, the next one up is going to be Larry Salter.
On page 18, Larry Dwayne Salters.
Governor, Mr. Salters will also be admitting that he violated his community correction sentence. He's going to serve 180 days, day for day, and then he will likewise be furloughed to treatment at such time with a similar agreement. Should he complete, he would be reinstated. If not, he would be revoked.
Mr. Salters, raise your right hand. Let's place you under oath. State your full name for the record.
Larry Dwayne Salters.
Mr. Salters, you're here today on a charge of violation of community corrections. I want to make sure you understand your right. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation? You understand? Speak up, because we're recording this, okay?
Yes, sir.
Do you understand that if you had that hearing, you'd have the right to have a lawyer, to have one appointed if you could not afford your own? And of course, we've done that with the public defender.
Yes, sir.
You understand that if we had that hearing and I found you guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that if entering this plea, you're waiving your right to a hearing and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
You understand that that means you're going to serve 180 days, day for day, and then you're going to be released to treatment. And he's getting credit for time served against that 180 days?
Yes, sir. He's been incarcerated for a little while.
All right. So you get credit towards that 180 days. Thereafter, you're going to get a furlough order to go to treatment. Furlough order means you are released from jail for one purpose only, to go directly into treatment and successfully complete that treatment. If you do that, then you come back and the agreement is that you would be reinstated to community corrections. If you don't successfully complete it, you walk away or you get kicked out, then you got to go right back to jail because you're going to go to prison to serve out your sentence. If you don't go back to jail after you get kicked out of that program, then that's another felony escape from a charge that will be brought against you. Do you understand that?
Yes, sir.
You understand everything I've explained to you?
Yes.
Do you wish to enter a plea according to this agreement and waive your right to a hearing? I don't care if you do it or not. You don't seem very convinced to me.
Yeah.
I would be a little bit more enthusiastic if I was to be given another chance after
Yeah,
chance
yes, sir.
after chance. So what do you want to do?
Yes, sir. That's
You,
fine.
you want to
agree.
do this?
Yes, sir.
With your heart and soul, you want to
Yep.
do this?
Yes, sir.
You want it more than anything else?
Yes, sir. I guess so.
You want it more than going to prison?
Yes, sir.
Doesn't matter to me. I can send you to prison today if you'd rather.
I'd rather just do it. It's better myself.
Do you want to do the
Yeah,
rehab?
Yes, sir. Yes, sir.
I'm somehow not too convinced that you're going to be very successful in the rehabilitation. You understand that if you go and if you get the help and you successfully complete it, then that's going to be your opportunity to stay out of prison. If you don't, then you're going to go to prison. You understand
sir.
that?
Yes,
It's just
sir.
your choice. It's up to you.
Yes.
So what happens from this point is entirely up to you. Your lawyer's worked out a deal to give you that chance.
I'm fine with that, Your Honor.
I'm reluctantly going to give you this opportunity. And as I said, it would seem to me you might want to be a little bit more excited about. I understand going to rehabilitation is not necessarily what you want to do.
Yes, sir.
But if you need help with your drug problem, then
Yes,
this
sir,
is
I
your
do.
opportunity
I
to do it.
Yes, sir.
All right. Then
I'm fine
upon
with
your,
that. I'm fine with that, Your Honor.
all right. Your plea of guilty to violation of probation, I find you guilty, order that you be ordered to serve 180 days, day for day, with credit for time served. You will then be granted a furlough to a long-term treatment that your community corrections officer selects, and you'll be required to enroll in and successfully complete that treatment program in order to be reinstated for reinstated to community corrections. We'll set him for that September the 26th date for review. Mr. Salters, I hope you prove me wrong and that you go into this treatment program and you turn your life around and you are come out of that,
Yeah,
you know,
'cause
with
I'm tired of this, Your Honor. Tired of it.
we'll give you that opportunity because that's what the state and your lawyer have agreed upon. Thank you.
Right.
January 26th.
Judge, next up is Dane Sheets.
On page 18, State versus Danny Sheets.
Thank you, Your Honor. On this one, I would ask the court to grant us another settlement date and also to make that a date for motions in this case, Your Honor. I have some motions I plan to file.
Have you filed?
So there's also a couple other rule
All right.
violations.
If you'll go to the next one,
Rule
please.
6, as far as reporting, it failed to report for the months of February, March of 2012. And the financial obligations of Rule 9 and 10. He hadn't provided any payments towards court costs or fines since December the 13th of 2011. And also had a special condition of completing DUI safety school, had not provided any documentation of completing court-ordered DUI safety school.
After the date of February of 2012, did Mr. Christie report ever again to probation?
I don't recall.
You issued on April 25th of 2012 this warrant, is that correct?
Yes,
And does it show when he was served?
it shows 4/16 of 25.
So you don't know if he reported the remainder of his time or if he was not reporting and not served?
I can't recall that for certain, but I wouldn't have issued a warrant, for failure to report if he had been reporting.
Well, right, and I realize that he didn't report in February or March of 2012. My question is did he report after that date?
I don't recall.
Okay. Thank you. I don't have any further questions.
Mr. Fry, did you personally attempt to verify this address?
I don't recall if I was actually there, present at that day and time or not.
What was the residence you were attempting to verify?
I don't have that document.
Was it a different residence than he initially gave you when he went on probation?
The address that they provide to us is the address that we go to.
But this residence verification allegedly occurred on March the 23rd, 2012, correct?
Yes,
And that would have been some 7 or 8 months after he would have went on probation, correct?
yes.
So why such a gap there? Why did it take so long to verify a residence?
At the time, the standards with the department have changed over the years. They weren't as they are now.
Right. This was some 13 years ago, right?
That's correct.
Be fair to say you don't recall much of anything that far back?
Well, I've seen a lot of people in 14 and a half years.
Nothing further.
Is it the responsibility of the person that's placed on probation to keep the probation department apprised of their residence? Or is it your job to go out and find them and try to determine that?
It is their responsibility to keep us apprised of any change in address and report.
Is that a term of probation?
Yes, sir.
Thank you, that's all. Anything further? Step down. Call your next witness. All right. Come up, Mr. Chrissy. Mr. Christie, come around here. We're going to put you on the witness stand.
Mr. Christie, you went on probation back in August of 2011.
Yes, sir.
Do you recall that?
Yes, sir.
Okay. And so where were you living at that time?
I was at the residence that he had for about a month. And, I mean, to be honest, my life was, not good then. I was doing a lot of drugs, drinking every day. And to be honest, I don't know where I would have been when whoever came. But in 2013, I changed my life and quit drinking. I got off drugs and everything. And the whole time, I mean, I haven't ran. I didn't try to run. When TDOC come to my house this time and arrested me for the warrant that I didn't even know I had, because when I'd look online, or my wife would, it wouldn't show nothing. So I assumed that the warrant was gone.
What happened in 2013 that you changed your life?
I quit doing drugs and drinking
Why was that?
because I promised my mom and my wife that I would do it, and I had to because of my health.
Did you end up getting in trouble anywhere else?
No, hadn't been in trouble since.
And you've made it sound as if you were here the whole time. Have you
I've been here, yeah. I mean, I've lived in White Bluff since 2019, and then in 2024, me and my wife moved to Dixon, where we are now. We've been there over a year, and I just signed the new lease again in March for another year.
And it's your testimony today that you've been residing in Dixon County from 2011 to 2025. You haven't
Yes.
left. Okay. And you had no idea a warrant was pending for you.
No, I mean, I actually thought it'd been so long because I started getting letters from a collection agency in Texas wanting me to pay the fines and court costs, and I assumed that the warrant was gone and they were wanting the money. I didn't know.
And this was just a 2-year sentence that you had signed up for.
Right, yes.
And so at any point over the last 14 years, if you had known that you needed to do something, would you have come up here and resolved it?
Yes, I would, just like that's why when they were at my house and my cousin called and told me I was in Bellevue, and I spoke to the officers, the TDOC officers, on my phone, on the security camera, and I asked them what they were doing at my house, and they went on and said they needed to speak with me in person. I knew they was gonna arrest me. I asked them why, and then it's when it's all come up. So I told them I was 45 minutes away in Bellevue, I'd be there shortly, and I went and turned myself into it.
Well, it sounds like you've done well for a long time without
I
getting any
have,
trouble.
yes,
If
sir.
the judge were willing to reinstate you, or better yet, dismiss this case today, you think you could stay out of trouble?
I know for a fact I could. If he reinstated me, I would do the probation the way I should have had back then.
I'll pass the whip.
Mr. Christie, you knew you were on probation, is that correct?
Yes, ma'am.
And you just testified on direct that you only stayed at that address for about a month, is that correct?
That's right, yeah.
And you never reported a change of address to your probation officer?
No, actually, I asked him, I went in because I wanted to go where my mom was in Alabama. And when I went in and asked him if he would transfer it to Alabama, he said, I can't right now, we can get to it next month. And I said, all right. So, and then that's the way it ended up.
And then is that when you stopped reporting?
Yes,
Okay. And you agree that you stopped reporting after, I guess, 7 months of probation and didn't report anymore?
yes, ma'am.
Okay. And I know you're saying on here that you're doing well, and I hope you are, in regards to not drinking or doing drugs, but obviously you haven't been on that probation or that time period, so we don't know that. It's just your word. Is that correct?
I mean, yeah, but that's all I have is my word and my family's word.
But you were drinking and using drugs during that time period that you were on probation. Is that correct?
No, not, I didn't start till after the probation and when I quit going. That's basically why I quit going, because I started back doing the stuff.
All right. Thank you. I don't have any further questions.
Anything further? Thank you, sir. Step down. You have any other witnesses? Officer Fry, I'd remind you you're under oath.
Officer Fry, I realize we're kind of operating in the realm of theoretical here, but if a probationer under your supervision were simply to fail to report a new address to you, and otherwise after that fact came back into compliance, what would be the appropriate remedy in your opinion? For simply failing to report a change of address? Would you say that's a technical violation?
Back then, we weren't operating as we are now with the Public Safety Act that would classify that as a technical,
Sure.
more so than a new arrest or zero tolerance matter
But you've been doing this a long time, correct?
for a little while.
All right, and you've seen all manner of violations, correct?
Yes,
All right, and how serious would you class that in and of itself?
failure to provide an accurate address. I'd say that's pretty serious.
Would your general recommendation on that charge alone be to revoke someone's sentence entirely?
I'll have to defer that to the courts.
What about if that person not only didn't supply you with an address, but never reported? Just didn't report?
I would say they weren't a candidate for probation.
And is this individual, did he ever report to you after you checked on his address?
I don't recall anything after the issuance of the warrant.
All right, thank you. Step down. Let me, you have anything else? All right. Because of the fact that I was the judge in the James Brent Wall case, and that case has been cited, I will deal with what I consider to be the differences in the two. In the James Brent Wall case, there was a warrant that was issued for violation of probation and a capias for his failure to appear. He was arrested on the capias, and the proof was that he didn't appear from the proof at the Court of Criminal Appeals that he was ever actually served with that, and as a result, with a violation of probation. So when we had the hearing, and I found him guilty of violation of probation, he had actually never been served with a violation of probation warrant. So therefore, Court of Criminal Appeals said it does not, it indicated that I may not have had proper jurisdiction to do that. I found that the warrant and the amended warrant of violation was recalled and never reissued, and that his arrest on January the 8th was on an alias capias. He was never served with either of the violations of probation warrants, and that his sentence expired then before he was arrested and served with the actual warrant. In this case, the only similarity is that the length of time meant that the sentence would have expired between when he last reported and when he was actually served with a warrant. But in this case, it's, in my opinion, is different as follows. There was a violation of probation warrant that was issued on April the 25th of 2012. And this is after he had pled on August the 25th of 2011, from what I'm seeing. And the 2012 reopening of the violation on a violation of probation warrant, and it was shown that on August the 29th, 2013, it was stricken from the docket with an alias capias. And then he was arrested on April the 9th, 2025, arrested on the alias capias and the state VOP warrant. And then it shows on April the 16th that he was arrested on the state VOP warrant, and then it was set for May 19th. The statute that and I think it's important to read the order that was entered by the court at that time. Judge Robert Birch is the one who entered the order. The order to strike was entered on September the 4th, 2013, and it states the following. On the 29th day of August 2013, this matter is before the court upon charges of violation of probation. The defendant having failed to appear, the court is of the opinion that this cause should be stricken from the docket on default of the defendant pursuant to Tennessee Code annotated 4015-101A, with a capias provided in Tennessee Code annotated 4015-101B. That upon the defendant's arrest or return to the state of Tennessee, The case to be proceeded with as if not stricken from the docket. And it goes on to order that language. 4015-101 states the following. When a case, in subsection A, when a capias has been returned not to be found, and in felony cases when before or after conviction the defendant breaks jail or forfeits the bond for appearance, the court may strike the cause from the docket and give judgment against the state for the cost as the state is bound to pay in case of a nulli prosecute or acquittal of the defendant. Subsection B, the cause shall not be discontinued by such judgment if the defendant is afterwards taken or comes into the state. A capias or other process shall run against the defendant and the case shall be proceeded with as if it had not been stricken from the docket. This court's opinion, that language is very clear, and the intent of that language in the statute is that a person who absconds can't be found once they are located, that the case can be proceeded with as if it had not been stricken from the docket. In this case, he was served with both, with the VOP warrant and an alias capias. In the Wall case, he was only served with an alias capias, never served with the violation of probation warrant. So I find that any objection that the defendant may have to proceeding with this case as far as jurisdictional is not warranted, and I find that it is in fact a case that the court has jurisdiction to hear and decide. Now, that brings us then to the issue of he is clearly in violation of his probation. You go on probation and never report to probation, a 2-year felony sentence clearly would have meant that he knew he was on probation, he knew he was supposed to report. Too often in probation cases, we find that defendants or the arguments made that probation didn't do their job by going out and finding him. It is the defendant's obligation to report. Judge Robert Birch, who issued that, was fond of saying to a defendant, there are no unimportant rules of probation. You violate one rule one time, then bring your toothbrush because you're going to prison or to jail. It doesn't matter if you're sick. You know, you bring your sickness to the probation officer and give it to him. If you're in a car wreck and you bring your bruised, battered body, drag it up the steps to the probation office and report. The only excuse that he would accept for not reporting to a probation officer was a death certificate with the defendant's name on it. I heard that speech, I bet 150 or 200 times or more. In this particular case, I do not find the fact that the officer Fry did not, went out looking for his address and didn't find him as a verification for a few months after he was pled guilty. It's not his responsibility to have that defendant report. It's his responsibility to report. So clearly, in my opinion, he violated the terms of his probation. Now, what to do about that? It's been 12 years or so since that time. Clearly, he seems to have gotten his life straightened up, and I appreciate that fact. So I find he's guilty of violation. I ordered that he restart his sentence and sentence him to 2 years probation on a restarted sentence. And we'll see how he does on probation this time. I'm giving you another chance to be on probation. Did you understand what I said about reporting? It's your obligation, and not just, they don't have to come looking for you, you have to go looking for them. You understand that? Only reason I'm doing this is because of the length of time that you've been away, and you never really were on probation because you never really reported it. So we're going to restart your sentence and give you a chance to report and see how you do this go around. If you don't do it, then you'll go to prison for 2 years from now. You understand that? He needs to see the probation department. All right. Do we have any other inmates? We have to have Mr. Christie return first, obviously. Zero tolerance for any drug screens, yes. But Mr. Health is the next one.
Ms. Rawls, does that work for your calendar?
Yes, I will be at work. I do work that day. If it's okay if I could do another video conference.
I'm totally fine with that, Ms. Rawls.
Okay, thank you.
All right, 3 o'clock, June 3rd. We'll see you then.
Thank you.
Thank you. We're adjourned. Mr. Evans? I hear somebody graduated.
Yes,
Congratulations.
thank you.
I bet you feel great. And now your next step is you're looking into.
Tech school,
I know which one. Have you thought about it?
Western Tech.
Excellent. Have you actually applied?
Well, I had a scholarship before actually, but I just need to see where it's going with all this.
Excellent. Excellent. Good to hear. We will go on the record in the matter 24 CF 51, State of Wisconsin versus Charles Evans. The state appears through District Attorney Kevin Schmidt in person. Mr. Evans appears in person with counsel Ryan Reed by video conferencing. We're set today in this matter for a status conference and a request to be heard on bond. Mr. Reed, please update the court.
Thank you, Your Honor. Mr. Evans has decided to resolve this matter with some cooperation with the state and a misdemeanor resolution. I anticipated that the state would want that scheduled before a plea is entered. So we would be asking for either a plea and sentencing or a status far enough out so that we could accommodate the debriefing with law enforcement.
How about a plea and sentencing on July 7th? In the morning?
Charles, does that work for you?
Yes,
All right. What about at 9:30?
That works for the defense, Your Honor.
All right, 9:30, July 7th, 9:30, July 7th. Now, with regards to the bail request,
Thank you, Your Honor. We would just renew our request to have the GPS monitoring condition either suspended or stopped. I think the court's concern at the last hearing was these matters moving to resolution. Mr. Evans has decided on which option he would like to move forward with. The burden of paying for the GPS monitor that he's been on for, I believe, a year, it would be appropriate, I think, at this point, with the resolution scheduled, to maybe modify that one condition, Your Honor. Thank you.
Mr. Schmidt.
As I said previously, it is positive that with his father in custody, that was the main concern about continued criminal behavior, and his mother, I think, is a much better influence. The victim did say they oppose changing the monitor system. I don't know how much it costs. I imagine that cost is being borne.
$20 a day. He's paid far more in his cost there than he would have in his bail.
Given this is a trajectory, I guess I don't object.
You don't care, is that what you said?
I said I don't object.
Oh, you don't object. All right. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Mr. Evans, you have now graduated from high school. You can put your hand down. You graduated from high school, correct?
yes,
That was a big deal, right?
yes,
You worked really hard, correct?
yes,
Do you want to, are you going to do anything to risk that?
no,
Going to do anything to risk your future?
no, ma'am,
Because you know what it's like to earn your degree, correct?
yes,
And you want to have a future, correct?
yes,
Are you going to come to court?
yes,
Are you going to stay out of trouble?
yes,
Are you going to follow the law?
yes,
Do you understand that if you have even any violation that will rise to a probable cause finding, and that's a very low little hurdle, probable cause, that the court will institute a very high cash, the highest I can go? Do you understand that?
yes,
And so will you be following and abiding by the law?
yes,
Promise?
yes,
All right. I'll modify your condition of bond, and I will allow you to no longer be restricted by the electronic monitor.
thank you, Your Honor.
Be good. Listen to your mother. No drinking, no smoking, no vaping, no illegal substances or drugs. You got a bright future if you just stick with it. All right?
Yes, Your Honor.
And there's still no contact with the other Evans,
Yes.
okay? And the other co-defendant. So, all right, you can come up here. You need to sign your bond, and then you're going to need to go find Miss Anderson, or at least make an appointment with her to get that back to her.
All right. Thank
All
you.
right, thank you.
Thank you, Your Honor.
Don't do anything to jeopardize your future, Mr. Evans.
I just have to make a bond real quick, sorry.
Mr. Kitchen Master.
Thank you. All right.
We will go on the record in the matter 25 CF 69, State of Wisconsin versus Dale Kitchen Master Jr. The state appears through Special Prosecutor Brian Wright. We also have this, we have Defense Counsel Daniel Chapman appearing in person. We have Mr. Kitchen Master appearing in person in custody. We're set today in this matter for a preliminary hearing. This matter is proceeding as such, Mr. Chapman.
Yes, Your Honor.
You may call your first witness, Mr. Wright.
Yes, Your Honor. The state calls Deputy Bailey Mangan.
Deputy Mangan, please come forward, raise your right hand, be sworn in, and have a seat at the witness stand.
Do you swear that the testimony you're about to give today in this matter is the truth, the whole truth, and nothing but the truth?
Maybe.
Deputy Mangan, will you please state your full name and spell your last name?
Yes, my first name is Bailey. My last name is Mangan, spelled Mangen.
Deputy Mangan, how long have you worked as a deputy for the Burnett County Sheriff's Office?
For the Sheriff's Office since December of 2020.
Were you on duty on Friday, April 25, 2025 at approximately 6:15 p.m.?
Yes, I was.
What duty assignment were you performing on that date and time?
I was on a routine patrol shift in Burnett County.
And what is the location that you were patrolling?
At that time, I was in Swiss Township at the Danbury Casino.
And is the Danbury Casino located in Burnett County?
Yes, within Swiss Township.
Did something draw your attention while you were at the casino?
Yes, I located or recognized a male subject inside the casino from previous contexts. I recognize that male as Dale Kitchen Master.
And how is it that you recognized Mr. Kitchen Master?
Previous contacts.
Do you see Mr. Kitchen Master in the courtroom today?
Yes, I do.
What is he wearing? And will you describe the table that he is seated at?
Yes. Mr. Kitchen Master is seated next to Attorney Chapman wearing an orange t-shirt.
Let the record reflect that Deputy Mangan has identified Mr. Kitchen Master.
Was there anything of interest that you were aware of when you saw Mr. Kitchen Master?
Yes, I was aware of a previous active arrest warrant out of the Department of Corrections.
Did you determine whether or not that warrant was active when you saw Mr. Kitchen Master at the casino?
Yes, eventually I determined that the warrant was active.
And how did you do that?
It was eventually confirmed through our dispatch through the teletype system, I guess.
Okay. And so when you saw Mr. Kitchen Master, what did you do?
I made contact with Mr. Kitchen Master. He was seated at a gaming machine within the gaming floor. I spoke to him. I informed him that he had a warrant out of probation.
And did you take him into custody immediately?
Not immediately, no.
Okay. What did you do?
Again, I spoke to Mr. Kitchen Master. There was another male subject that was with him or near him at that time. I eventually walked with Mr. Kitchen Master over to the the cashier area, and then eventually walked with him towards the front door of the casino.
And what occurred as you approached the front door?
While we were walking towards the front door, Mr. Kitchen Master was just in front of me. He took out his cell phone and was attempting to make a phone call as we were walking towards the front door.
Did you say anything to him at that point?
I don't recall if I said anything specific to him at that point.
And what did you do when you saw him remove the phone from his pocket?
Again, I continued to just walk behind him. We were walking towards the front door.
Okay, and what happened when you got to the front door?
Just before the front door, Mr. Kitchen Master told me to get away from him, and then stated that he was going to he said he was going to knock me out.
And how far away were you from him when he said that he was going to knock you out?
Just within I wouldn't say a couple feet, but a couple of yards.
What was his demeanor when he said that to you?
During my entire contact until after Mr. Kitchen Master was taken into custody, he was argumentative and confrontational.
Did you take that as a serious threat to do you harm?
Yes.
Why?
Just due to Mr. Kitchen Master's elevated and aggressive state, I've had numerous other contacts with Mr. Kitchen Master that didn't go like that one. Just again, based off his elevated and aggressive nature during my contact with him.
Did you consent to him threatening to knock you out?
I did not.
After he said that he would knock you out, was he taken into custody?
He was, yes.
And how was he taken into custody?
There was a struggle that ensued. He began to pull away from me after I told him to put his hands behind his back. There was a security guard for the casino that was nearby the front door. During the struggle, I took Mr. Kitchen Master to the ground in order to get him into custody. At that point, or someplace right in that time frame, the security guard from the casino assisted in attempting to take Mr. Kitchen Master into custody while he was on the ground.
And what attire were you wearing at the time?
A uniform just like this one.
Thank you, Your Honor. That's all the questions I have for Deputy Mangan.
Thank you. Questions, Mr. Chapman?
Am I to assume that he had not been taken into custody prior to when you told him to put his hands behind his back?
I guess if you're asking if he was in handcuffs, he was not in handcuffs at that point.
So you told him he had a warrant, and then you walked with him to the cashier and you were walking with him to the front door, but
yes,
he hadn't been put in handcuffs?
He had not.
And he took out his cell phone and started making a call?
Yes.
At this point, you said he was argumentative and confrontational, but so far this doesn't sound like an argumentative and conversational interaction, at least comparatively from what I've heard of other arrests. Was he fine up until this point?
I guess it depends on what you would say was fine. Throughout my entire contact, again, until Mr. Kitchen Master was secured in the back of my squad, I believe it was when we were leaving the casino, that's when he calmed down. But initially, my first contact with Mr. Kitchen Master at the gaming machine, he was argumentative. He didn't believe he had a warrant. I guess in a general sense, just didn't agree with the fact that he had a warrant.
Why wasn't he in handcuffs at that point then?
I guess I wanted to give Mr. Kitchen Master the benefit of the doubt. We're in a public spot. I guess it's normal sometimes for people not to agree or not to want to cooperate with law enforcement. So I was hoping that if I gave him the benefit of the doubt and not handcuffed him in front of everybody in the casino, that maybe I would receive a little bit more cooperation, I guess.
When he said this, get away from me and I'll knock you out, did he turn around and look at you?
I don't recall him turning all the way around. He was obviously interacting with me to some point. We were just I think I testified yards or feet away from each other at that point.
He was also on the phone, correct?
He was holding the phone up towards his ear, yes.
And you don't know who he was talking to or what the context of that phone call was?
I did not know if he was talking to anybody or who or what he was talking about, no.
Were you wearing a body camera at this time?
Yes.
Have you reviewed your body camera footage recently?
Not recently, no.
Do you still have the body camera footage preserved on some sort of system?
I would assume so.
Did you or anyone else from your department make any attempt to recover the security camera footage from the casino?
I did not.
Has anyone?
I'm not aware of anybody else doing that.
No further questions.
Any redirect, Mr. Wright?
No, Your Honor,
All right, you may step down, thank you.
Thank you.
Any additional witnesses?
not today.
Mr. Chapman, any witnesses?
No, Your Honor.
Any need for argument? Mr.
No,
Chapman?
Your Honor.
Based upon the testimony of Deputy Mangan, the court does find that there is probable cause to believe a felony was probably committed and was probably committed by the defendant, Mr. Kitchenmaster. Court will find the probable cause and bind the matter over. Information, Mr. Wright. Oh, you are paper, so you cannot do an information right now, but that's okay.
Yes, yes, Your Honor. What time frame would the court like me to have that filed?
You can, well, it's within 20 days, so whenever you want.
I'll have it filed by end of business tomorrow.
That sounds great. Mr. Chapman, when would you like to have an arraignment? I could do,
Looks like I'm in front of you June 9th.
well,
Then there's a big gap.
I made a nice little deal with Mr. Wright that I would keep him on Monday mornings, I believe.
Okay, that's a Monday morning,
So when are you here?
June 9th,
June 9th,
9 o'clock.
9 o'clock. We'll do June 9th at 9. Videos approved, Mr. Wright.
Thank you, Your Honor.
All right, thank you. We are adjourned. You're welcome. Are we in victims' rights compliance? Would we be able to move forward? Okay,
Oh, that I don't
for a
know.
bond hearing.
I think it should be fine.
Okay, we will go on the record in the matter 25 CF 40, State of Wisconsin versus Dominic Violette. The state appears through District Attorney Kevin Schmidt in person. Mr. Violette appears by video conferencing in custody in Burnett County Jail. We have his counsel, Glenn Keene, appearing by video as well. We're set today in this matter for a status conference and a bail bond hearing. Before we move on to any bail bond request, Mr. Keene, is there any update you can provide with regards to this case?
Yes, Your Honor. The DA's presented an offer that gave him a couple of options, but one of the options is for Mr. Violet to seek treatment. Mr. Violet is trying to do that because he's serving a sentence with the Sawyer County. So he's trying to get over there so he can comply with the terms of the offer by the DA's office to get a better resolution. So the bond motion is to try and give him a chance to comply with the terms of the offer.
All right, so I have a question. I need to understand this. Right now, we have him in our custody, but he's sitting a Sawyer County sentence.
On cash bond.
So
Yes.
why is he sitting in Sawyer? Okay, so that's why he's sitting a Sawyer County case, but if I amend it to,
A
so
signature.
was he sentenced? He was sentenced on our cash.
On both.
So
If you do a signature bond, he'll go to Sawyer County until October or November.
So what happened is that he might have been in the middle, either this is sentencing after revocation and then he was sentenced, or something else and he was waiting to be sentenced in Sawyer County. He came over here in March, and on March 12th, he allegedly did other things here in Burnett County. So he's put on my cash here, but in the middle, while he was in my custody, he pled by Zoom, or
Yes, sir.
you pled by Zoom, and so they sentenced you by Zoom, and so you're sitting on my dime in Burnett for a Sawyer County case.
Yes, Your Honor.
All right, I don't want you to be on my dime. So I don't even know, I don't even care. I'm gonna amend it to a signature because quite honestly, you're on my dime, on my county's dime. Might as well serve it in Sawyer County's dime. And then we'll figure it out from there. But what's gonna happen is that if you do not make any court appearances, Mr. Violet, I'm going to let you know that if you miss your court appearances, or if you attempt to appear by Zoom and I didn't give you permission to do so, that would be me, the judge. I didn't give you permission to do so. You will have cash and it will be high cash. Do you understand?
Yes, Your Honor.
All right. Now, have you had any thoughts of treatment? Because I believe in your request for a modification prior to getting this set, you were asking to serve your time in Sawyer or have me modify the bond so you can sit your time in Sawyer so you can have Huber so you can get out and work.
Yes,
So,
Your
but
Honor.
now you're going to see if you can go do some treatment instead.
Yes, or both, or I guess I haven't really had a chance to talk to my attorney about it. But I did apply for the Salvation Army, which is in Minneapolis. I'm waiting for a response back. The farming center wouldn't really meet the mandate because it's only like a 60-day program, and Sawyer County was agreeing with the fact that they think I need a longer treatment program. So I'm trying to seek that out. I don't know if they're gonna allow me to do that while I'm on Huber, or if they're even gonna guarantee grant me the Huber for sure. I'm not sure, but that's kind of where I'm trying to go so that I can complete a treatment mandate before I get sentenced on this case.
Your Honor, if I
All
may.
right. You may in a second. I just want to make
Okay.
sure that I have an understanding of the facts of this case. So I have my head wrapped around it. Now, with this case, is there any restitution being requested? Okay, so we don't have to worry about that and victims and making them whole and all of that. So Mr. Keen, what would you like me to know?
Yes, Your Honor. Mr. Violet has been diligent. He's mentioned a Salvation Army. However, that would have to be, a jail release to other activities, but he also can work and or seek AODA a treatment in
Yeah.
Sawyer County. So
I don't
he's
care what he does in Sawyer. I don't care what he does. He's sitting on their dime. That's up to either Judge Isham or to Judge Yackel. So
right, I'm not saying you have to care about that. What I'm saying is the reason he was trying to get over to Sawyer on their dime, other than the fact that it doesn't make sense for Burnett County to pay for him, is that his options to seek treatment to comply with the DA's offer improve once he gets to Sawyer County, because he can't meet them while he's sitting in Burnett County Jail.
I mean, that makes sense. But I'm going to tell you that this court isn't prepared to wait until he's done with his 6-month sentence, which will be done in probably October-ish. I'm not prepared to wait for then him to start doing some treatment, then, see where we're going to go from there. If that's the case, I'm going to be setting it for trial.
Your Honor, Mr. Violet, once he gets over to Sawyer, he can finish the application. And the idea is to get treatment before October, while he's in custody over there. It's not to finish your time and then go out, because if that were the case, it'd make more sense for him just to take the other part of the offer that the DA had. So we're not asking to come back that late. We're asking to say come back in a month, because that would give Mr. Violet enough time to fill out the Huber application to Sawyer County after he gets transferred there, figure out which treatment's available, if any. And then we'd have an answer of which offer the DA has may be logistically possible. So it's not to wait until after he completes the sentence and then start.
Nope, that all sounds good to me. So the bond is going to be amended to a signature bond, same conditions. What we're going to do is I'm going to get you back here for a status conference. You're going to update me, let me know. As you're going to be in custody, Mr. Violet, you're going to be able to appear by Zoom, obviously, because you'll be in Sawyer County custody. Okay, when can we have you come back? Let's get something a little bit in the summer sometime. Wowza. How about August 14th? Can you do August 14th at 9?
Yes, Your Honor.
All right, August 14th at 9 a.m. All right, we'll see you then. In the meantime, though, Mr. Keen, if you can, because I'm sure you're going to have communication with Mr. Violet, or I'm hoping you will, that you can let the court know prior to that and the DA's office know prior to that if he is able to get that treatment or what he is doing, if he's doing some Huber and those things, because I'd really like to know.
Yes, Your Honor. That's why I said we weren't asking you August. That's just the way the schedule bounces. But obviously, Mr. Violet would like to do something productive before then, or if that isn't possible, get the clock running on a potential probation. So he's aware that it's in his interest to communicate, and it's my interest to communicate. So we understand, Your Honor.
All right, thank you. And it wasn't my plan either to go to August 14th. That's just unfortunately where it all fell. All right, thank you. We are adjourned.
Thank you, Your Honor.
Mr. Olson. Were you able to get the interlock?
I have it, yes. I don't have
Oh,
any.
that's right. You were gonna get the proof.
Yeah, I don't have any. I don't have a phone right now,
Oh,
but I've had it. I get it out in July. I've had it for almost 3 years. The only time.
We will go on the record in the matter 24 CM 127. State of Wisconsin versus Nicholas Butkus Taft. The state appears through District Attorney Kevin Schmidt in person. Mr. Butkus Taft appears in person in custody with counsel Zachary Fisher. We're set today in this matter for a plea and sentencing. The case was later amended to a felony due to the restitution issue. And now we need to go and have an arraignment before we proceed with the plea and sentencing. Is that correct, Mr. Fisher?
Yes, Your Honor.
Victims' rights compliance?
Yes, Your Honor.
All right, Mr. Butkus Taft, do you understand what a preliminary hearing is?
Yes, Your Honor.
The burden is on the state to prove a felony was probably committed by you in Burnett County. Do you understand that?
Yes, I do.
Do you understand that by waiving your right to a preliminary hearing, you agree the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you? He'd be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. But for today's purposes, you're giving up those rights?
Yes, Your Honor.
Do you understand that if at the preliminary hearing, the state does not meet its burden to the felony, I could reduce it to a misdemeanor or dismiss it altogether, but you're giving up that right today?
Yes.
Do you understand that at the preliminary hearing, that if the court does find probable cause and bind the matter over, it will proceed to future proceedings and hearings?
Yes, Your Honor.
And that could include a trial. Do you understand that?
Yes, I do.
Do you also understand that once you waive your right to a preliminary hearing, it's forever and you can't get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
I'll find you're confident, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. We'll find probable cause and bind the matter over. Information, Mr. Schmidt?
I believe we already filed it before this hearing.
Oh, yes, it is filed. Proceed to a plea and sentencing, Mr. Fisher?
Yes, Your Honor. We do have an agreement in this matter.
All right, please recite the agreement for the record.
Your Honor, Mr. Butkus will plead to count 1, count 2, and count 4, and then count 3 will be dismissed and read in. It would be a DJOC on count 2 for 18 months. And the terms of that agreement are, I've reviewed the terms of the diversion agreement with Mr. Butkus, and I do have a copy of that agreement for the court as well. One of those conditions would be to obviously maintain compliance with probation, and then he would be placed on probation for counts 1 and 4 for 2 years on a withheld sentence. And then the conditions of probation would be to maintain, and these are also conditions of the deferred agreement, or to maintain absolute sobriety, to not possess or use any unauthorized prescriptions unless provided by a medical professional, and then to do an AODA and mental health assessment and follow any recommendations, any other assessments deemed appropriate by probation, and then $11,720.01 in restitution, court costs, fines, and fees, and he has 78 days credit.
78 days credit. Thank you. May I have the documents, please?
Yes, Your Honor, may I approach?
You may. Thank you. Mr. Butkus Taft, that was the agreement that you've reached with the state, is that correct?
Yes, Your Honor.
And I have in front of me those documents that your attorney referred to.
Your Honor, may I approach?
Yes, I was going to say, I only have the second page of the plea questionnaire. Thank you. So I have both of those documents, the plea questionnaire waiver of rights form, as well as the deferred judgment of conviction. You recognize those documents?
Yes, I do.
And did your attorney thoroughly go over those documents with you?
Yes, he did, Your Honor.
Did he essentially go over them word for word?
Yes.
And so you understand them completely?
Yes, I do.
And is that your signature on the last page of each of those documents?
Yes, it is.
You are 30 years old. You have 12 years of schooling. You can read, write. You understand the English language. That's all correct?
Correct, Your Honor.
No drugs, alcohol, but you have had medications?
Yes, Your Honor.
What medications have you had?
I take Suboxone
All right, and you've taken it as prescribed?
as prescribed.
And that does that interfere with your ability to comprehend or understand things?
No, it does not.
All right. Now, other than that, no drugs, no alcohol, no medications, but you are not receiving treatment for a mental illness or disorder?
Correct, Your Honor.
And did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt as it relates to all three of these crimes?
Yes.
And did your attorney go over with you the maximum possible penalty you face for all three of these crimes?
Yes, Your Honor.
All right. Because you're charged with crimes, you are entitled to constitutional rights, and your constitutional rights are listed on both of these documents on the first page of both of these documents. Did your attorney go over these thoroughly with you?
Yes.
Did you read these?
Yes.
Do you understand them completely?
Yes, Your Honor.
Do you need me to go over these rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving these rights completely?
Yes, I do.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, Your Honor.
And do you understand here that there are two types of agreements essentially? The state here is recommending to the court a probationary as well as the deferred judgment of conviction. As it relates to the probationary recommendation, you would be pleading guilty to a criminal trespass to dwelling and a criminal damage to property. The state would have to prove to the trespass that on or around July 2nd, 2024, you intentionally entered the dwelling of victim 1 and victim 2 without their consent, as they were lawfully upon the premises under circumstances you tended to provoke a breach of peace. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you understand that with regards to?
And Your Honor, just for the record, the probation is on the disorderly conduct for count 4.
Oh.
That is on the.
Oh,
deferred
and
payment.
they're adding a criminal damage?
No, the criminal damage is for the DJOC agreement. The probation is on the 2 misdemeanors.
All right, okay, so you put that on the plea questionnaire as well?
Yes.
Okay, all right, and so that with the disorderly conduct, the state would have to prove on or around July 2nd in Burnett County, Wisconsin, while in a private place, you engaged in indecent, boisterous, abusive, violent, or otherwise disorderly conduct, which under the circumstances tended to provoke a disturbance. Do you understand what the state would have to prove?
Yes.
Do you understand that upon completion or upon conviction, you do face a fine of up to $1,000 or imprisonment of up to 90 days or both?
Yes, Your Honor.
And with regards to the deferred judgment of conviction, that is a felony, which the state did add after fully analyzing the case and the restitution requested. and you would be pleading guilty to that charge, hoping that the court would enter that deferred judgment of conviction. Do you understand that the state would have to prove on or around July 2nd, 2024, you intentionally caused damage to the physical property of another, a French door belonging to victim 1 and victim 2 without that person's consent, whereby the property was reduced in value by more than $2,500. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 3.5 years or both?
Yes.
Now, do you understand that there's an agreement here reached with the state where with the 2 misdemeanors that the court, they're recommending the court place you on probation with a withheld sentence with certain conditions, and with the felony that the court accept the deferred judgment of conviction. Do you understand that I'm not bound to follow any agreement?
Yes, Your Honor.
And that means that I could sentence you to the maximum possible penalty for all of these charges. Do you understand that?
Yes, I do.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
And do you understand that it's my discretion in sentencing whether I do a withheld sentence or an imposed but stayed sentence? Do you understand the difference?
Yes.
Do you need me to explain anything more about that?
No, Your Honor.
And with regards to conditions of probation, do you understand that it's ultimately my decision in what conditions I place upon you? Do you understand that?
Yes, I do.
Does that change your mind as to pleading today?
No, Your Honor.
All right. Now, did you go over the criminal complaint with your attorney?
Yes.
And in particular, there is a section called the probable cause section where it basically says what happened and why you were charged with the crimes. Now, for the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that your conduct and behavior rose to the level of provoking a disturbance?
Yes, Your Honor.
And did you intentionally enter the dwelling of victim 1 and victim 2 without their consent?
Yes, Your Honor.
And it provoked a breach of peace?
Yes.
And are you pleading guilty today to the the criminal damage to property because you did cause physical damage to the French door of victim 1 and victim 2 without their consent?
Yes, Your Honor.
Are you stipulating to restitution in the amount of $11,720.01?
Yes, Your Honor.
Mr. Fisher, may the court use the probable cause section along with the statements made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes, I am, Your Honor.
Has he discussed with you after looking at the discovery and the evidence, whether or not he believes you have any defenses or a lack of defenses in the case?
Yes.
Has he discussed with you a potential for going forward with a jury trial?
Yes, Your Honor.
And again, you're satisfied with his services?
Yes.
Do you have any questions for the court?
No, Your Honor.
Any questions for your attorney?
No.
Do you understand that if the court were to enter judgment as to a felony, you would no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in any election until your civil rights are restored?
Yes.
All right. As to count 1, criminal trespass, how do you wish to plead?
Guilty.
As to count 2, felony criminal damage to property, how do you wish to plead?
Guilty, Your Honor.
As to count 4, disorderly conduct, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 3 charges. As to counts 1 and counts 4, I will enter judgment at this time. As to count 2, I will hear argument along with sentencing if the court should accept the deferred judgment of conviction. Mr. Schmidt.
The structure of this plea agreement is designed such that the goal is to get the defendant treatment and to also get restitution paid and incentivize him with the possibility of not getting that felony conviction if he does it. Mr. Butkus-Taft's history is not that severe. In the past 11 years, he's gotten 2 OWIs, 2 OARs, and then a bail jump in a DC. He has no prior drug convictions, even though drugs were implicated in this offense. Part of what I don't think the criminal complaint demonstrates very well is Butkus Taft had numerous interactions with law enforcement before this incident at the hospital, where he is getting increasingly psychotic. He's saying he's coming down off of drugs. Eventually, law enforcement, noticing the psychosis and the eventual suicidal statements, can't ignore it. They take him to the hospital. The hospital is the first one who suggests we need to call crisis. He maybe needs to be chaptered. Unfortunately, in our county, we have this access phone line where the decision to do a chapter or emergency detention is not with law enforcement. It's with this phone line where they don't personally observe him. They don't see the behaviors firsthand, the subtle nuances of it. And access chose not to chapter him. The police had no basis to arrest him for what he had done. So when they left, he, still psychotic, just left the hospital. The victims lived nearby. He broke into their house. Caused an ungodly mess, terrified the residents. One of the victims had to basically take him down himself, and police came there. Because of what he damaged, it was very expensive, hence why the misdemeanor became a felony when we got a quote. When you watch the body cam of him after the police got there, he was still, he didn't even really know where he was. He was rocking back and forth. He was still psychotic or showing symptoms of that. This is a person who really doesn't have a criminal history that would lead one to think this would be something he'd do. And that's a big part of why we're doing the incentive with the felony and giving him a chance to make amends and pay back the restitution for the behavior. And also taking stock of the fact he does have some jail credit now, a not insignificant upfront jail credit time. So there is an upfront punishment. There's the rehabilitative potential with the probation. And there's a potential carrot of him avoiding the felony if he does make good on all of this. So I think with all those things considered, this is the best possible way to protect the community and also give the offender a chance to rehabilitate to kind of the person we think he should be. I think it's very good he's taking Suboxone to deal with his issues, and I think that's already a good sign. Thank you.
All right, thank you, Mr. Fisher.
Your Honor, I would ask that you follow the recommendation that the court has in front of it today. I would echo what Attorney Schmidt said in that this was a severe mental health and or both, if not ultimately combined with a drug issue. Ultimately, Mr. Butkus did have several contacts with law enforcement where he was making statements that to an ordinary person would be they weren't very rational statements to be making at the time. And it clearly showed that something was wrong, and that whether it was that he was coming down from methamphetamine use, was still experiencing the symptoms of methamphetamine, or frankly, I don't obviously have the full understanding of what was going through his mind at the time, but it's clear he was not in the right headspace. And when I watched the footage of him essentially after ultimately what happened with the victims being involved, this is not at all to focus on what happened to him, but rather show his state of mind at the time and ultimately why this happened, in that he had severe injuries from breaking through the window. He did bleed severely through a large cut on his leg. And essentially when law enforcement were trying to restrain him in the victim's yard, he was flailing his legs to the point where he was breaking his toes, and he was not really able to even feel that or notice that. And law enforcement had to move him to protect him essentially at that point from himself. And I really do think that it's an unfortunate situation that he wasn't chaptered, and I think that could have led to a different outcome. Ultimately, we're here now for what his actions are, and there's no changing them. There's no going back today. And I think the restitution is the most important thing, obviously, for these victims, not at all taking away from the trauma that they experienced or suffered from this incident. It was a very traumatic event, regardless, no matter what, at the end of the day, to have someone come into your home in the middle of the night without any notice and knowing who they are. And we're very fortunate that no one was killed or no one else was severely injured. And I think that looking at Mr. Butkus' lack of severe criminal history, lack of any felony convictions, and the essentially responsibility that he has on this agreement, he has a lot of restitution that he has to make up. He needs to take his mental health and his addiction very seriously throughout these next 18 months and 2 years on probation. And if he doesn't do that, there are severe consequences that he could face, not only from the court, but also from his probation officer. And I would hope that for anyone, but especially Mr. Taft, that the opportunity to not have a felony conviction and to make the victims as whole as they could be by providing restitution, that he could meet the rehabilitative goals that would be before the court, that hopefully would lead him to not ever have to come back and hopefully have him live a great life going forward and not have to deal with not have to struggle with addiction and mental health as he has been going through recently.
Thank you. If I didn't say it, all other counts and matters are dismissed and granted for purposes of sentencing. Mr. Butkus Taft, anything that you want to say or you want to add?
Yes, Your Honor. I want to say I agree with everything that Mr. Schmidt and Mr. Fisher just said. And to piggyback, I cut my leg, like Mr. Fisher said, through the window and went to the hospital from the night that this happened. And from there, I did a 30-day inpatient program for my addiction, and I've been clean since. Prior to me being in custody, I was doing an outpatient treatment program, all voluntarily. And besides that, I just wrote a short statement that I'd like to read.
But I'm just going to say, if you read it, please read slowly and enunciate your words because my court reporter needs to take everything down, okay?
Okay. I wrote that I take the matters of this courtroom and the consequences of my actions seriously and
Say, read it a little slower.
okay. I take the matters of this courtroom and the consequences of my actions seriously and will prove so by fulfilling my restitution and completing probation successfully. It will be my top priority to make payments in full, on time, and to meet all probation's requirements. Then in regard to the victims, I don't know the words to express a proper apology. An apology not just for the damage I caused to their home, but more importantly to them. I wish I could take back any anxiety, fear, stress, or frustrations I caused. I wish they would know that I prayed for them and that if I could take this back, I would. I mean it when I say I am sorry. And I also believe completing my restitution and probation will help prove that as well.
Thank you, Mr. Butkus Taft. That did sound heartfelt.
Thank you.
Are those relatives? Or are they victims?
Those are my parents.
Okay, your parents. I kind of assumed that they were your parents. The gentleman was here the last time.
Nope.
All right. In sentencing, I know that you haven't been in court a lot, and that's a positive thing for you, and that goes on the positive side here. In sentencing, a judge has to look at multiple things. I'm told I have to look at first and foremost the nature and the gravity of the offense. How serious is this matter? Then I look at you, I look at the defendant, and I have to look at your character, your past criminal record, any needs for rehabilitation. I look at your age, your education, your remorse, if it's sincere. I have to look at other things then of the community and the need to protect that community and to keep the community safe. I also have other things that I look at, victims and making them whole and the effect upon the victims from the actions. I also have to look at other things such as deterrence, specific deterrence to specifically deter you from committing other crimes like this or others, and general deterrence, deterring others, generally deterring the public, other people from engaging in criminal conduct, especially something like this. And there are other things that the court looks at as well. This is serious in the fact that it's serious for both you and for the individuals in the house. You broke into a French door, you smashed on through, you could have cut an artery, you could have bled out in the matter of minutes. And that would have been even more traumatic for the couple, the victims. Thank God, thank goodness that did not happen. And it's serious because to the individuals having somebody barge through their home, which is supposed, it's your solitude. It's your castle, your place that you can go where you don't have to worry about others and you're supposed to be safe. And then to have somebody barge through and break that, and to have a French door broken, which is not easy to fix. And I'm sure they had to put up tarps, and it takes probably at least maybe a week, probably. They have to get a door that fits and find a person to put it in. And so it's more than just an inconvenience. And Mr. Butkus-Taft, I see you with emotions right now. They're not fake. I can tell when emotions are fake, and I can see that this has had an impact on you. I'm glad. I'm glad to see this, because the individual that is in the black and white words in the criminal complaint from the police report is a hurting individual who has went to illegal substances to self-medicate for an unknown reason. Now, I don't know why. I don't know if you know why, because I can tell that there's something. You can't tell me that that was fun. You can't tell me that the coming down off the substances is fun. And it causes havoc like this. And you seem like a nice young man. I'm going to tell you, when you absconded from my court and you were gone and you didn't turn yourself in, I kind of had a different feeling, like, he's a little juvenile delinquent. You're not a juvenile, but you know, you just have, like, you have this thing on your shoulder, and you think you can do what you want when you want. I don't think that's the case, quite honestly. I think hearing Mr. Fisher today and Mr. Schmidt, and hearing your statement and seeing true emotion in your eyes today, I think you're a good kid. And I think you want to be a good young man. You're not a kid. You're 30. I mean, my goodness. You got a baby face. And I think at the last hearing, you said you have kids yourself. And you wanted to go and you wanted to take care of them and do those kinds of things. You weren't ready then. I'm going to tell you, you weren't ready. And I don't know if you needed to sit in jail for a while. I don't know if you needed your head clear. But seeing you, even though it was on video and I don't get to have an up close and personal, you weren't who you are in front of me today.
May I?
May.
I couldn't agree with you more, Judge. I think I thought I was something that I wasn't. I'd like to say I made quite a few changes over almost the past year, but I wasn't quite the person that I thought I was. And coming in custody, and the first initial appearance in front of you in custody proved that. And the last 78 days gave me a lot of time to think about that, and I couldn't agree with you more.
I see it. I'm telling you, I see it in your eyes. I see it in your expressions and the little ways your eyes are twitching. I pick up on that, and it's real. I have people who are like, oh, it's not real. That's real. Otherwise, I wouldn't have expressed that and brought it out, because it's not like you were trying to force that out. I see changes in you from the last time where you said, please let me out, please let me out, please let me out. You needed this time to get centered, to get focused. Little secret, I don't like to have people in jail. It's not my favorite thing. It doesn't make me feel good to have people in jail, or to send people to prison, or to do those kinds of things. Your conduct and behavior put you there. I'm truly hoping that your conduct and behavior is going to change. You're going to step up. You're going to gain control of your life. for yourself, number one. You can't do it for anybody else. Yourself, number one. And then those children. You, then those children. And then you build more and you move forward. I don't think you're a risk to the community unless you continue to self-medicate, or I don't know. I don't know the ins and the outs, and I don't know your life, and I don't know what you've experienced. I would love for you to go and to try and figure that out and have some self-reflection. Even if it's to go have an evaluation, a therapeutic evaluation, and just go for a few sessions to get to the root of it, because something led you to methamphetamine. Something led you to methamphetamine. I'd hate to see you throw your life away. I think that the agreement is appropriate for the most part. As to the felony, I'm going to accept the deferred judgment of conviction. Number one, get your AODA assessment and follow through. It must be to the district attorney within 90 days, or it's going to be, or this will be revoked, okay? That's the second top reason I see the district attorney's office asking me to rescind this agreement and enter judgment against you and sentence you on a felony. Second most high reason. First is paying that $150. So you better pay that $150. It's due within 60 days. Get it paid. That's the number one reason I have the district attorney's office asking me to revoke and terminate these agreements and enter judgment and sentence somebody. So do those immediately. So I'm accepting the deferred judgment of conviction. I think you're going to benefit. As to the other two counts, I will follow the recommendation for 2 years of probation. Well, 18 months. If you're going to be on the deferred judgment of conviction for 18 months, I'm going to do 18 months. They'll both follow and track along. I'm not doing a withheld sentence. I'm doing an imposed yet stayed sentence. You're going to know what you're going to have hanging over your head. You didn't like 78 days. You're surely not going to like what you're getting now. As to count one, 9 months in jail. If you're revoked. You didn't like 78 days, you're not going to like 9 months. So focus on you. Fix you and whatever's going on in there. Resist or criminal damage, we did that. 3 and 4?
I believe count 1 and 4 are the misdemeanors.
Oh, 1 and 4, thank you. And disorderly conduct, that's right. And the disorderly conduct, that is up to 90. I'll just do the 90 days and that can be concurrent. So you just know that the max, it'll be 9 months. You have 78 days of jail credit. Conditions, pay your restitution. That's part of your deferred judgment of conviction. That's going to be part of your probation. They're going to monitor, and that's a big deal. Absolute sobriety. No use or possession of illegal drugs, substances, or paraphernalia. No prescriptions without a valid prescription. Do your AODA and follow through. Provide that to the DA's office. I want you to do an apology letter. I think you halfway did one already. They just didn't get to hear it.
Right.
And so apology letter, and it would go to your attorney, which can go to the state, and they can make sure it goes to the victims. Because do victims care about contact? Do they want no contact?
They want no contact.
So no contact with victims or their residents. So you're going to need to do that apology letter, get it to your attorney, and he'll make sure it gets passed on, okay? They don't have to read it if they don't want to. I'm going to tell you, I could tell that was from the heart. I'm going to say the therapeutic evaluation. I don't want to say mental health evaluation, maybe mental health evaluation, because I think they do both, just to see if there's something going on. I don't know. And that's where you can be 100% honest. Nobody else gets to know. So you get to say all of the things, all right?
Okay.
Just you and that person. So then you can share and you can have some, you know, internal reflection and know some things. You were working before, so gainful employment or higher education. I don't know if you're looking at doing anything else. $443 in fines and fees for count 1. I'll waive court costs for count 4, but I have to assess the mandatory $200 DNA surcharge. Honestly, court costs and fees, that's the last. I'm not even going to worry about a monthly payment. I want you to pay that restitution. But if you fail to pay the court costs and fees and you fail to pay restitution, not only will a civil judgment be entered against you, but the court will issue a warrant. You could sit up to 6 months in jail. I'm going to tell you, even if you're off probation, you're not off of Judge Mogen's court. I still call you in and I still make sure you pay. And I can still hold jail over you. That's not a threat. It's just, it's about making the victims whole. And it sounds like you want to do that.
I do.
French doors are expensive. They're expensive. I need your DNA. The jail will make sure that we have it. You can request it be expunged through a written letter to the Department of Justice, not to this court, to the Department of Justice. Again, 78 days jail credit. I think that covers everything, Mr. Schmidt.
Nothing from me.
Mr. Fisher.
Nothing further.
Good luck, Mr. Butkus staff.
Thank you, Your Honor.
It was a pleasure. So I'm supposed to have,
Okay.
we'll have a 145. Let's quick do the 145. We're gonna do the 145 and then we'll do the 145. Mr. Rosenthal, can you hear me?
I can, Judge.
Thank you. We will go on the record in the matters 24 CT 103, 25 CM 54, 25 CT 10, 25 TR 125, and 126. State of Wisconsin versus Vincent Stennett. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stennett appearing in person with counsel Joseph Rosenthal by video conferencing. We're set today in this matter for a plea and sentencing. Mr. Rosenthal, is this matter proceeding as a plea?
Judge, I think we can go ahead. I just want to check with my client. Vince, I tried to call you a couple of times. I just want to make sure that you are okay with a plea to one of the OARs and then just time served. I did check with the jail. You've got 4 days credit. That's the offer, is to plead to one of the OARs, time served. Are you still okay with that? I know we talked about that about a month ago.
Yeah, no, that's fine.
Okay, all right. That's the offer, and it sounds like my client wants to accept that, Your Honor.
All right. So which one would he be pleading guilty to? 25, or is it, excuse me, 24 CT 103?
I think that works, Your Honor.
All right. So, Mr. Stennett, you're pleading guilty to one count of operating while revoked. Is that correct?
Yes, Your Honor.
You're accepting the state's offer, which is for 5 days of jail plus court costs and fees.
Yes, Your Honor.
And you have an attorney, Mr. Rosenthal, and he's appearing by video conferencing, and you can see him over there on the big screen.
Yes.
Are you okay with him appearing by video?
Yes,
Do you understand you have a right to say, you know what, Judge, I'd rather have him be here in person with everybody else?
yeah.
But you're okay with him appearing by
Yeah,
video?
that's right.
Now, if you have any questions or concerns and you need to speak with him, let me know so I can adjourn the hearing and send you to a Zoom room. And so you can have a confidential breakout session with him, okay?
Yes,
Okay. Now, how old are you?
yeah, 59.
Can you read, write, and do you understand the English language?
Yes,
Any drugs, alcohol, or other medications in the last 24 hours?
no,
Any mental illnesses or disorders?
yeah, I'm dealing with paranoid schizophrenic antisocial personality.
Do you take any medications for that?
Yeah,
And did you take them today?
no, not this, I just woke up.
Do you take them as prescribed?
Yeah,
And do you take them, so you take them as prescribed, do they interfere with your ability to comprehend or understand things?
no,
Do they in fact help you better understand things? Okay. Now, do you understand that you would have certain constitutional rights because you're charged with crimes, and you would have the right to go to have a trial. You'd have the right to have your attorney cross-examine the state's witnesses and call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today? Do you also understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that the state would have to prove on or around September 17th, 2024 in Burnett County, Wisconsin, that you operated a motor vehicle while being a person whose operating privileges have been revoked in the state of Wisconsin. You operated on a highway during that revocation period or thereafter, and that revocation was a result of an offense that could be counted under Wisconsin law, and that was something that was an OWI or similar related offense. Do you understand what the state would have to prove?
yes,
Do you understand that the maximum possible penalty could be a fine of up to $2,500 or imprisonment of up to 1 year in the county jail or both?
yes,
You further understand that upon conviction, the court may suspend your driving privileges for not more than 6 months.
yes,
You also understand that the recommendation in the joint agreement by both parties is 5 days of jail with court costs and fees. Do you understand? I'm not bound to follow that.
Yep.
Said differently, I could sentence you all the way up to that maximum penalty if I thought it was warranted, and I could do that today. Do you understand that?
Yep.
Do you still wish to proceed and enter a guilty plea?
yes,
Now, are you admitting here today that in fact did operate a motor vehicle while having your operating privileges revoked?
yes,
And you knew they were revoked?
yes,
Now, did you go over that criminal complaint and those facts with your attorney?
Yeah.
And for the most part, are they accurate?
yeah,
Mr. Rosenthal, may the court use not only the statements made by your client here today, but also the facts alleged in the probable cause statement of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or promises to you, Mr. Stennett, for you to plead guilty to this charge?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
Yep.
Has he looked at this matter thoroughly?
Yep.
Are you satisfied with his services?
yes,
Any questions for the court or for your attorney before we proceed?
no,
All right, then as to 24 CT 103, the sole count of operating while revoked, misdemeanor, how do you wish to plead?
guilty,
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. It will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the sole count in 24 CT 103. As to the remaining cases and tickets, they will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Mr. Stennett has a history of driving without a valid license. It's been going on for quite some time. Basically, it keeps striking him as a bolt out of the blue as he continues driving in violation of the law. He gets stopped, he gets arrested, he gets so much court that he misses court, and then he just keeps getting these random days of jail in his life. If he doesn't get his license and continues driving, he's gonna keep getting these like random days of jail, and it's gonna keep making his life harder and harder. I hope he does. I hope this bout, well, in conjunction with his past bouts of these days of jail, will get him to want to do that. Thank you.
Thank you. Mr. Rosenthal?
Your Honor, these OARs are typically not jail type cases, but there's perhaps an argument that could be made that jail is warranted here, just kind of based on the number of cases that are involved. So the defense does not, disagree with this as kind of a mild sort of deterrence type of situation where, it's typically not jail, it's typically not probation, but the number of cases I think does justify a short jail, which my client doesn't have credit for. And we would ask the court to accept the joint recommendation as fair and reasonable.
All right, Mr. Stennett, do you care to make a statement here today?
No.
Okay. Well, Mr. Stennett, these are not the most serious cases, obviously. The aggravation here is that you keep doing it. And you've been doing it since I first started on the bench in 2017. And I know your story and I know your history. You have to figure those things out. I think it's in Minnesota with all the back fees and those payments that you have to do. And I'm really hoping that you can figure that out. And I know it's a lot of work. I don't know exactly what you have to do, but I want you to do it because I don't want you to keep getting these operating without, operating after revocation tickets and then charges, because it's only going to prolong your ability to get your license. And the goal here is for you to get your license, because not only is it prolonging your ability to get your license, but as Mr. Schmidt said, it's putting you in jail. It's costing you more money. It's delaying you from a better life for moving forward. So hopefully you're going to be able to figure that out. I think that the agreement is appropriate, so I will sentence you to 5 days of jail. And what I'm going to do is I'm only going to order $250. So that'll be the DNA surcharge plus $50 court costs and fees. You've already, I think, had some bail forfeited. Hopefully you're just going to figure it out and not get these again. I'm hoping. Aren't you hoping?
Yeah, but I did send that paperwork over to Minnesota.
Okay.
So I'm just waiting on them to respond to me about if they were to take the DOA over here or the treatment thing over here and then just pay them whatever they wanted. I don't know. I'm waiting for them to send that back to me.
Okay, keep following up with Minnesota, because keep doing that so that you can get that checked off, and then you'll be able to get your license over there, which will help you be able to get your license here.
Right.
Okay. All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You can go check to see if the sheriff's department needs that. If they do, they'll swab you. If they don't, they'll send you on your way. You have the ability to request it be expunged from the system through a written letter to the Department of Justice. I believe that covers everything, Mr. Schmidt.
Nothing further from me.
Mr. Rosenthal?
Nothing further from me either. Thank you, Judge.
If you can just what?
Oh, no, nothing further from me. I'm sorry. Thank you, Judge.
All right, thank you. Then we are adjourned. All right, thank you, Mr. Stennett.
You want me to go down to the...
Yep, you'll get this form and you'll just run to the sheriff's department. You'll just give them the form. Most likely they don't need your DNA. We will go on the record in the matter 25 CM 51, State of Wisconsin versus Kelly Neubauer. The state appears through District Attorney Kevin Schmidt in person. Ms. Neubauer appears by video conferencing with approval of the court. We're set today in this matter for a status conference. At the last hearing, Ms. Neubauer, you had inquired whether or not there was some other type of agreement or something that you can work out with the district attorney's office. The court and all right, I have Mr. Marco, Mr. Rosenthal, and I think I have Mr. Chavarria, but I cannot tell. It's a TCL phone or something. I'm asking to start video and asking to unmute.
Can you
There
hear
we
me?
go. It's Mr. Yes, I can. All right, we will go on the record in the matter 25 CM 61, State of Wisconsin versus Jose Chavarria. The state appears through Special Prosecutor Aaron Marco by video conferencing. We have Joseph Rosenthal, Defense Counsel by video, and Jose Chavarria also by video. We're set today in this matter for a plea and sentencing. Is this matter proceeding as such, Mr. Rosenthal?
Yes, Your Honor, my client does wish to accept the state's offer of a plea to the sole count with a joint recommendation of $100 fine plus court costs.
All right. And I don't see a plea questionnaire waiver of rights form, but you were requesting that the court do that. Is that correct, Mr. Mr. Rosenthal?
If we could, Your Honor, I didn't file my questionnaire in advance, but if we could just do it on the
I
record.
need to stop. I'm sorry. I'm getting extremely distracted because Mr. Chavarria, I think you have it on a speaker type situation and it's muffling and it's echoing.
Hold on. Let's see. Should I probably mute it or something right now then or something?
Probably.
If you could go somewhere quiet, Jose.
Well, it has nothing to do with if he's quiet or not quiet. It's just the fact of when some people put it on like the speakerphone kind of thing, it causes it to like double play whatever's being said.
Okay.
All right, so it's pleading to the charge and for court costs plus $100 fine, correct?
Yes, Your Honor.
All right, so Mr. Chavarria, that's the agreement and you're gonna have to stop and I don't know how we're gonna get through this.
Yeah, I don't know. He's walking around there. I'm not sure what's going on.
Mr. Chavarria, why don't you stop and then why don't you undo the speaker and let's just do it without you having it on either video and or on speaker. I don't need to see you. I just need to hear you.
All right.
And you can hold the phone up to your face.
All right. So what are you gonna do? Just shut off the video or what?
No, well, let me see. If I'm talking right now, see, it's causing a little bit of an echo. It might be better now.
It is.
Mr. Chavarria, how old are you?
34.
Can you read, write? Do you understand the English language?
Yeah.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Yeah, see, you're gonna have to stop the audio. You're just gonna have to do it on your phone.
Hold on. Can you hear me though?
I can hear you. Yes.
All right. Are you still hearing that the echo or whatever?
I don't know. I'm gonna have to talk, and when I'm going through you, I can either hear it or see it. I think so.
Well, I don't know because I can hear you pretty good. and I don't hear echo.
I know you don't because you don't have a system like I do. And it double plays it in through my system.
Oh, all right.
All right, so how old are you?
34.
Can you read, write? You understand the English language?
Yeah.
Any drugs or alcohol or medications?
No.
Any mental illnesses or disorders?
No.
Really, this is annoying. I hear what I say twice and it's annoying.
I don't know why.
Just call in. Just call in.
Should I give him Mary's number, Your Honor?
Yes, please.
Okay, I'll mute myself and I'll give him that number.
All right. Well, I can give him the number. Mr. Chevrier, it's 715-349-2149. Call into my assistant. Yeah, because my court reporter has to take down everything and she's legally required to take down double the words that are being said.
Okay.
Joking. Yeah, so I'm going to remove you from here and just call in to the number, okay?
All right. Yeah, I got you.
We're off record. I'm gonna call Mary or text Mary. All right, he is on his way. Are you there, Mr. Chevrier?
Yeah, I can hear you guys.
Excellent. This is much, much better. Okay, back on the record, same appearances as previously noted. I went over your age, your no alcohol, no drugs, no mental illnesses or disorder. So, Mr. Chevrier, do you understand you're charged with crimes, and because you're charged with crimes, you're entitled to constitutional rights? And I know you've been over these rights various times throughout the years, but I'm going to go over them with you again so that you understand them, and you understand that by pleading guilty, you're waiving and giving up those rights. Do you understand you'll no longer have the right to a trial? You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You will also no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up here today?
Yeah.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yep.
And do you understand that you're pleading guilty here today, and you're going to be sentenced? Do you understand that you have the right to be here in person, and you have the right to say, you know what, Judge, I want all the parties, the attorneys, everybody to be in the same room in the courtroom. Do you understand you have that right?
Yeah.
And you're appearing by telephone now, and your attorney's appearing by video, as is the district attorney special prosecutor. Do you understand that you can say, you know what, Judge, I want everybody to be in person?
Yes.
If at any time you have questions or concerns and you need to speak with your attorney, let me know. I will stop the hearing and I'll allow you to give him a call, okay?
Okay.
All right. So do you understand that here in this case, the state would have to prove for the disorderly conduct that on or around April 5th, 2025, in Burnett County, Wisconsin, while in a private place, you engaged in either abusive, violent, unreasonably loud, or otherwise disorderly conduct, which under the circumstances tended to provoke a disturbance. Do you understand what the state would have to prove?
Yeah.
You understand that upon conviction, you face a fine of up to $1,000 or imprisonment of up to 90 days of incarceration or both.
Yeah.
Do you understand that there is an agreement here for court costs as well as $100 fine? Do you understand that?
Yes.
Do you understand I'm not bound to follow that? Meaning I could sentence you all the way up to the maximum penalty if I thought it was warranted, and I could do so today. Do you understand that?
Yeah.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over the criminal complaint and those facts alleged in that criminal complaint with your attorney?
I went over it.
And so you understand those facts of what happened when you had that argument with Mr. Margarito, your
Yeah.
brother? You understand that?
Yeah.
And for the most part, as it relates to disorderly conduct in your part, are those facts accurate?
Somewhat. Yeah, a little bit.
As it relates to disorderly conduct, are you admitting here today that your conduct that day did tend to provoke a disturbance at the very least?
Yeah.
All right, Mr. Rosenthal, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Chavarria, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today.
Yeah.
And voluntarily.
Yeah.
Has your attorney represented you competently?
Yeah.
Has he answered all of your questions?
Yeah.
Has he looked at this matter thoroughly?
Yep.
Are you satisfied with his services?
Yeah.
Any questions for the court or your attorney before I proceed?
No, no questions.
As to count 1, disorderly conduct, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of disorderly conduct. A judgment of conviction will be entered today. Argument, Mr. Marco?
I think that $100 fine in court costs is reasonable. Comes up to $579, which is a pretty significant financial obligation. In addition, it was a mutually combative situation with his brother. As you had mentioned earlier, there wasn't any harm as far as nobody had to go to the hospital. Nobody had to get stitches. It was kind of a pushing and a shoving match. He does have a criminal history. I think that would cause this matter to be unduly depreciated if it was simply no prost or even an ordinance violation. So I think in totality, this is reasonable, and I ask court to adopt a joint recommendation. Thank you.
Thank you. Mr. Rosenthal?
Your Honor, we would ask the court to accept the joint recommendation. I think it's fair and reasonable. I've had an opportunity to get to know Mr. Chavarria over the past year or couple of years. I've represented him on other cases. He's got a number of positive character attributes. He's, I think this is a situation that is, sort of, I think, on the lower end of the statutory scheme. I mean, it's a class B misdemeanor, some pushing, shoving, arguing, no injuries that occurred. I don't see this as a rehabilitation case or something that would require like, some sort of jail time to account for deterrence. So I think under all the circumstances, this is fair and reasonable. Your Honor, I think that's all I have. Thank you.
Thank you. Mr. Chavarria, do you care to make any statement here today? And you know you don't have to, but it's your only opportunity to let me know anything you want me to know.
No, just that it was an argument, but hey, I'm just wondering about the money because that's not mine. And
Well,
I was wondering if it can go back to the person that posted it.
it cannot. Unfortunately, they sign a document that says that it goes towards court costs and fees, and your responsibility is to pay them back.
And Your Honor, if I could
All right.
just kind of step in here, I'm not trying to circumvent any sort of joint recommendations with DA Marco. I think when my client, I did talk to my client yesterday about this issue. So I believe his sister posted the bail money. His sister recently.
If he wants to bring me $200, I'll release the $200 to his sister.
Okay, I think
But I'm
she's
not
just got
releasing
some-
the money. They sign a document that says they are paying the money.
Okay.
They understand the money's gonna go to court costs and fees. They understand that. They're posting the bail. The defendant knows that they must then repay the person who posted it. It's their responsibility to repay the person who posted for them.
No, and
All right,
I
I got
explained to
you.
my client I didn't think the court was going to go lower than $200. His sister just recently gave birth. She's got some financial considerations. I guess I
Well,
think my
then Mr.
client's intent.
Chavarria must get a job, shouldn't he?
Yeah, I think my client's intent
Yeah.
was to ask for some leniency on court costs and fees. That was what I think he was trying to convey.
Okay, on court costs and fees, well, I can't go lower than 200 ever anyway, plus there's $100 fine here that was the agreement. I've known Mr. Chavarria since 2017. I know that he has been struggling with substance abuse issues, and that's his downfall. With this disorderly conduct and with other disorderly conducts and criminal charges that have occurred while at his father's house, it's been usually while he has been under the influence or coming down from being under the influence of a substance. And I really, Mr. Chavarria, I truly would like you to see or go to see if there is a possibility for you to go into some type of treatment. You and I both know the losses that you've suffered over the last few years with your family and substance abuse. It would be so devastating and heartbreaking if you would follow down that same path. It's sad. And I do understand that this involves a fight among family members where both of you got hot and heated. And that's what it is. It's not a huge argument. It's not a huge deal. It's two brothers, family members that got into an altercation, and you both were arrested. And by the facts of the case, you were the primary aggressor, and Mr. Margarito was indicating that he was defending himself. None of us were present there except for you and Mr. Margarito. I really hope, Mr. Chavarria, that you're going to look and find some help. I truly do. What I can do is I can give you a little bit of a break on the court costs and fees, because quite honestly, you've just been here a little bit ago. I just sentenced you on a different crime, and court costs and fees add up. I know you don't have a job. I want you to find a job. I want you to find work. But what I'm going to do is I will assess the $200 DNA surcharge, a $100 fine because that was the agreement. I'll waive the rest of the court costs and fees. I'm not going to release the $200 cash bond that was posted. You have to figure out how to pay your sister. That's your debt to her, not the court's responsibility.
Yeah.
That's your debt. But I will waive the rest of the court costs and fees. You have to figure it out. You have to figure out how to support yourself and how to help your family and how to do those types of things. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I am ordering your DNA. Call the sheriff's department. They have it. But you have the right to request it be expunged through the system through a written letter to the Department of Justice, not to the court, to the Department of Justice. Call the sheriff's department again, make sure that they have your DNA and you're ordered to take care of that. I think that covers everything, Mr. Marco.
It does, thank you.
Mr. Rosenthal.
Yes, Your Honor, thank you.
All right, thank you.
Hey, so if they have my DNA, I don't have to go up there?
Yep, if you call them and they say we don't need it, then you don't have to go up there. I just have to order it.
All right, then. All right.
All right, thank you. We are adjourned.
Ms. Graff?
I don't think so.
Okay, so you're gonna go out the door, make a right at the clerk's window, and they'll take care of you, okay? You have a good day. Court is now calling City of Conneaut versus Brandon Lee Butts, case number 25 TRD 408. Good morning. Mr. Butts, did you understand all of the rights and plea options I explained to everyone earlier?
Yes.
Do you have any questions regarding those?
No.
Did you receive a copy of the traffic citation that was issued on May 17th?
Yes.
So you have two charges filed against you. The first charge is driving under FRA suspension. Because this is your third offense, at least your third offense in 3 years. This is a jailable offense. It's a 4th-degree misdemeanor. If convicted of this offense, you face upwards of 30 days in jail, a maximum fine of $250 plus court costs. You understand that?
Yes.
Also, if the officer checked the box indicating you failed to provide proof of insurance on the vehicle you're driving that day, if you are not able to provide to this court proof of insurance on the vehicle you're driving and you are convicted of this or any traffic-related offense in this case, you do face a non-compliance license suspension with the Bureau of Motor Vehicles. Do you understand that?
Yes.
The second charge is a turn signal violation. That is a minor misdemeanor. It is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
Okay, with respect to the charge of driving under FRA suspension, a 4th-degree misdemeanor, how do you plead?
Not guilty.
The second charge of turn signal violation, how do you plead?
Guilty.
With respect to the guilty plea to the turn signal violation, do you understand by pleading guilty to that charge that you're waiving all of those trial rights I've just explained?
Yes.
You'd also be waiving your right to an attorney by pleading guilty. Is that what you wish to do?
Yes.
Okay. With respect to the turn signal guilty plea, I do find the defendant's plea of guilty to that charge to be knowing, voluntary, and intelligent. The court will accept the guilty plea, and I will therefore find him guilty of a turn signal violation. Okay, Mr. Butts, with respect to the not guilty plea to the driving under FRA suspension, are you going to retain an attorney, or are you asking the court to consider appointing an attorney?
Asking the court to consider appointing.
Do you have any source of income?
I'm picking up like side jobs right now. I've been working on like tractors and lawnmowers and stuff like that.
How much do you earn every week?
$350.
You support anyone financially?
No.
Okay, I'm going to appoint the public defender's office to represent you in this case. Okay. You're still living at, well, this has 1165 Lake Road. Is that where you're living?
No,
Where do you live?
613 Orange Street.
613 Orange Street? Okay, I'll set bond in the amount of $2,500, personal recognizance. As conditions of your bond, I'm ordering you not to consume or possess alcohol and drugs. You are subject to random chemical testing by probation and law enforcement. We will set this case for a pretrial conference in the near future, at which time the public defender will be here to represent and advise you. And then I'll defer sentencing on the turn signal violation until the next hearing. So if you fail to appear for any future hearing, or if you failed to remain drug and alcohol free, I will revoke your bond. I'll issue a warrant for your arrest, and I'll have you sit in jail for as long as I can keep you there, and then I could order you to pay the city of Conneaut $2,500 as a penalty. You understand that? Do you have any questions? Okay, you can go to the clerk's window and they'll take care of you, sir. Thank you. Court is now calling State of Ohio versus Johnny Gregory, 25 TRD 386. Court is also going to take up 25 TRD 26. Failed to remain drug and alcohol free, I will revoke your bond. I'll issue a warrant for your arrest, and I'll have you sit in jail for as long as I can keep you there, and then I could order you to pay the city of Conneaut $2,500 as a penalty. You understand that? Do you have any questions? Okay, you can go to the clerk's window and they'll take care of you, sir. Thank you. Court is now calling State of Ohio versus Johnny Gregory, 25 TRD 386. Court is also going to take up 25 TRD 26. Mr. Gregory, did you understand all of the rights and plea options I just explained to everyone?
Yes, sir.
Do you have any questions regarding those?
No, sir.
Okay. Did you receive a copy of traffic citation issued on May 12th?
Yes, sir.
You're charged with a safety belt violation as a driver. If you are convicted of this offense, you do face a mandatory fine of $30 plus court costs. Do you understand the maximum penalties you face if convicted of this offense?
Yes, sir.
And how do you wish to plead to this charge?
Guilty.
You understand by pleading guilty to this charge that you're waiving all of those trial rights I just explained to you, as well as your right to an attorney.
Yes, sir.
I do find the defendant's plea of guilty to this safety belt violation to be knowing, voluntary, and intelligent. The court will accept the guilty plea, and I will therefore find him guilty of this charge. Is there anything you would like to say before I impose sentence?
Yeah, I was taking my granddaughter to school because she missed the bus. And I just got out of bed, woke up, and I didn't put my seatbelt on when I left. I got pulled over because of my tin on my window, I didn't know how far it should be or whatever. That's the original reason why I got pulled over. I told him, he asked me if I had my seatbelt on, I said no.
Okay. Okay, I will impose the mandatory $30 fine plus court costs. Total fines and costs will be $153. I'm also going to take up this other case, 25 TRD 26. In this case, Mr. Gregory, you failed to appear for a review hearing that I scheduled, let me finish, that I scheduled on May 8th, 2025, and I issued a warrant for your arrest. And you owed this court some money in that case, and you failed to comply with the requirements of paying the fines and costs, which is why I set a review hearing, and I issued a warrant for your failure to comply. So can you help me understand why you failed to appear for a May 8th, 2025 hearing?
Yeah, I thought it was the 11th or some reason I just thought it was the 11th because I lost the slip that the court gave me. And as for the fine, I'm trying to get work right now because I got laid off in general room when they shut the plant completely down.
You did community service for what?
That's what, as part of that, on my last one, the fine, I had to do 25.
That's right. Yeah, I ordered 25 hours. Yeah. That was in addition to fines and costs.
Yeah.
Did you provide the clerk proof of it?
I
Proof of
got
that?
it.
We don't have any proof of it.
I got it down in my car. I forgot to grab it out of my console. I do have that.
Well, here's what I'm going to do, Mr. Gregory, because we don't have time today to address that. I'm going to lift the bench warrant block in this case, and I'm going to set another review hearing. On all cases in which you owe this court money. And I'll indicate you're going to provide proof of that community work service at that hearing. Okay. You owe, now that this new case has been, you've just imposed a fine and costs, you're going to owe somewhere in the neighborhood of this court, somewhere in the neighborhood of $650 in total on these cases. So we're going to address that at the next review hearing.
You said I can work some of that fine off the last time for the last week.
I did allow you in lieu of fines and costs to complete community work service. So I'm going to give you 30 days. I'll set this for a review hearing in 30 days or so. I will allow you to perform community work service in lieu of the fines and costs in the new case as well.
Thank
you. Okay. Do you have any questions about anything, Mr. Gregory?
No, sir.
Okay, you're going to go to the clerk's window and they're going to take care of you, okay?
All right.
Thank you. The court is now calling State of Ohio versus Molly Gianna Snavely, case number 24 TRC 445. Are you Ms. Snavely?
Yes. It's really Molly Jean.
Molly Jean? Okay. Okay, Ms. Snavely, did you understand all of the rights and plea options I explained to everyone?
Yes, sir.
Do you have any questions regarding those?
No.
Okay. Did you receive a copy of a traffic citation that was issued on May 23rd? court is now calling State of Ohio versus Molly Gianna Snavely, case number 24 TRC 445. Are you Ms. Snavely?
Yes. It's really Molly Jean.
Molly Jean, okay. Okay, Ms. Snavely, did you understand all of the rights and plea options I explained to everyone?
Yes, sir.
Do you have any questions regarding those?
No.
Okay. Did you receive a copy of a traffic citation that was issued on May 23rd?
Yes, I did.
There are 3 charges filed against you. The first 2 charges are, and I do note for the record that Ms. Snavely has retained an attorney, Patrick Quinn. And Mr. Quinn has filed a notice of appearance in this case. He actually attempted to file a written plea of not guilty, which this court does not accept written pleas on anything greater than a minor misdemeanor. So we contacted him, and he also filed an ALS or appeal of the administrative license suspension as well. So with Ms. Snavely here, I'm going to explain to you the first 2 charges filed against you are operating a vehicle under the influence of alcohol, drugs of abuse, or a combination thereof. Now, they carry a little bit different consequences, each of those charges, because one charge is filed under one section of the code, and another charge is filed under another section of the code. The first charge is based on just generally that you were under the influence. The second charge is based on the alleged blood alcohol concentration, which apparently, according to a breathalyzer, shows that you tested a .314. That would be almost 4 times the legal limit. So I'm going to give you the range of consequences you face if convicted of both of these charges. And I do find that this is a second offense in 10 years. So the range of consequences you face is, and I'm going to give you that range based on the more serious offense. You do face a minimum 20 days in jail, or in lieu of 20 days in jail, 10 days in jail, plus 36 days of electronically monitored house arrest, up to a maximum 6 months in jail. Now, I could, if I did impose house arrest, I could also impose a continuous alcohol monitoring requirement on you. So do you understand the range of incarceration you face if convicted?
I do.
The next thing is you do face a minimum fine of $715 up to a maximum fine of $1,625. Do you understand that?
I do.
Alcohol and drug assessment would be required. I'm mandated to impose that, and any recommended treatment would also be mandatory. Do you understand that? You do face a minimum license suspension of up to 1, or a minimum of 1 year, up to a maximum 7 years. Do you understand that?
I do.
You would not be entitled to any driving privileges for the first 45 days of your suspension. Do you understand that? If I did grant you privileges during your suspension, those yellow restricted plates would be required for a high test. In your case, it would be a high test if convicted of that offense. And so it would be required, and then the license ignition interlock would also be required if this is alcohol related, and it would be optional if it was drug related. So do you understand that?
I do.
Finally, the vehicle, is the vehicle registered to you?
It is.
The vehicle is subject to immobilization for 90 days if the vehicle is registered to you. Where is the vehicle now?
It's at an impound place.
Okay.
They towed it.
Yeah. So please know that, and your attorney can help you navigate that process, but it is subject to 90 days of immobilization.
We would like to, if possible, get it out, have it towed to my residence so that I'm not paying the impound fee.
Okay. Well, you can talk to your attorney about that process. Yeah. This is a 6-point violation with the BMV if you're convicted of either of the OVI charges. Do you understand that? Also, if you are convicted of operating a vehicle under the influence in this case, and then you're charged with OVI at any time in the future, this OVI conviction could serve to enhance the severity of any future OVI charge. Do you understand that? And then as well, OVI convictions are not sealable or expungible from your record. They remain with you for the rest of your life. Do you understand that? The third and final charge is a marked lanes violation. That is a minor misdemeanor that's punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
Based on the attempts by Ms. Snavely's attorney to enter a written not guilty plea, I'm going to enter not guilty pleas on the defendant's behalf to all 3 charges in this case. And for the record, Ms. Snavely, Mr. Quinn is retained by you?
Yes, he is.
The citation has you living at 35501 Hannah Road in Willoughby. Is that where you live?
Yeah, Willoughby Hills.
Willoughby Hills. How long have you lived there?
39 years.
Okay. Bond is set in the amount of $10,000 personal recognizance. Are you currently receiving the treatment services of any substance abuse or mental health agency?
I'm involved with the AA program.
Okay, are you, I'm very familiar with AA, but are you currently receiving treatment for?
My attorney recommended that I remain silent.
Okay,
I don't
that's
mean
fine.
to be disrespectful.
That's okay. Well, I'm going to order that you not consume or possess alcohol or drugs. You be subject to random chemical testing by probation or law enforcement. I'm going to order an alcohol and drug assessment at Signature Health, which is located there in Lake County. You're to undergo an alcohol drug assessment, and you're to successfully comply with any recommended course of treatment as a condition of your bond. And we'll set this case for a pretrial conference when we're able to ensure that Mr. Quinn is available for that next hearing. Okay, Ms. Snavely, do you have any questions?
How does the bond work?
Okay, so, and I know your attorney can explain this to you, but the bond is you're being released today on your own recognizance. You're going to sign a bond, which is a promise. You're going to promise to the court that you're going to be here for each and every hearing that's scheduled, that you're going to stay drug and alcohol free, and that you're going to follow through with an assessment for substance abuse and or mental health at Signature Health and successfully comply with any recommended course of treatment. If you fail to do any of those things, I would revoke your bond. I'd issue a warrant for your arrest, and then I could order you to pay the sum of $10,000 to the state of Ohio as a penalty for your failure. You understand that?
Yes, I do.
Okay. Any other questions?
No, sir.
Okay, Ms. Snavely, you can go to the clerk's window and they'll take care of you then. Thank you very much.
every day in the USA, people find themselves in court.
Silence, keep outside during proceedings.
All right, we call 25 CR 49 as we begin. Turn off your phones. Patrick Pleasant, come forward. Prosecution. I'm gonna need some help on these things. What was a blood draw?
Yes, Your Honor, it was 0.133.
What else? Anything else?
No, just alcohol, Your Honor.
Because there was marijuana in the car.
Yes, we only tested it for alcohol. The DPS, the way that it works is if they test over 0.08 for alcohol, we do not test
They
it for
just
drugs.
drop it.
Yes.
Hmm. All right, you're still at 10333 Clay Road? Sir. Where do you live, sir?
431 Orange Avenue.
431.
Orange Avenue, Port Arthur, Texas.
There's an Orange Avenue in Port Arthur. Yes. A 77640, right? What's six? What's his zip over there?
77640.
So they're let down. So it's not there. Yeah, that's what I think. Are you employed somewhere? Oh, is Langston Adams your attorney?
Well, no, I'm on initial designation, initial designation. I think.
Are you retained?
No, sir.
Oh, okay.
No, sir.
Are you working somewhere?
Yes.
Where?
Back from, I just been off work for a week. I was sick. I would like to ask, request to give him a paid lawyer. If that's fine.
Who have you talked to?
Jay Hona out in Houston.
Oh, okay. So where are you working though?
Bethel.
How much do you make an hour there?
30.
You're gonna hire your own lawyer?
Yes, sir.
Yeah. Yeah. That's. How much time do you need to do that?
Weeks. 2 weeks.
2?
2 weeks, yes, sir.
You got 3. 3. You got 3.
Yes, thank you.
Oh.
Yeah.
Do you understand you're charged with the state jail felony of operating a motor vehicle while intoxicated with a child under 15 years of age? If it would have just been DWI, it wouldn't have been a felony. But because there's a child involved in the vehicle who is at risk, it's a state jail felony, which carries with it up to 2 years in the state jail. Do you understand? Mr. Adams is going to continue to represent you until you can get somebody hired. If you need to get some advice, you call him. He's standing by if it's needed. But it sounds like you got a plan, so. That's what we'll do. We'll set it with 3 weeks. Get a resetting and. And also just have a seat in there in the box before you leave. We're gonna test you to make sure that there's no alcohol or drugs.
Right
one, Chris, right one.
Okay, Derek Robinson.
Think it up one more time. One more time.
It's called next. 18-30830. And also just have a seat in there in the box before you leave. We're gonna test you to make sure that there's no alcohol or drugs.
Right one, Chris, right one.
Okay, Derek Robinson.
Think it up one more time. One more time.
It's called next. 18-30830.
Out there for the highlighted X's. There's that. I need to have some right there.
All right. Okay. Are you Derek Robinson?
Yes, sir.
Are you still at 10776 Gage Road?
Yes, sir.
Beaumont? You're charged here with the state jail felony of illegal possession of synthetic marijuana. And that carries with it up to 2 years in the state jail. Are you retained?
I'm appointed on it.
No. Okay. Where do you work when you're not hauling drugs around?
I'm just currently getting out, so I'm not working here. Just currently getting out. I did 7 years. And
Wait, 7 years in prison?
yes, sir.
How long have you been out?
Like about 2 months left.
And you get arrested for drugs?
No, it's old.
This was actually, it looks like from 2018, Your Honor.
It is 6 years old. They just never did anything because you've been in prison?
Yes, sir.
What were you in prison for again?
Family violence.
For 7 years for family violence?
7 years.
That's not the way it works. I do this every day. You just don't get it from family violence. You must have been charged with aggravated assault. Pull him out. Is it from Jefferson County?
Yes, sir.
You don't get 7 years. How many convictions do you have? Do you have other convictions? Did they stack them together?
No, it was enhancement.
What do you mean? Enhancement?
It was enhancement. It was
Because of a prior conviction?
Yes.
Okay, so you had a conviction before a felony conviction, which made you weren't allowed to get probation from a jury.
Yes.
What was your conviction for before?
It was for family violence.
For family violence. Oh, and then you get charged with another family violence charge? Were you on probation at the time?
For the first one, yes, sir.
For the first one, and then you committed another one while you were on probation?
Yes, sir. And
Was it in this court?
And they enhanced it.
Oh, that's what I do. They print that out so I can see it, please. So what's your status of work? You're not working?
No, I'm currently looking. And Judge, I think I can move this case today.
Yeah. Here's something that's got to be moved today, and that is he did not fill out. There's no indigent form here that needs to be filled out
Right.
before we dispose of the case.
Yeah, I don't have no options. It's not supposed to. So just put that on the phone. No, we try to move it today.
I guess, yes. Them on.
Had a hold. Look at this. Look at that. Signed, it's initialed by the JP, but nothing's filled in, and then it's. You want me to tell in front of everybody?
No.
You look at it. You gotta fill that part out. It looks like somebody initialed for the justice of the peace without it being filled out, which is improper.
Yes, sir.
God, you just can't make this stuff up. It's like night court. All right, it needs to be filled out. But
All right, we'll try. No, this. I'm trying to take it. This, I'm trying to take it right now, today. Hey, Larry. So we definitely don't have a hold of it.
hey,
Filling it out.
hey, Mr. Robinson, that was a jury trial.
Yes, sir.
Oh, okay. No, that's why you got 7 years. Yeah, you went for the 4 juries and you had a prior conviction. And juries just don't tolerate that. They shouldn't. We need to get I need to get this thing 2-hole punch when we have time to, because I want it part of the file. Zane Buring, please, done.
Yeah.
25 CR 198, Zane Buring.
He's right here.
Maybe he is, maybe he's not.
Wasn't once before. Okay.
Yeah. That's you, sir?
Yes, sir.
Okay, what's your address? Is it still 365?
No, I
Good.
had moved to Austin.
Everybody's moved. What is it? Thanks. Okay. And I've got Adam Dixon, looks like that has been reset for
Yes, sir.
medical reasons. Princeton Giles,
Cooper?
Tom Burbank,
And Robinson, that's sent to you.
huh?
I sent Robinson.
How did it, please?
That's a photo I sent to you. Hey, Dad.
You keep saying Robinson.
Sorry.
I don't have it. They've been moving.
You talking about Derek?
Yes, that's
Come on up. Derek
I
Robinson.
don't have the complete paperwork. I just want to say it to me.
I'm sending it right now. He said he's sending it to you. It's all filled out.
30830 is now called the state of Texas versus Derek Robinson. That's you.
He's the case that he had for 7 years. So we're gonna move it today.
You're here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment in 18-30830 alleges that on or about April 20th, 2018 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance. Do you understand what you're charged with here? It was synthetic marijuana. If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, the fine may be assessed not to exceed $10,000. Do you understand? Yes. We're gonna fake out the pad and use a different stylus. An agreement's been reached where you would be sentenced to
I put 7 months.
7 months. Is that right?
That's correct, Your Honor.
It's not my case, Judge. I was just standing here. Mr.
You're just standing here.
Yes, sir.
Yes, sir.
7 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of the state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty? Voluntarily and because you're guilty.
Yes, sir.
Okay. Good luck. Here. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence?
No
And
objection.
without objection, it's admitted. Among other things, the state should be mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement if nothing further. And find you, Mr. Robinson, you are pleading to the state jail felony of illegal possession of a controlled substance voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement, and you were hereby sentenced to confinement in the state jail for a term of 7 months. You will be given credit for all time you have served. You understand what has happened today, sir?
Yes, sir.
All right. We'll begin sentence immediately. How much time do you have credit, do you know?
You should have time served, Your Honor. I believe it's showing 211 days.
If you got enough time, they're going to check you in and then you go out.
It's gonna take a couple of business days. We do have to send paperwork.
Well, no, this is actually, I made sure it was at the jail here. The time he said in there on the jail here.
We still, because he sent us to state jail, we still have to send a teletype to state jail. So it
Okay,
may,
right.
may take a couple of business days.
Okay.
It may not. I can't.
Hopefully.
I'll do my paperwork today, but
Get the, I need to get this thing 2-hole punch when we have time to, because I wanted to part of the file. Zane Buring, please, done.
Yeah.
25 CR 198, Zane Buring.
He's right here.
Maybe he is, maybe he's not.
Wasn't once before. Okay.
Yeah. That you, sir?
Yes, sir.
Okay, what's your address? Is it still 365?
No, I
Good.
have moved to Austin.
Everybody's moved. What is it now?
412 East William Cannon.
What?
412 East William Cannon.
East William Cannon.
Austin, Texas, yes, sir. East William Cannon.
What is the zip?
I believe 787.
Yeah, speak up.
I believe 78745.
How long have you lived there?
For the past year.
For the past year, and you don't know your zip code?
I never use it last time.
You never use it?
No, sir.
It comes in handy when you write a letter.
I haven't wrote a letter in a long time.
Or paid a bill.
Sir?
You pay bills, don't you?
I pay the person that's owns the stuff.
Oh, you're renting there?
Yeah, I'm just.
Oh, okay. All right. Yeah. Did you get your driver's license changed?
No, sir. I haven't had a chance to be able to give my.
How long have you been there?
I'm just doing a year, sir.
A year? That's no excuse. That's not, the state doesn't put up with that. What do you have, 60 days? 60 days, something like that. That's all, days, not a year.
Boy,
You don't have a driver's license? Well, how do you get around? Do you walk?
My dad brought me there.
Okay, but you don't operate a motor vehicle? But you still have to have a state ID of some sort.
Like I haven't been over to get mine.
Who's the landlord there?
There's no space savings.
Okay, friend, acquaintance. All right, now, let's get to the meat, the guts of this one. You're charged with what's called engaging in organized criminal activity, which in summary, you and others collaborated in, according to the grand jury, in carrying on a criminal activity which involved illegal possession of a controlled substance and possession of dangerous drugs and illegal possession of marijuana. You understand what you're charged with? And this, the way this has been indicted, this is a first-degree felony if convicted. You're facing life in prison if convicted. Do you understand?
Yes, sir.
What happened was the way the probable cause affidavit is, y'all had a large-scale drug operation going on Homer Drive in Beaumont. And people convicted of such a thing we're talking about pounds of drugs. They end up paying a steep price. All right.
For roughly 4 weeks. It's a brand new case. Yeah, I just met this morning.
You're unable to hire a lawyer? Is that right?
I'm trying to obtain.
Are you able to, where are you working right now?
Right, I work at a recording studio and I'm also a student.
How much do you make an hour?
12 every year.
You know, 12.
12.
Yeah, that's like 20 grand. You're, but for a first degree felony, an attorney's gonna cost that.
Right.
At least. Fill out an indigent form. Get over there, fill that out, an indigent form, and that's to be completed so Mr. Dusler can continue to represent you. You can hire somebody anytime you wish. The taxpayers would love that, rather than paying for your mess. We would rather have you earn it and pay for messes. But until then, fill that out. We will go to the next step. DeMarcus Roy, Don, that's next. DeMarcus Roy, 25 CR 338. See, this is, you're DeMarcus Roy?
Yes.
Patrick Pleasant, come on out.
Highlighted it for me.
You're clear to go as well. Thank you. Zane Buren. On the other hand, you're not. You got drugs in your system. You got, you tested positive for tetrahydrocannabinol marijuana. Your bond is revoked. What is his bond?
1,000, Judge.
Is revoked. It is now doubled to $30,000. Yeah, you can blame yourself, not anybody else. You gotta have I'm gonna speak and you be quiet. Thank you. This isn't a debate. The test shows you've got drugs in your system. All right, and stand by. Yeah. You shouldn't be surprised. I mean, you're in organized criminal activity of making drugs. Anyway, your bond is now $30,000. Plus you have to have a drug patch as a condition of bonds. So if you post a bond, once any drug gets into your system, I'll know about it. And then you won't have a bond the next time. This one out. Mr. Dusler, you're his attorney? Yes. All right. He's going to be taken into custody. What's the next event?
An announcement, Judge.
An announcement in 4 weeks. That is all. And Mr. Buring on this date has filled out an indigent form. And Mr. Dusler will continue to represent him. On Derek Robinson, he is declared indigent, and an attorney will continue to represent him, even though this wasn't filled out till
Yeah.
months later. And the court is
Yeah.
is accepting responsibility, not the previous JP that did not even have this filled out. That's we're John West. Anything else? We're waiting on John to finish papers. Okay.
Your Honor, if I could address the point first, I could just do some.
I don't know, who are you?
I'm the father of one of the defendants who got, I think, already locked up, Jane Geary.
Okay, who is his attorney?
He has a point of attorney, but I was not, actually, that's what I was gonna speak. I was gonna try. He got his bond revoked by you, so you know, had it earlier, that was his, sir.
Oh, today?
Yes, sir.
Okay.
And, well, sir, he was only arrested March 16th. And he, in school, he's working, he has not been using, he hasn't had enough time for the THC to get out of the system. And his attorney was just a point of, he should have told you that. But it was, sir, he wasn't even picked up, he didn't even have a clue he had a warrant. But he has not been using, sir. I'm his father, I'm it's watching every single step of the way, it's making sure he's reporting, making sure he's doing what he's supposed to do. He's enrolled in school and he has a job at a recording studio. He is.
Yeah, that's right. I remember hearing about that.
Yes, sir. He is all the way out of trouble, Your Honor. He has not been using.
The scientific test proves otherwise.
Well,
It's not a debate.
To rest.
I'm sorry, it's not a debate. If he has drugs in his system when he's tested, that's all we know for sure, because you don't have any method of telling when that went to, you're gonna speak over me? You don't have any method of telling when that might happen. You don't know. You don't know. But when they're tested in the courtroom, when they test positive, sorry, they shouldn't have been ever using drugs in the first place. But when it tests positive, there is no way you can say that that didn't have anything to do with recent use, misuse, not you. So you can, all right, you need to tell your attorney, the court's orders are what they are. And I'm not changing them because of your opinion. Who is the attorney on the case? Who?
Don Dusler.
Don Dusler. Is he around?
I didn't understand why he didn't say that to you in the beginning when you put it
Uh,
on. He didn't argue anything and I didn't
Yeah,
understand that.
you need to call him and talk to him. Don, what's his
He
phone
walked
number?
down on me, sir. I tried to speak.
I'm gonna give you his phone. I'm gonna give you his phone number. Here, come on up. Yeah, you have a right to talk to him and to get heard and find out what his plan is on representing your family. Yeah.
Your Honor, I tried to speak with him and he told me he didn't care and that I get to go do something. We tried to speak to him 3 weeks since he was appointed to him. He would not answer his phone. He would not return calls. He would not return messages.
All right.
Not
What's
from anyone,
what's the
sir.
defendant's name? Again, your son's name?
Zane Buring.
Okay, I'm gonna set that for a hearing tomorrow morning.
Okay, we live in Austin, Texas. I got
I'm
up at
sorry.
4 a.m. to be here.
Yeah,
We were gonna
see, he's gone. What I wanted to do is set it for tomorrow, have Mr. Dusler in here explain why he's acting that way. If that's the way he's acting now, I'm hearing your version. I want to hear him too.
Yes.
But he's supposed to handle, all the defendants are supposed to be represented by competent, vigorous representation.
And he told me outside he didn't care, sir. And that's where his words.
Well, I'd like to, yeah, I need to.
Mr. Ibarra was standing there when I was trying to talk to him. Oh, he would, he told me he didn't hear. He was saying he was outside.
Well, I mean, don't call witnesses if you
Sorry,
don't know what they're
no,
saying.
sir, I'm sorry. I just thought, no, he was standing there. I apologize. But Your Honor, I can attest to my son has been staying out of trouble.
Okay, but the scientific test proves otherwise. We've been doing this 19 years, sir.
It's been less than 40 days, sir, since he was arrested. And I promise you, sir, he's been doing everything to stay out of the way. Enrolled in school, in college.
You're saying that the marijuana has been in his system for 40 days?
Sir,
Is that what you're saying?
Yes, sir. I would like to.
Sorry, it's not going to work.
Sir,
It doesn't. That's not
marijuana
the way
can
it
last up
works.
to hair follicles 90 days, up to 60 days in your urine if you're a chronic user.
Anything else?
No, sir.
Okay. We're going to give you Mr. Dusler's number. I want to know if he's recusing. There's a posted note right there. If he is not, if he does not answer phone calls in regards to immediate family members who are trying to get information for their client, that would be inappropriate. And I'll have.
Yes, sir. I'm sorry.
And then he's appointed at the court's discretion. And if lawyers are not treating clients and relatives of clients, especially those who are in custody appropriately and professionally, then I'll deal with it firmly.
Your Honor.
And that I don't put up with that. And I don't generally get complaints. But when it does, when we do, we address them. You have a right to find out as much information as you can about your child.
Your Honor, but Your Honor, I promise you, my son, I wouldn't be standing here if it wasn't for the fact that he was doing so well in life. I would not be standing here, Bridget. Okay.
Yeah.
And
Look, just at the end of the day, not to say that you're don't act naive. But let me just tell you, when people use drugs, I've only been doing this for 40 years, involved as a defense attorney, a prosecutor, a judge now for 19 years.
Yes, sir.
When it comes to drugs, people are rarely forthright.
Yes, sir.
Because it's something they know is wrong and they hide it, and it gets the best of them, and they lose their abilities to really think rationally because they become the drug overpowers them, and it's always been that way.
Always, yes, sir.
And I see it over and over again. And the family members are the last. They're never going to do things in front of their family or let their family know because they know it's wrong. They're ashamed of it, but they're stuck. And I'm thinking when we deal with this, we have a 92% success rate in our probation, especially drug cases.
Yes.
The average is 75% in the country.
Yes.
We have a 92 because we deal with things pretty aggressively on getting help, especially with drugs.
Yes, sir.
But I know what you're saying,
He has,
but
he
I
doesn't
know,
use
I
any
don't,
other drugs.
but I
at
know
all.
what happens over and over
Yes,
again
sir.
for 40 years, sir.
Yes, sir.
40 years.
I have no
It's-
doubt in my
The
mind.
parents come up here and they're shocked and ashamed and they're trying to defend their child, but he's a grown up.
Yes, sir.
And you don't see him all the time.
We-
And you don't see him all the time, and they're not gonna use drugs in front of you. They're
No,
not
sir,
gonna
I-
wanna
I
embarrass.
Yes, sir. I wouldn't, I understand what you're saying. Yes, sir.
But
Again,
and
he
the
doesn't
scientific
use-
test is what we use, and that is
Your Honor, if you were to give him a
proven.
chance, if you were to give him a chance, I can guarantee you, he comes back in for 30 days, he will not have anything in his
It's in the
system.
debate.
That would give
I don't
plenty
deal
of time
with-
for his system to be clean of
I
marijuana.
can't deal with, I'm not gonna deal with you on that. He tested positive, and that's what we test for. Now, his lawyer needs to get in the game to get him up here so we can resolve this case one way or the other.
So that's when I had asked him outside. I asked him if he would come in and try to talk to you. He says, no, this isn't Austin. And I said, sir, you're here to represent my son. He said,
That's-
do you live in Austin? And he brought up Austin again. I said, sir, I lived here as a child. I know what.
I
you
understand.
see."
And he
then
shouldn't.
he walked off on me. And I
Well-
said, sir, can you please go let them know he hasn't been out?
Are you,
long?"
but you're not gonna be able to be here tomorrow?
No, sir. I missed up. I own a tattoo studio and
Okay.
he's got school in the morning and work tomorrow.
I'm sorry. I can get him back
Please
in the
go,
morning and
please.
talk to the attorney and have him explain, but you're not gonna be here. And having explained what you have told me, and without you being here, it's not gonna be much of a debate.
Yes, sir.
But I can bring your son back and ask or direct him, since I appointed him
That
as
would be
the attorney,
amazing, sir.
direct him to aggressively deal with this case and also be forthright with family members, close family members, so they are not in the dark on the way he's gonna represent your son.
Yes, sir. I can show you numerous calls that we've made to his office, both of us over the past 2 weeks. No answer, no reply to messages, very thorough messages, very clear. Made sure we just need to get some information about court. We were trying to appear by Zoom today because we live so far and he
Yes,
had
sir.
work.
Oh.
And we thought that would be better, but Your Honor, I
But
promise
see,
you,
that's,
if
see,
he
that's
wasn't
another problem.
working so hard
This
to
is
stay
why
away
I
from
don't do,
here.
see, this is also why we rarely do Zoom, is because when it's dealing with drug cases, we don't have the ability to test.
Sure,
And
yes, sir.
I can guarantee every drug defendant would want to appear by Zoom, and we're not able to test, which is what we have.
And
to
Your
do.
Honor, we didn't get a reply. We drove our butts up here. I got up
Good.
at four o'clock this morning after I worked till midnight.
I caught
I
the
slept
storm.
an
You got
hour.
caught in a storm, huh?
I drove through it, Your Honor.
Yeah,
I
yeah, it was a
drove
bad
through it.
storm.
He's not a flight risk. He's not going anywhere and he's not a doper. He smokes in the hot, man. And I.
That's not right.
No,
But that's not
no,
right.
it's not.
And you
It's
don't
not
even,
right.
and here's the
he's
deal,
not-
you don't
he's
even know
not.
what you're, if, unless you're making it, you don't know what's in it anymore.
Right. It's
I mean,
dangerous.
I had people here with synthetic marijuana cases.
It's so
which
bad.
is-
And you know,
which is
there's a lot of
like-
legislature going on, so there's a lot of that stuff, THC going on in Austin right now. And I totally understand it's illegal, period. But Your Honor, I promise you, it's been a small amount of time, and with the amount of weed that these guys smoke every day, all day, I know that he's doing the right thing, Your Honor. If he wasn't, I wouldn't be standing here. He's doing better than he's ever done. His mother's been in prison for murder since he was 4.
So
I wasn't worth. His mother's been in prison for murder since he was 4. Out of this, Jennifer Walter. Yeah, that's
In this court?
I don't know who it was Halloween night of 1999. Jennifer Walter and Christopher.
Yeah, that's before I got there.
Yeah. It was me. I was 19 years old when I had him. It was me, and that was it. And I didn't have any parental guidance. I'm lucky to be standing here in front of you myself, sir.
Why is that? Because you've learned to make the right choices.
Because I didn't make I didn't make good choices, and I didn't have anybody to help me make good choices. But he has somebody here now, and although I wasn't doing the best when I was younger, as past 14 years have been phenomenal. I own 2 businesses. I also help with an entertainment company, and I'm staying out the way. And I've worked. I would not. A year and a half ago, I would not be standing here talking to you. I wouldn't be here.
What I do when you test positive, you heard. your
Yes, sir.
Bond is revoked,
Yes,
then
sir.
it's double. Plus you have to wear a drug patch.
Yeah,
And
and
that's
I can't
all of
afford
the-
double the bond. I
well,
spent everything I had just to get him
What
out. and I
I'll
would
do is
only-
I'm gonna list, I'll bring it back tomorrow. Whatever the bond may be, I can change a bond.
Yes,
for
sir.
any-
I'm poor.
But a drug patch is going to be required.
Yes,
of-
Your Honor, if he comes back in here and he's dirty, lock him up and don't give him a bond. I don't care.
But
I
he
promise
can't,
you, he's
we
doing
don't
good.
release him until he tests negative.
Okay, yeah, it will
And
probably
then
take
he's gonna
about
have to have a
30
drug
days.
patch, because if you put a drug patch on early, it'll test positive.
Yeah, right, yeah, yes, sir.
When they
And I
take it
don't
off.
want that for him.
Yeah,
man.
and
I
he's-
just don't
he's
want him to
involved.
get kicked out of school.
So we'll bring him back tomorrow.
Yeah.
Then I'll do, I'll do a drug test on him and see what happens tomorrow.
Okay, yeah,
And then-
it's just for marijuana and that stuff binds to the
No.
fats. It's not like it's out of your system in 72 days. If you do the research, it binds to the fat cells in your
Thank
system.
you.
30 to 60
I'm familiar
days.
with
Yes,
it, sir.
Up to 90 in the hair.
But too often marijuana is used
Yes,
as a
sir.
carrier with other methods. And
He just had,
also you don't know what's in the, how marijuana, some marijuana is stronger than others, and it just works that way and works differently. And that's why when you sniff it, if you smell it, you run like the wind,
Mhm.
especially if you're on bond. You don't even want to sniff it.
Yes,
You
sir.
want to move out of the way, stay out of the way.
Oh, and that's almost.
Because you don't
impossible
know
out
what it's
there.
going to take to get into your system. And the tests are those are profoundly accurate tests. Is what has been proven accurate through court decisions and science. So that's why we don't do it flippantly.
If it had been over 2 months, I would definitely not even have asked you anything about that or even attempted to. I just thought his attorney should have said, Your Honor, sir, he has only been out of jail for 40 days. He hasn't had enough time to get his system cleaned out. Give him a couple of weeks to get his system cleaned out, come back, take a test.
We'll bring him back tomorrow and see where he is.
Yes,
And then I'll bring him back every few days until it tests negative.
Okay, and that's fair. And when he
That's
says
what we-
negative, sir, I promise you,
And I'll talk to Mr. Dusler about
I-
what your complaints are, but
I'll try again, Your Honor,
Yes,
to
sir.
contact him. And even on his Google reviews, it says he does not contact us. Because I tried to make sure I was calling the right thing. And on the reviews, it says he will not communicate with his client. And it's several reviews if you look yourself, and that's the thing.
I don't.
I was scared when I walked out there and he was representing my kid because he didn't even sit here and say, oh, no, sir, he's this,
Okay.
you know.
I
That was the
understand.
first thing he should have said was that he has only been out for
Yes.
40 days.
Okay. All right.
Well, I really appreciate
Thank
you
sir.
taking the time to
You
listen.
have
to
you have the defendant's name for tomorrow
Yeah.
on this case? Thanks.
I get back to
Tom, do I have a plea? Thank you.
On the plate.
Done it twice and it's hung up on me, so
Hey, this is just terrible today.
Oh, I know.
Yeah.
Hi, there we go.
Yeah.
One of the things I Mr. Giles, Prince Giles, did you withdraw the bond?
Yeah, we didn't do it.
Okay.
Yeah.
I didn't hear.
No, it's okay. At least he had a note that he would come.
Okay, John, we're waiting on your plea.
Yeah, as soon as I
Good
get
luck,
it,
because this devoted attention. You have got my attention. And that's not what you want. Sit over there. Sit over there. We're gonna deal with you and the other people who are taking care of their business. We can take care of them. Thomas Skinner. Come on out, 25 CR 419. Should be. You're Thomas Skinner?
Yes, sir. How you doing?
I'm fine. You gotta be kidding me, right?
What's that?
That's what you wear?
I didn't have any clean shirts.
You don't have a clean shirt at all? I'm on the Salvation Army board. We got all kind of stuff for people. But you can't wear, I mean, would you wear that to church?
No.
Why not? Disrespectful? Would you say it was disrespectful for church? Well, you don't think court
I do
is,
apologize.
you don't think the Constitution is something that deserves respect?
I apologize.
You gotta do better than that.
I understand.
There's no excuse in this town. I mean, we're low.
Well, I live in Hampshire, still just.
You, well, but we take care of people from Hampshire too. We can take care of
I
people
do
who can't.
apologize, Your Honor.
Yeah, I don't want to see that again.
Okay. Hope you'll never see me again.
Look, everybody, yeah. You know, if I had $1 every time somebody said that, I hope that's true, but I'd be Donald Trump. If I had $1 for every time people said that. That just seems to be what everybody says, but I see them a few months later in court over and over again. And fix this. Have you ever been convicted of a felony before?
Yes.
What?
Child endangerment.
Is that it?
Yes, I believe so.
You don't know?
I'm sure there's one more. I can't remember what.
You forgot a felony conviction? You forgot?
I was on probation for 5 years in 2010 for child endangerment, child abandonment.
Okay, was that regular probation or deferred?
It was deferred.
Okay, did you get revoked?
No.
Okay, you weren't convicted.
Okay.
You don't know that?
I was assuming I was.
Who said, well, you look into that. I don't think you're convicted if you were on deferred and it was not revoked, sir.
I'll look into that when I get out.
Is there anything else that you can't remember that you coming back to your mind?
That's all I can remember.
All right. I think if you would have had that prior conviction, what county was that?
Jefferson.
It would have showed up on the indictment.
Okay.
And it's not.
Okay.
Well, you don't want to go around filling out job applications saying you were convicted if you want to. You're not gonna get a job.
Yes.
Huh?
It was deferred.
See, it was deferred and it's been dismissed.
You're welcome.
Okay, you're clear.
Okay.
Except for this now.
Yes, sir.
See back over there.
All right. It's a state jail felony which carries with it up to 2 years in the state jail. All right. Does the defendant who's here with his attorney, Mr. Deucer, waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about February 28, 2025 in Jefferson County, Texas, you committed a state jail felony of theft, which carries with it, if convicted, confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine up to $10,000 can be assessed. Do you understand what you're charged with?
Yes, sir.
Okay.
It's the worst thing ever. It is. Right, well, that's what I know. But there's a trustee. That's not probably the most efficient one time. Anyways, probation and
Seen the block chisel. Cavemen used to use that. That's what they found. Okay. You understand what you're charged with here and
Yes,
the
sir.
punishment range applicable?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on deferred again?
Yes, Your Honor.
Where you're, Santa has come to see you again.
Yes, Your Honor.
You're placed on deferred or unadjudicated probation, which, well, we saw how well that worked last time, kept him out of trouble. Or
15 years.
it's supposed to be forever. You're not supposed to commit.
I was trying to do something nice for a person.
And well, you owe $1,504 to the complainant. You understand?
What's that mean?
The complainant, the person who was victimized. You owe, that's what the loss is. It states restitution in the amount of $1,504.
Okay.
How soon could you pay that back?
I can pay. I don't have a job right now, but I have a girlfriend and she's helping me out. But I'm going today and trying to find a job. Taking 6 months.
Because that's going to give you 6 months to pay it back.
Okay.
But don't be bumming off your girlfriend.
Well, I don't. I mean, I do try and find odd jobs.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty, sir?
Guilty.
Are you pleading guilty voluntarily?
Yes.
That is on your own free will
Yes.
and because you are guilty.
Yes, Your Honor.
I'm going to show you what's marked as State's Exhibit 1.
You can show me what?
Yeah, right. Here. That thing. That, all of our pads are down except that one. The one we don't ever use, and we don't want to ever use, but we're stuck using it now.
Yes.
You can see why. It's an odd thing.
Terrible with that.
You've seen State's Exhibit 1. Did you sign it voluntarily, understand it, discuss it with your attorney, or the contents all proved correct?
Yeah.
State's Exhibit 1 tendered into evidence without objection. Among other things, it states you were mentally competent to enter your plea of guilty. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included. You were giving up your rights to your jury trial and your rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer.
Yes, sir.
All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports waived.
Yes.
I'm going to follow this agreement. And I'm going to find you pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted yes to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on, you know what it is, deferred or unadjudicated probation. There will be terms and conditions of probation that you need to follow so that you are not revoked and convicted.
Yes, sir.
The first thing, you will pay restitution in the amount of $1,504 to the complainant, the victim. That must be done within 6 months. There will be other terms and conditions of probation which are normal and customary that the probation officer will go over with you in a minute. Make sure you follow those. If you fail, your probation can be revoked.
Yes, Your Honor. Thank you.
You're then be found guilty and then sentenced up to 2 years in the state jail.
Thank you, Your Honor. Not for your games?
No, you're going to go over the, let me sign this. And you're going to go over all of those.
It's how long?
You do well, it can be shortened to a third.
Thank you.
Okay, do you see that, ladies? Is it the green thing? Is it the green thing today? Is this different? This whole thing.
Yes. Send it back to me. Yes, correct. It's not holding a charge. So
And look, here's the deal. It pulls back.
Judge, you can use your other pen.
Yes.
I mean, it's a little bit, it's a little short. It's different from the one.
Other stylus.
Yeah, I mean, do that. I think I'm using the other side. So, okay.
The other stylus.
Jasmine Young, please, 25 CR 363. We're going to do.
On this with the writers of conflict.
What, say it again?
I've got a big replacement, the conflict that was previously pointed out.
And a warrant will be issued for his arrest. Bond was $30,000. It is now doubled to $60,000. The defendant must have a GPS device on him, so we know where he is when he's not in court, when he's supposed to be. Next, 18-28851, Kim Nguyen. And Mr. Wynn Thomas is the attorney on that.
I can see her, you just got that, use the restroom for a second, you did.
Okay,
And then I'll need the client to come fingerprint in front of me. Those back in the corner.
okay, while we're waiting, Mariah Gallo. Mariah Gallo is on.
I'm sorry, I was probably doing 4 things like one, and I said it. Just.
Say that again?
He's here, but he just told me to call his name.
Let
so
me,
I should email the restaurant.
Yeah, I will.
Was there a bar meeting going on, a bar association meeting in the restroom going on? That's.
It might be him, sir. Can wait. Come on.
You know, yes. Mr. Berman said.
That changes
All right, then
the status of it.
we'll reset it for 4 weeks and the attorney needs to, whoever is the new appointed attorney needs to be made aware. Yes. Kim Wynn, thank you.
You might wanna.
I need Mr. Wynn, Mr. Wynn. And we now call 18-28851. Kim Wynn, that's you, sir? Yes. And Thomas Wynn is your attorney. Are you related to Mr. Wynn? Wynn is like a Smith, isn't it? The language. All right.
Giles, Mr. Giles, what you had was a.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, we can, Your Honor.
In summary, Mr. Wynn, in 18-28851, you were charged with the state jail felony of engaging in organized criminal activity. And the indictment goes on to state that on or about January 4th, 2018, my God, I was just a teenager back then. Why did this take so long? Did you move or something?
Yeah.
Joe, are you still living at 11814 Sharpview?
Yes.
Okay, in Houston? Something must have happened because that's, we're talking 7 years.
It's a long time ago.
Long time ago. It looks like you were at 17814 Sharpview at one time. Then it's 11814 Sharpview is where we have you now.
I never been the other one, maybe.
You never been at 17814 Sharpview?
No.
Never lived there? That's what happened. That's what the indictment shows. But you're at 11814.
Yes.
No. Okay.
Somebody transpose a number from 7.
Yeah. One number off.
Yes, sir.
Which in Houston, that's everything.
Yes.
3 million people. All right. Again, on or about January 4th, 2018 in Jefferson County, Texas, you committed the state jail felony of engaging in organized criminal activity by intentionally and knowingly operating and participating in the earnings of a gambling place. And which involves 8-liner matters.
Yes, sir. We're pleading to the lesser included of gambling promotion, which is on that second paragraph on the next page. Part of the offense the offense of gambling.
This is, I've never seen an indictment written like this with what appears to be 3 different paragraphs. So each of these paragraphs constitute a separate offense?
No, sir. They're all one offense is the
Second and third?
Yes, sir.
Second or third?
Yes, sir.
Either one is good, right? It doesn't require second and third.
Well, no, they both say and. So it's part of it's not or, it's an and. So it's all one crime. It's just the way they alleged it. But we're proceeding under the lesser included of gambling promotion, which is the last part of that last paragraph. Make it a class A misdemeanor.
Yes. Yeah, he does.
Gambling's in 47. It's 4702 is gambling, so in 47.
First disposition of gambling paraphernalia ban.
Good luck with that.
It's in Code of Criminal Procedure. All right.
Yes, sir. And I think through the word have been filed on all these, so I think that's already been taken care of. Just dealing with he's was one of the employees that was working there. It was not a manager or anything.
So section 71.02 Texas Penal Code, among other things, states that a person commits an offense with intent to establish and maintain or participate in a combination or in profits of a combination or as a member of a criminal street gang or foreign terrorist organization, which is inapplicable here. The person commits or conspires to commit one or more of the following. And subpart 2, any gambling offense punishable as a class A misdemeanor.
Yes, sir.
So you go to gambling under chapter 47.02, a person commits an offensive
We're doing
make the
gambling
bet,
promotion.
make the bet, plays and bets. And that is no, that is a class C misdemeanor. What we're looking for is what it takes for a class A misdemeanor.
Gambling promotion is the one we're
47.03.
Yes, sir.
That is a class A misdemeanor. Operates, participates in the earnings of a gambling place, engages in bookmaking, for game, becomes a custodian, sells chances, or for gains, sets up, promote. Okay.
Yes, sir.
So all of those are different ways you can commit.
Yes, sir. The last paragraph, last sentence talks about committing the offense of gambling promotion or keeping a gambling place. We're going gambling promotion because he did participate in the proceeds.
Okay, that is all under 47.02. That's what he's going to be, the lesser included offense.
Yes, sir.
Is what he's gonna
Gambling
be
promotion, yes, sir. 4703.
So we're taking organized criminal activity out and then
4703. Gambling
section
promotion.
47.03, a person commits an offense if he intentionally or knowingly operates or participates in the earnings of a gambling place.
Yes, sir. Yes, sir.
And this states
The last paragraph,
that
it states
then and there.
if you look at the last paragraph on the last page, that top part, it says participated in the proceeds of.
Right here in the first paragraph, it says, did then and there intentionally and knowingly operate and participate in the earnings of a gambling place.
Okay.
So it appears that it is clearly a lesser offense that can be applied, which is a class A misdemeanor, carries with it up to 1 year in the county jail and a fine up to $4,000 and or a fine up to $4,000. Do you understand what you were charged with here in this case, a state jail felony, but what is agreed upon between the lawyers that you would be pleading to the lesser included class A misdemeanor? This pad, we won't ever use it again. This
very touchy.
it doesn't show up until about 3 seconds after you write. And then so you can't.
We only do it for 10 seconds.
Right.
So right after I wrote it. Nothing bad was enough.
God bless you. An agreement's been reached where you would stand by.
Michael.
Class A, you would be pleading guilty to the Class A misdemeanor of gambling promotion and be placed on 1 year deferred or unadjudicated probation. Is that 500?
Yes, sir.
Fine. Okay, I got it. That it turned out to a 3. It's not 3, it's 5.
It's 500.
Redo it, 5. And placed on 1 year deferred or unadjudicated probation for this Class A misdemeanor, $500 fine. There would be other terms and conditions of probation which are normal and customary for this type of crime. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included Class A misdemeanor under the state jail felony? Guilty or not guilty?
Mute.
Are you pleading guilty voluntarily and because you are guilty? Yes.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Did you understand it? Discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence and without objection.
No objection now.
Admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses like you were pleading guilty to now. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I'm going to follow this agreement and find, sir, you are pleading guilty today voluntarily to this Class A misdemeanor of gambling promotion. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to do that. I'm going to defer any finding of guilt for 1 year, place you on deferred or unadjudicated probation. You must follow certain terms and conditions of probation. There will be a fine of $500, which must be paid. And the probation officer will go over those terms. If you do well within 1 year, this case will be dismissed. Do you understand?
Yes, Your Honor.
If you fail, your probation could be revoked and you could be sentenced up to 1 year in the county jail. We don't want that. So please see the probation officer and do well. Thank you. Yes, sir. Thank you. David,
Yes, sir.
who do you have that we need to deal with? I've got Donna Arnold.
I have
And-
Donna Arnold and I have.
Dior Fraser.
So, I don't know her.
And Donna Arnold, can you give me those 2 files? Donna Arnold. Two cases are called 24 CR 1879 and 1880. The state of Texas.
It's us pond. I mean, it's fish. I mean, it's got plenty of fish.
Oh, wow.
And then my sister-in-law has got a new working on fish, so he cleaned up around the pond, repaired his deck and got it all in shape. So she went fishing this weekend several times.
All right, 24 CR 2109 is called the state of Texas versus Kong Van Palm. Mr. West is the attorney. Are you Kong Palm?
Yes.
Do you speak English, Mr. Palm? A little bit,
A little bit.
a little bit. Ciao. And do you speak English and Vietnamese
Yes, sir.
fluently? Who are you?
I'm, Lee.
You're his niece. What is your name, ma'am?
Good evening.
And how long have you been speaking English and Vietnamese in your life? Your whole life?
Yes, my whole life.
Okay. Raise your right hand. First of all, that's your left hand. God bless you.
He doesn't have a right hand.
Oh, he doesn't have a right hand. What happened? What happened? Was it in an accident?
Yes.
Sure about accident.
Oh, that's terrible. Okay, but raise your left hand and your right hand now. Do you solemnly swear or affirm that you will truly translate from Vietnamese to English, English to Vietnamese, Mr. Pom Kong Poms, and he's your father?
No, he's.
Your uncle, his answers that he makes from Vietnamese into English, and the questions that are asked of him by the court or by his attorney, English, you will translate into Vietnamese, the language that Mr. Palm understands. You will do that correctly and accurately, so help you God.
Yes, sir.
And I'm going to ask you to translate to Mr. Palm. I'm going to speak English, and I want you to speak Spanish. Spanish is what we often do.
Yeah.
Speak Vietnamese, translate Vietnamese. Are you Kong Palm?
Yes.
You put your hand.
He said yes.
Okay. Do you solemnly raise your right hand, your left hand? Do you solemnly swear or affirm that you will make true answers to such questions as may be asked of you during this hearing? And you will answer truthfully, so help you God.
Yes.
Lower your hand. And I'm going to ask him questions and just repeat, ma'am. And tell us your full name. Tiffany Lee, do we have that? How do you spell Lee?
L-E.
Okay. Are you Kong Van Pham?
He said yes.
Okay, you won't say he said, just you'll answer yes on his behalf, just like he speaks. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 10th, 2024, in Jefferson County, Texas, that you committed the offense of operating a motor vehicle while intoxicated. Do you understand what you're charged with?
Yes.
Right. The indictment also goes on to state that you have 2 or more convictions of operating a motor vehicle in a public place while intoxicated. This states that you were convicted in 2005 and 2011.
Yes.
Do you understand? All right. If convicted of paragraphs 1 and 2 of the indictment, you are facing a 3rd-degree felony, which means you can be sentenced to no less than 2 years in prison, no less than 2 years in prison, up to 10 years in prison. and fine up to $10,000. Do you understand?
Yeah.
An agreement has been reached, though, where you would be pleading guilty to what? The DWI?
Yes, sir.
Isn't that a class B?
No, it's
Class A?
enhanced.
A regular.
Or you regular?
It says lesser included. You know what? I've got Kim Wynn. This is Kong Wynn.
Yeah.
Tong Van Pat.
Kim, we already did.
Yeah. Okay. That's
such a change up from me. I was like,
that was the only
No,
Vietnamese name we had.
Yeah.
It's like, okay.
Sorry. So
You were just checking us, weren't you, Judge? Thank you.
an agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended and you would be on probation for 10 years. You would pay $1,000. There would be terms and conditions of probation, which are normal and customary for this type of offense for DWI. And you must, as a condition of probation, you will be sentenced to 10 days. Is it 10 days?
Yes, sir.
You will be sentenced to 10 days in the county jail as a condition of probation. You have to go to jail for 10 days. Do you understand? He has to go to jail. It's required under Texas law for all cases of a DWI third.
A procedure coming from.
Okay.
Yeah, we can do it later. I would request.
It can be postponed until he's able to do that. How long will he be unable to go to jail? When can he attend the 10 days, which is required?
Okay, the obstacle of his own, can you take it in jail? No, nothing.
Yeah, you're allowed as long as you have a prescription.
Take it with you. Yeah.
Yes.
Yeah, that's no problem. How long, when can you,
Now.
a couple weeks, a week, 3 weeks?
No. Next week,
How about is 2 weeks good?
I think.
Okay, so he would check in. What's 2 weeks from today?
You can.
On or before 6
June
o'clock
9th.
PM.
June 9th.
Well, Tuesday, though, today.
Yeah, oh, that's right. That's right. Sorry.
Yeah, today's a Tuesday.
Would Monday be better?
I'm living it like a Monday. I apologize.
Think we all are.
Monday
Is
be better?
Monday or in 2 weeks, Monday or Tuesday, which is better?
Huh? Tuesday.
Tuesday. All right. 2 weeks from today, you must check into the jail on or before 6 o'clock PM. And you would have to spend 10 days and then you'll be released. If I follow this agreement, you have no right of appeal of your case.
Say yes.
How do you plead to this charge, guilty or not guilty?
You say guilty, you say guilty.
Are you pleading guilty voluntarily and because you are guilty?
Wow. Yeah.
And prior convictions of DWIs in 2008, 2005 and 2011.
Yeah.
Are those true and correct as they are alleged in the indictment?
Yes.
And are you pleading true and correct voluntarily because they are true?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that?
Yes.
Did you understand it, discuss it with your attorney? Are the contents all true and correct in State's Exhibit 1?
Yes.
State's Exhibit 1 is made a part of the record for all purposes without objection? Okay. This states that you are mentally competent to enter your guilty plea, and it is freely and voluntarily made. You understand what you're charged with. Your attorney has reviewed all of this with you. You are guilty of the offense charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true and correct, this says. Is that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes, without objection.
No objection.
Is a pre-sentence report waived?
Please, Your Honor, yes.
I'm going to follow this agreement. And Mr. Palm, I'm going to find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
Yes.
You are giving up your rights to a jury trial and the rights to the presentation of witnesses. You are satisfied with your attorney, and you are also guilty of the two DWI convictions in 2005 and 2011, as the indictment shows. And all of this is true and correct, so help you God.
Yes.
State's Exhibit 1 made a part of the record for all purposes. Sentence report is waived?
Yes.
All right. I'm going to find you were pleading guilty to paragraphs 1 and 2 of this indictment, which constitute a third-degree felony. You are mentally competent to enter these pleas today. State's Exhibit 1, admitted at this hearing, supports your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of DWI. I am going to follow this agreement. You are hereby sentenced to confinement in the institutional division prison for 10 years. That is suspended and you were placed on probation instead for 10 years. Please follow these terms and conditions of probation that the probation officer is going to review with you here in a minute. You must pay a fine of $1,000. You must Stand. You must have an auto ignition interlock system in any vehicle you operate. That's to test you before you start the car to make sure you're not intoxicated. Everyone with a DWI has to have that. There will be other terms and conditions of probation that the probation officer will review with you. Please make sure you follow these terms. If you fail to follow these terms and conditions of probation, your probation could be revoked. And then you could be sentenced up to 10 years in prison. We don't want that. So make sure you're always sober when you drive. The probation papers are given to this lady. Please speak with her and she will go over all those terms and you're going to need to translate with her and Mr. Palm.
Yes.
Mr. Palm, do you understand what has happened today, sir?
He's on his medication. If he get in, how do we?
Yeah, he has to have a prescription. Okay, he needs to bring that when he checks into the jail. And what they'll do is they'll keep it and they administer it to him. They have to give it to him because they don't want, if people kept it in the jail, they'd give it to other people. We don't want that. It's in the bottle. He has to bring that with the prescription. God bless you.
The prescription is he's going Houston, Winston, Texas.
Get them to send an email with a prescription or something and print it out, something to verify that it's prescription.
Yeah, work with Mr. West. He's the attorney. If you'll tell him where the prescription is, they can fax or send something to him and he can print it out properly. And if there's a problem, let me know. Okay, he needs to report
By next 2 weeks from
June
today.
10th.
Yes.
June 10th. That's okay.
When you check in jail from Jefferson.
Jefferson County, yes, ma'am. Here, please see the probation officer. Thank you. Thank you. Ciao. Anything else? We're in recess till when?
1:30.
1:30. One ending, right? Yes. What are we going to do today? What are we going to do?
Oh.
It says a motion of motion hearing, right? Everybody ready?
Yes, sir. State's ready.
Yeah. Okay, it's unagreed is what it is?
Yes, sir.
Okay. 24 CR 481 is now called the state of Texas versus Gary Aiden Bass. That's you?
Yes, sir.
Sir. And you were here with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
Yes, sir.
Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion to revoke unadjudicated probation filed on September 24th of 2024 alleges that on June 3rd of 2024, that you were placed on 10 years deferred or unadjudicated probation in this court for harassment of a public servant, a third-degree felony. Is all of that true?
Yes, sir.
One, states you failed to report to the Jefferson County Probation Office on June 3rd, 2024 in violation of condition 4 of your deferred order. And that deferred order and states report is directed by your probation officer and obey all rules and regulations of the Jefferson County Community Service, Community Supervision Office, Probation Office. So is that allegation true or untrue?
It's true.
Are you pleading true voluntarily and because it is true?
It's true.
Do you understand that a voluntary and knowing plea of true to one or more violations of probation, that's enough to grant the motion to revoke probation? Your probation can now be revoked. You can be found guilty and sentenced to the full range of punishment, which is no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. There are some other violations of probation that the court is interested in. Community service hours. Number 3, it states you failed to provide verification of performing community service hours as required. And is that true or untrue?
It's true.
Are you pleading true to that voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
You understand what the consequences are by a plea of truth. We talked about that before. You failed to enroll, number 5, you failed to enroll in services at Spindletop Center and follow the recommended treatment plan in violation of probation condition 36 of your order. Is that true?
Yes, sir.
Are you pleading true to that voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
Why is that? Why did you fail to enroll in the services at Spindletop?
Because I was trying to get back to Harris County. Jasper County came and picked me up from Jasper County, took me to Beaumont to give me a psych evaluation. I didn't want to. I'm out of Harris County, at Harrison. And so I was trying to get back to Harris County. So they were talking about, hang on. The nurse was talking about, hang on, let me get the doctor and talk to him about it. So when I took the IV out of my arm, I was walking to the exit, and they told me to please, don't move.
Yes, sir.
We're gonna get you help.
Okay.
When I told them no, you know what I'm saying? So they said, we're gonna call security. And so the security
That's what happened.
strapped me down to a psych chair. Hands, feet, arms, you know what I'm saying?
Yeah.
So I'm strapped down to a psych chair, but I have methamphetamines inside my system. I was freaking out.
Okay.
So I turned over and spit on the security guard. So I was paranoid. I didn't know what was going on.
Okay, 6. Number 6 states you committed the offense of evading arrest with a motor vehicle out of Harris County, Texas on or about September 7th, 24. 7 states on that date in Harris County, Texas, you committed the offense of unauthorized use of a motor vehicle. And also number 8 in the motion to revoke probation states you failed to remain in Jefferson County, Texas on or about September 7th, 2024, where you were required without the permission of the Jefferson County Probation Office. And 9, you were at a location other than your residence at approximately 11:40 p.m., which was beyond your curfew. All of those 4 allegations are in violation of your probation order, 6, 7, 8, and 9. Is that true or untrue?
Right. John, I'm gonna abandon count 6.
Okay.
Harris County has only found the other amount.
7. What about the unauthorized use of a motor vehicle? Was that true?
Me and my homeboy was in the car, but I was in the passenger seat. He was driving.
He's already been found guilty in Harris County on this charge, Judge.
By a trial?
It's, I believe it was a plea.
Is that right?
Did you enter a plea? Guilty on January 8th.
They gave me PO bond to sign. I signed for a PO bond, a pre-release.
No, that's not what we're talking about. Did you enter a plea of guilty in Harris County to that charge?
He said yes.
Yeah.
Yes, sir.
And what was the disposition?
Nothing.
Just a copy of the judgment from that judge.
No, this states you were found guilty. It was reduced to it under 12.44 of the Texas Penal Code to a state jail felony. You got 1 year. It was a state jail felony reduced to time under county, and you received 1 year in the county jail.
Yes, sir.
Well, you didn't remember doing that? You said told me just then you didn't. You got this. This was a disposition back on January. So all of that is true.
Yes, sir.
Okay. All right. So then number 7 is true. You've committed the offense of unauthorized use of a motor vehicle in Harris County that you ended up pleading guilty to.
Yep.
Correct?
Yes, sir.
Are you pleading true voluntarily and because it is true?
Yes, sir.
And the same thing, you understand, 1 or more violations of probation, that's enough to grant the motion to revoke probation. Your probation can be revoked and you can be sentenced up to the full range of punishment. And then finally, 8 states on September 7th, 2024, you failed to remain in Jefferson County, Texas, as you were arrested in Harris County, Texas, without the permission of the Jefferson County Probation Office that you had to have to leave Jefferson County, Texas. Is that true?
Is that true or not true?
So we picture a question.
Yeah, this states you failed to remain in Jefferson County, Texas, that was required of you in your order of probation by being in Harris County, Texas on September 7th, 2024, without the permission of the Jefferson County Probation Office. I guess that's when you were arrested for unauthorized use of a motor vehicle that you pleaded true to. Is that true too?
Yes, sir.
Okay. So are you pleading true then again to allegations 1, 3, 5, 7, and 8 voluntarily, knowingly, intelligently of this motion to revoke unadjudicated probation and understanding that the court could revoke your probation and your probation, you could be found guilty and sentenced up to the full range of punishment for this 3rd-degree felony, no less than 2, no more than 10 years confinement in prison. Knowing all of that, do you insist on pleading true to these allegations 1, 3, 5, 7, and 8 of the motion to revoke probation?
Yes, sir.
I find you are pleading true to those allegations voluntarily, knowingly, intelligently, and because those are true. All right. Is there an agreement here? No. What says the defense?
Your Honor, we're gonna ask that you continue him on supervision. And I was going to allow my client, he did admit to those allegations as you named, the 1, 3, 5, 7, and 8. However, we have compelling reasons as to why we're asking you to keep going supervision. All right, so Mr. Bass, all right. In this particular case, you heard the court ask that we have any kind of plea agreement, right? And the state had offered you 3 years in the institutional division as an offer on this case. And you remember signing this rejection saying you didn't want to take that offer and you signed your name on it, right? So when you signed that rejection, when you signed that rejection, you wanted to go open to our judge so he could make the decision, right?
Yes.
All right. So to give him a reason and good reasons as to why he might want to keep you on supervision, let's talk about some things. One of the things that was emailed to me in this case was your psychological evaluation. Well, it's more than one psychological evaluations.
Yeah.
You have had, I'm sorry, you've had an extensive history of mental illness, is that correct?
Yes, sir.
And with that extensive history of mental illness, and you can tell me specifically about yourself because you know you better than anybody, right?
Yes, sir.
All right. Do you remember, and I think this examination was by a Brent Wortham PhD in 2020, you evaluated in the Texarkana Center Developmental Disabilities Center. Do you remember that?
Yes, sir.
Thank you.
Right. And when you were evaluated there was some issues that the person had came up with you, the doctor had diagnosed you with, and one of those was adaptive behavioral level, and he talks about you having some cognitive issues with your, and I'm gonna be specific, intellectual disability, developmental disorder, where you
IDD.
yeah, IDD. Do you remember that diagnosis?
Yes, sir.
So when it comes to your ability to understand things and comprehend things while you've been on probation, can you tell the judge in your own words what's some of the things that you haven't been able to understand that's been difficult for you? Well, you know, with that diagnosis, have you been having any problems?
Yeah,
Go ahead.
since I was about maybe 15, 16 years old, I was in a group home in Lubbock, Texas. And when I got to Houston, I started falling off. I started going around, going to school, smoking dope, doing drugs, hanging out with the wrong people. And that's what made me go downhill. I'm saying that's what made me go to jail. And that's what made me.
We're gonna talk here from time. Now, let me ask you some questions, so as you bring an issue. But were those choices you made?
Yes, sir, I made them choices because I felt like I was I had the mindset of I felt like I was growing up, but I felt like my mindset of people in my family kept telling me I'm still a kid.
Well, but you knew right from wrong, right?
Yes, sir.
Okay.
And
you were running around with a bad group?
Yeah.
You know, my dad used to tell me, you're going to only be as good as the worst person in the group you run around with. So that's why you want to always deal with people who are better than you. They help you make better choices.
Yes,
by,
sir.
okay.
And I understand that you were given medications, and this is at least as of June of 2023. I think you had the several medications for your mental health issues. Were you able to take those medications while you were on supervision?
Yeah, because I was getting handed to me.
All right. And if judge continues you on supervision, some of those issues that you got with your mental health, would you continue to take those?
Yeah.
All right. And then on top of that, why are you asking judge? I know you said no to the 3-year offer that the state made. I got that. So why are you asking judge to continue you on supervision in your own words? Why?
That I mean, I'm the reason why I'm asking the judge because I know I messed up. I know I put this up, but we can backtrack and fix it. You know what I'm saying? We can't go to the past and you know what I'm saying
Right.
it's the present.
That's right.
I'm trying because since I've been going through a whole life, growing up, family situation, I just wanna just sit down and relax and just chill for a minute and just think what I'm gonna do and do it. Because I wanna work, I wanna get a job, I wanna make some money so I have money in my pocket. You know what I'm saying? I wanna get me a house to live in. I wanna change my whole, you know what I'm saying? I don't wanna go through this no more.
Right. And we have a lady to my, I guess it'll be right, who's here with Spindletop MHMR. If judge continues you on supervision, would you be willing to work with her with Spindletop MHMR?
Yes, sir.
And would you follow appointments to do what you're supposed to do?
Yes, sir.
And would you be a danger to the society or anything like that?
No.
And with your probation officer to my right, would you listen to her and follow instructions?
Yes, sir.
All right. And do y'all have a relationship?
I never.
You don't never seen her?
No.
Okay, all right. So the bottom line is, would you be willing to listen to her and do what she asks you to do?
Yes, sir.
So, you know, you're asking the judge to give you one more shot here.
Yes, sir.
That's it.
Okay. Let's get one thing though. We've talked about mental issues. The defendant is not declared incompetent. He's competent to stand trial. He has not ever been ruled insane.
Right.
Okay. And he was on the mental health caseload while he was on probation here in June of 2024.
He was
but
ordered,
didn't work long during on that probation.
he was ordered, he's never reported. The state saw all those issues at the time in which I made the initial plea agreement with Miss Mantellini. And that was to place him on a mental health caseload because we saw what the issues were. We can't help somebody who won't help himself. The man never reported, never did anything. Instead, he went out and committed new offenses. I haven't heard one thing that tells me he's going to do anything different than what we just did.
What is your recommendation?
Judge, we can't help somebody that won't help himself. So the only recommendation I can make is prison time.
For how long? Yes.
I offered the opportunity for them, as Mr. Adams pointed out multiple times. I gave him an offer of 3 years. He didn't want that. I leave it to the court to the determination as to how much time, but I don't feel safe representing Jefferson County suggesting that we give him another opportunity to commit more offenses.
Mr. Bass, anything you would like to add?
I'm just fed up being in custody.
Yeah, I bet.
I wanna do the right thing and don't come back. I know if I go to a group home, I'm gonna stay in that group home that I'm assigned to. I'm gonna stay in that group home and follow the directions of what they got going on.
Okay. Well, after the group home though is completed, what are you gonna do?
Try to give me a job, get on my feet.
Well, we understand that we gave you this chance. You were charged with third-degree felony harassment of a public servant. Then you never reported, and you admitted to committed another offense of unauthorized use of a motor vehicle in Harris County. What did they? Is that just pending in Harris County?
No, Judge, they resolved both those cases with the judgment I showed, Your Honor.
Okay. And
they dismissed that evading and gave him some jail time on the
unauthorized use.
Yes, sir.
And then you
to be specific,
trouble in Harris County because you didn't obey the orders here, and you've admitted to 1, 2, 3, 4, 5 separate violations, including one new crime, and failing to even report one time to the probation office, which we can't help you when you don't show up for work. You know, you're going to get fired. That's what happens. All right, if nothing further, here's what the court's going to do. The court's going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation to grant it by preponderance of the evidence or greater, as allegations 1, 3, 5, 7, and 8 in this motion to revoke unadjudicated probation have been proven true by preponderance of the evidence or greater, as the defendant has voluntarily, knowingly, and intelligently admitted responsibility for committing those violations, including unauthorized use of a motor vehicle, a crime. Thus, the defendant's deferred or unadjudicated probation is hereby revoked. Earlier in this case, the defendant pleaded guilty to harassment of a public servant voluntarily, knowingly, intelligently. There was sufficient evidence supporting his guilty plea from State's Exhibit 1 admitted to find him guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony based upon the allegations in this motion to revoke unadjudicated probation that you have admitted. Your probation is revoked, and you are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 2 years, the minimum. You will be given credit for all time you have served. I have 207 days credit, and that should be well toward satisfying this this time of 1 quarter. That's more than a quarter of 730 days.
Yes, sir.
And you may be being released here pretty shortly, Mr. Bass. You'll be getting credit for all this time. Anything else?
No, thank you, Your Honor.
All right.
We appreciate
That is all. Thank you.
you.
And what are y'all gonna do with the other, thank you, the other cases? Pending, the other matters pending, what are we gonna do with those?
We don't have any other matters. Unless I'm missing something. We have no,
I'm sorry, I was yeah, I was thinking about Krista Bird. Is Don Dusler out today? He's not gonna be here,
He's here this morning.
sir?
He's here this morning. He'll be here in the morning on that one and call him back.
Judge Sam Hodges was reset.
Sam Hodges was reset, I didn't
Yes,
have
sir.
that. Okay, Ja'Cory Grant. David,
Yes, sir.
and then John is working on Krista Bruton. Correct, I think he's on Ja'Cory Grant.
I think we're gonna have hearing on him.
All right, Ja'Cory Grant, please, thanks. Here's. Looks like there's a motion to revoke probation pending in one case. And then, yes, among other things. Number one is illegal possession of a controlled substance on April 16th, which is coinciding with the new indictment. Come on up, sir. You're Corey Grant. Come forward. Yeah. And Mr. Grove is your attorney. You've got two cases here that we're working on. Number one is the cause number 23-41455, a second amended motion to revoke probation filed April 21st of this year. And an indictment handed up last year, August 28th of 2024 in 24 CR 1811, alleging state jail felony of illegal possession of a controlled substance, namely methamphetamine. And the second amended motion to revoke probation in 41455 begins with the allegation that on April 3rd, 2023, in this court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation for 10 years for engaging in organized criminal activity, a second degree felony. And then allegation number one alleges you committed the offense of illegal possession of a controlled substance that's recognized in 24 CR 1811, the new indictment. Two, illegally possessing methamphetamine.
I think that's the same date, Judge.
Yeah, it is. Four, failing to provide verification of entering and successfully completing moral reclamation therapy. Five, committing the offense of failure to ID on or about March 8th, 2025 in Jefferson County, Texas. Six, failing to report to the probation office for the months of December 2024 and January, February, and March of 2025 in violation of your probation order. Seven, illegally possessing drug, namely tetrahydrocannabinol on or about May 8th, 2025. Eight, being at a location other than your residence at approximately 1:10 a.m. in violation of your curfew order in your probation order on or about March 8th of 2025. We're not going to talk about the money. So do you understand what you're charged with here in these two matters, sir? Do you understand what you're charged with in these two matters? Okay. Raise your right hand and solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. I'll lower your hand. This second amended motion to revoke probation, does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
In summary, once again, Mr. Grant, and you were Ja'Cory L. Grant.
Yes, sir.
This motion states that on April 3rd, 2023, In this court, you were sentenced to 10 years in prison, probated for 10 years for the second-degree felony of engaging in organized criminal activity. Is that true? All right. Number one states you committed the offense of illegal possession of a controlled substance on or about April 16th, 2024 in Jefferson County, Texas, in violation of your probation order, and that was namely methamphetamine. That is also what is recognized as the allegation in this new indictment of August of 2024 in 24 CR 1811, charging you with the state jail felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you're charged with in this, sir?
Yes, sir.
Is this allegation true or untrue? True. Are you pleading true to it voluntarily and because it is true as it is alleged?
Yes.
Do you understand, sir, that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation, in this case, could be revoked. You could then be found guilty and sentenced to the full range of the second-degree felony, which is no less than 2 nor more than 20 years confinement in prison. Knowing that, your probation can be revoked. You were placed on regular probation. You were found guilty already on April 3rd, and we suspended the term of probation of 10 years and placed you on regular probation. What can be done is your probation can be now revoked, and you could be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes,
nonetheless, to allegation 1. I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true to this. Is there an agreement?
No, sir.
Okay. All right. Go ahead, then, Mr. Grove, on behalf of Mr. Grant.
Is that the only ground the count?
That's all we're gonna go on.
Okay.
This new indictment, yeah. I think that's all that's necessary, right? Yes, sir. Go ahead.
Okay. You are the court grant, right?
Yes, sir.
And you're under oath, you understand that. You were arrested by the Beaumont Police on April the 16th, 2024 in Jefferson County, Texas, weren't you?
Yes, sir.
Okay. And why were you arrested?
Legal positions.
All right. Were you there with some other people?
Yes, sir.
Who else were you there with?
With my girlfriend and friend.
All right. And then the police stopped you to search you. Is that right?
They was running my name to make sure I had no warrants, but they was there for another guy that I was there with.
Okay. They weren't there looking at you. They were there looking at this other guy, but you were there too. So they had you under supervision and they were watching you, right? Okay. And then what happened?
They came, asked for our names, run our names, and that's what we never. Then that's when I realized I had to do my petition.
Okay, what drug did you have in your possession?
It was
methamphetamine. Okay. And then what happened?
I tried to get rid of it, but then it found people to lie.
Okay, you tried to dump it on the ground and the police found it there. Did they ask you about it?
Oh, he just picked it up. After they realized, well, he said they seen me on camera tossing it. So after he picked it up, he had a couple, so I was arrested.
Good. And then did you have some other warrants too?
Right that day.
No, what day?
I got arrested.
Okay. And how long? That was back on April 16th, 2024. And how long have you been in jail? The entire time?
Oh, no, I was in a 3-day station.
You got out after 3 days? How long have you been in jail since then? after you got rearrested? Best guess.
I've got the numbers. Do you want to know for the record?
Yes, sir.
He's being credited with 167 days on the motion to revoke probation and 88 on the new case.
Okay. And the judge's records show you were in there 168 days on the motion to revoke probation case. Does that sound accurate? Now that, as you know, the judge has the right to revoke your probation if he chooses to do so. If it sends you to prison for the maximum term of your probation. What would you ask the judge to do in punishing you for possession of this methamphetamine?
Like, I would like to give me status conceive of probation. Well, I would want to seek the time like for a position short, hold my probation case, do the time for a position and get out to conceive my probation, TDC for short. Probation.
And let me see if I understand what you're saying. You'd like to be convicted and given a conviction for the state jail amount of methamphetamine possession. And after you serve the time on that, you would like to be reinstated back on this probation that Judge Stevens is having this hearing on today. That's what you're saying?
Yes, sir.
Okay. And why do you want to be reinstated on probation for the engaging in organized criminal activity that went before the court on today?
So I would like to start to completely be home with my baby mama, to take care of my kids, and I don't want to go to prison because it's not for me.
Okay. The judge gave you some additional conditions of probation. Will you follow those?
Yes, sir.
Anything else you'd like to tell the judge about why he ought to consider going with your requested keeping you on probation in the case you're currently on probation on engaging in organized criminal activity?
Yes, sir. Because I made a mistake having possession of the drug, knowing that I violated my term. I'm not supposed to have it. I'm not asking for second chance, but I'm asking for help. So I had it to smoke during the time I was going through. But I can't make my payments that I owe up to, and I would like to finish my classes.
And that was a ground that was not before the court on this motion to revoke probation, but you have a considerable arrearage in your case. Is that correct?
Yes, sir.
And you'd like to be able to pay that?
Yes, sir.
Anything else?
Sir.
State.
Your Honor, state asked you to revoke him in this case and sentence him to 8 years TDC. Believes he possessed methamphetamine again after being given a chance on probation. That's exactly the kind of things that lead to the engaging in organized criminal activity, getting on these drugs, going, stealing things. That's exactly what he's getting back to doing the drugs while he's on probation, not showing up, not reporting, and then also, again, failing to ID when he was actually pulled over by an officer there. So it's continued on all the way through a second amended motion to revoke. And I believe he has been given a chance. He failed at that, and state's asking for 8 years TDC.
Anything else?
Just very briefly, Judge, I would point out to the court that the amount of methamphetamine involved in the new case was a state jail amount. I don't know the exact weight, but it would have been less than a gram. And in addition, failure to ID, by the defendant was on another date and we didn't address that or weren't given the opportunity to address that. And I'm not sure it would change the court's ruling on that. But when Mr. Boyd brought that up, we didn't get a chance to object that. Now, there would be some things that we would say about that. So I object to that being considered by the court. Because
It won't be. And the amount of drugs weighed with 1.3 grams. According to the probable cause affidavit.
Would you like to tell the judge something?
On the days I missed my reports, they were doing my one time. That's what I spoke to.
I'm not going to consider it.
I spoke to her about it.
Yeah, almost like considered. Against you. How can you report when you're in custody? Why? That's impossible. All right, this state is asking for 8 years in prison, and the defense is asking for continued probation. From probation office, anything you would like to add, ma'am?
This may be a first, Your Honor, but I actually think that Mr. Grant should be continued on probation. Prior to this incident, he was actually doing really well. He had not failed to report. He's on the high medium risk caseload. That's my caseload. He was going to MRT. He was working. He was making payments. He had worked some community service. And so I do think that Mr. Grant can be successful. I think that if we're looking for some form of punishment in this regard, cognitive track of ISF may be appropriate recommendation. But I believe that Mr. Grant can be successful if he's getting the opportunities.
So what is it that he needs? What is it that we can do that is different from what we're doing up to now to prevent further?
I think the cognitive track of ISF is a 90-day program, as you know. He would be in custody until he went. He would be there for 90 days. He would come back to my caseload. I would still insist upon him taking and completing MRT. He would have to report more frequently. He would have to do regular check-ins with me. And honestly, I would examine from there to see if there were any additional classes or things that he might need to assist him. But ultimately, his attitude with me, he's been with me since July of 24. His attitude has been good, truly. He has always spoken to me that he wants to do better. And I have seen his effort, whereas in other people on my caseload, it's not always that case. But Mr. Grant genuinely is trying. And I see that.
Okay.
Your Honor, I just noted
happened
that
on this drug case.
that still leaves the new case.
Right. And that
There,
is the
which
issue.
we're not offering a probation on. That. Obviously, you could plead to the court and, but
That is the issue.
Ma'am, what do you mean?
That is the issue, is that obviously he wouldn't be able to go to ISF if he has a pending case. And if we're not considering placing him on probation, that is the ultimate problem. Maybe, he's convicted and he sits the time required and then gets out because he's on a 10-year probation, with engaging in organized criminal activity. So we could continue him on probation, but let him sit the time for the new possession. It can be viewed as upfront time in that regard. Maybe so it can be cemented a little bit stronger in his brain that if he continues this is where he's headed. But ultimately, I think that Mr. Grant is better and can do better.
What do you want? Do you want to get out and move on with your life?
Yes, sir.
And with your family?
Yes, sir.
Or do you want to continue probation?
Stay to continue my life. finished probation. But be home, my family, kids. And also, I had got some help to deal with the drug choice too.
Sir.
I seen I also had got some help, like been speaking with the mental health with my about the drug choice for me not to want to do any drugs while on probation. And they prescribed me on some mental health pills and been helping me with like my anxiety, depression, not doing that. Like,
You're taking mental. Does that have anything to do with competency or insanity in these cases?
Judge, I'm not aware of what he's taking, but I haven't seen anything to indicate that he's incompetent or incoherent. I think that this is probably to treat his drug problem, not to make.
What are we gonna do on the new case? State.
Yeah, our state was offering state jail time, and it has not accepted that.
I understand.
We certainly could do that today, Judge. Under that scenario, I believe it would be conviction as opposed to a probation or suppose.
He's got 167 days credit on the MTRP, which is. And then 88 on the new case. The state jail felony. Which is. But at the end of the day. What is it that the probation supervision can give you that you don't already have? That is the willingness to do the right thing. You know right from wrong. You knew fiddling around with drugs, especially methamphetamine, was going to be catastrophic to you and your family's existence. You know better. Do you? And that's.
Judge,
the others are just. Parts, other non-penal code related non-criminal act violations. So this is the big problem. All right. Anything else? If not, here's what I'm going to do. I'm going to send you back to your family. Okay. On this second amended motion to revoke probation, I'm going to find there is sufficient evidence supporting the granting of it, as allegation 1 has been pleaded to by the defendant voluntarily, knowingly, intelligently. I find that the motion to revoke second amended motion to revoke probation should be granted by a preponderance of the evidence based upon the defendant's violations in number 1. And thus your probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years, which is the minimum. You have 167 days. You may be getting out. That is going to be credited toward your sentence, and that should move a long way toward you getting back to your family. Like you say, you were convicted when we put you on. It's your choice. You know what's right. You know who to fiddle around with, and what is the wrong thing is not in the best interest of your family. And you know the people you run around with will bring you down to the lowest common denominator. You're only as good as the worst person. You've got a family at home. You've got to act mature and think of that as the role model for the children. So I cut you a break on this. Make the most of it. What are we going to do on this? well, we've got, I'm sorry. What are we gonna do on this, 24 CR 1811, the new indictment? He's got 88. No, yeah, he's got 88 days credit on the new indictment.
Judge, we've been negotiating and we have an offer for Mr. For the defendant to plead guilty to the new case for 8 months.
Is that what you want to do?
Yeah.
All right, write it up. Let's, and
Yes, sir.
this will run concurrently with each other.
Yes, sir.
Okay, write it up. Thank you.
Can I be dismissed, John?
Yes, ma'am. Fine. Thank you so much for all you do at the probation office.
Can I sit him over here? Still where he trust. Sit right here. Chair right here.
Is John working on something in the back? Yeah, okay, on.
What do you think, sir? What you think? I just know it's not.
We now call 24 CR 1811, the state of Texas versus Jacory Grant. That's you. With Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment, sir, alleges that on or about April 16th, 2024 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you were charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
The agreement's reached where you would be pleading guilty, sentenced to 6 months in the state jail to run concurrently with the previous case. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement and find, sir, You are pleading guilty in this state jail felonies case voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt in this case. I am following this agreement. You are hereby sentenced to confinement in the state jail for 6 months. This sentence shall run concurrently with the preceding case that you entered a plea in earlier this afternoon. Do you understand what has happened today, sir?
Yes, sir.
All right, good luck to you, sir.
Thank you.
Do better. What did we do with Kong Pan's case? Yeah, we've only done that. I've got 1, 2, 3, 4, 5.
Every day in the USA, people find themselves in court.
Benjamin H. Bravo and Monica O'Rourke Bravo. It's case number 2024 DM 309. There's no appearance from Benjamin Bravo. Monica O'Rourke Bravo does appear. Docket notes from our last court proceeding was from April the 2nd. Both parents appeared pro se by Zoom. The court noted California had set a trial for apparently this week. A UCC JEA conference was needed. Mother desires Kansas jurisdiction. Father wanted California jurisdiction. Court made no orders other than setting a Zoom status conference for essentially today at 11 o'clock. Court was likely to issue a written order following a UCC JEA conference with the California commissioner. Subsequently, on May 21 of 2025, the court did conduct a Zoom conference with Judge D'Alessandro of the Fresno, California court. A decision was discussed regarding UCC JEA jurisdiction. In other words, who will decide who will exercise child custody jurisdiction. California did not decline jurisdiction. California decided to keep the case for trial out there starting, I think, May 28th, which would be tomorrow. This court would issue a journal entry documenting this. This court did enter an order entitled Journal Entry of Determination of Child Custody Jurisdiction following communication between courts. And that was apparently dated and filed May 21st of 2025. Both parties were notified. Perhaps after receipt of that order, Mr. Bravo felt it wasn't necessary to appear this morning. I wish he would have. However, I think under the circumstances, I understand why he didn't. The real issue before the court right now is what does the court do with this Kansas case? California did not decline jurisdiction. They decided to exercise it at the trial to take place this week. I don't know if there's any real business for this court to conduct. Monica, you're on this meeting. What is your position here?
Thank you, Your Honor. I have two primary questions / concerns. My first question is regarding the judge with whom Your Honor spoke with in California. Judge D'Alessandro has not ever and is not presiding over our case in California. So my question is how it came about that he was the one who conducted the conference and made this determination, because he has not been present at any court proceedings over our case, and he is not presiding over the hearing, the upcoming hearing on that's later this week.
All right, I note your email that was sent to my assistant back on May the 6th, which specifically identified Judge Samuel D'Alessandro of the Family Law Department. This was from you that informed our court that he was the new judge on the case who would hear it. So naturally, he was the one that this court contacted. I first tried to contact Judge Hamilton, who had handled the case previously, got no response. And then eventually, after receiving your email, the court contacted Judge D'Alessandro, who said that he was bringing himself up to speed in the case. He was looking over the case and apparently did some of that prior to our conference. It was my understanding he was going to be the trial judge. I don't know if it's been reassigned to someone else for the actual conducting of the trial. All I know is it was that judge that I conducted the conference with. So,
Your Honor, that email that I sent you was based on incorrect information that was came from the paralegal at my lawyer's or my attorney's office. To speak very colloquially, the Fresno, California court system, especially the family court system, is a quote unquote mess. They move judges continuously. We have had, I think, 8 different judges hear our case over the course of the last, what would it be, 7 years. And what happened was there's benches by department number, and they moved judges to different departments. So we were previously in department, I think it was 303. Judge Hamilton was the judge presiding in that department. A month or a month and a half ago, they moved Judge Hamilton to a different department, to Department 202. Judge D'Alessandro is now presiding over department, I believe it's 303, which was the previous department. And so the paralegal made the assumption that when the judges were moved, that our case would continue to be presided over in the same department. And so then she notified me and said, you need to let the Kansas judge know that this isn't a different department, or this is a different judge that will be presiding. Which is why I sent you that email. When I spoke with my lawyer last week, it was, and then followed up with the actual court clerk. I personally called the court clerk in Fresno last week. The courts in Fresno moved our case with the judge. So we are now in a different department, but retain the same judge, which is Judge Hamilton. It will be Judge Hamilton that is presiding over our case. Judge D'Alessandro, I would assume, stated that he was catching himself up with the case because he's never seen it before. Additionally, he's not the judge that will be presiding over the hearing that's coming up this week.
okay.
So he has not ever and will not have anything to do with our case. He has never heard it. He's never seen any of it.
All right. Certainly, if Judge D'Alessandro felt like that he wasn't the one to talk to, I trust he would have told me that. He did clearly acknowledge that prior orders had been entered, I think, by Judge Hamilton.
Mm-hmm.
But he did know that you had been through mediation. He knew that you were scheduled to go to trial this week, and that the case essentially was imminent as far as a trial date was concerned in California. And he asked specifically how far proceedings had gone here in Kansas. And I said, well, until the jurisdictional issue was settled, they haven't been furthered at all, which is the truth. Mm-hmm. As I understood the applicable law, California first exercised jurisdiction in the case.
Correct.
They were the court of initial child custody jurisdiction. One of the parties still lives there. Therefore, it would appear under our statutory law that we needed to confer. California needed to make certain findings to send it back to Kansas. That we were the more appropriate forum, for example, that we were the more convenient forum. Those findings were not made. From the conversation that we had, that's what I based my order on to document in my file that I'd had the conference and that California did not essentially relinquish jurisdiction to Kansas, though I think he certainly considered it. He eventually declined to do so, that it was that court's decision ultimately, not this one's. So rather than set up a situation where you're doing two trials with potentially conflicting orders, I think the laws of the two states are intended to make sure that there's some harmony and some agreement about who's going to exercise jurisdiction, and it appears that California is going to at this point. So one option the court has is simply dismiss this case without prejudice, because I don't know that there's anything right now that the Kansas court can do or will do. But go ahead. I think you're going to make a statement.
I actually I'm just a question. Did Judge Alessandro give a rationale for maintaining jurisdiction? Because I am aware that the California statute requires that children who have not been residents of the state for at least 6 months, and the statute states that children where the predominance of evidence lies is where the jurisdiction should lie. And obviously we have a trial coming up and every single witness is appearing via Zoom from Kansas because all of the evidence regarding the state of the children is here in Kansas. There is no evidence at all in California regarding the state of the children. And so my question is, on what basis did California determine that they should rechange jurisdiction? Was it simply because there was a current pending motion, or was there more than that?
I don't want to speak for Judge D'Alessandro and his mental processes for his ultimate decision, though I don't think there's any question that the fact that you've got a trial date actually set and ready to go, that both sides are prepared, both with attorneys, I think that was probably a factor in the decision, without a doubt. Ultimately, it was that court's decision and therefore that court's rationale. So I don't really want to speak for Judge D'Alessandro, but only speak for the fact that the Kansas court is not going to be exercising child custody jurisdiction at this time.
So then my follow-up question is, moving forward, we do have a trial. I have an attorney. He does not actually have an attorney for the upcoming trial. And upon the conclusion of that trial, there will be an order that will exist. I am asking, the current orders, or the orders that were temporarily put in place, require that the children fly to California extensively, and that has a very significant effect on their well-being and their lives. And so that is the basis of the trial. Additionally, it should be known that the children have expressed vehemently that they will not board a plane. I let them know that starting in June, they were going to be required to fly to California per the current orders, or per the temporary orders. And they did express very clearly to me that short of putting them in handcuffs and having law enforcement take them to the airport, that they would not be traveling to California. Your Honor should know that the oldest is 13, and he is set to testify at this trial as such. Following the determination that the California court makes this week regarding the current orders. And what I am asking California is that visitation continue to be in Kansas so that the children are able to continue to participate in their regular daily lives here in Kansas, and also maintain a relationship with their dad when he chooses to show up. He was ordered to have visitation in Kansas the months of January, February, March, April, and May. He came January, February, and March, and he has refused to visit the children since then. So there is inconsistency in visitation. There's issues here. The court, I understand fully why the California court retained jurisdiction, because there is the upcoming trial. Following the trial, Judge Hamilton will make a determination regarding custody. For better or for worse, it will be what it is. My question is, following that determination, what process, my children are 11 and 13, so we have 7 more years until, of custody issues. And at what point or by what process would it be reasonable for me to bring this case back to Kansas and request another UCCJA to change jurisdiction? I mean, in my mind, I guess what I'm wondering is if it's possible, once orders are made, once a determination is made, can we preemptively set up? It doesn't matter what the orders say. To me, it doesn't matter what the orders say. I would like to preemptively set up as a follow-up UCCJA to see about moving jurisdiction here for the remainder. We're not talking like 6 months, we're talking 7 years more of custody. Regardless of whether something is filed a motion is filed to change the parenting time, that it could be established that when it is deemed necessary to make an adjustment to the parenting time order that is going to currently be made now, where that can happen.
To a certain extent, the answer to your question may depend on what the California court does at this trial. Certainly, if the father is granted primary custody of these kids, I can't see a scenario in which Kansas would assert child custody jurisdiction of kids who are under a custody order and living in the state of California. But there are other alternatives that could come out of this hearing that might allow the Kansas courts at some point in the future to assert jurisdiction. However, I'm not in any position to answer your question. Perhaps that would be better addressed to a Kansas lawyer or to your California lawyer, either before, during, or after your trial. I think certainly that lawyer would need to know what the outcome of the California proceeding truly is.
Right.
But what I'm inclined to do at this point is not to dismiss this case at this time. What I'm inclined to do is to leave it open until August the 29th. We have a target in Kansas that civil cases are supposed to be resolved by 1 year. That will be your 1 year from your filing date in this case. I'm just going to grant a stay of proceedings for a period of about 3 more months. We're not going to schedule any more hearings. There's nothing for Kansas to do. Any assertion, a proper or legitimate assertion of Kansas jurisdiction needs to be made by some sort of new motion, depending on whatever it is, enforcement, modification. I don't know what relief would be properly sought. I'm not going to pre-rule on it, but I'll leave the case open for a period of 3 months. If nothing is filed at the end of that 3-month period, in this case, that would properly ask for assertion of Kansas jurisdiction, the court will dismiss this case without prejudice, which means it could be refiled in the future. But I need to get some sort of eventual end to this case, one way or the other.
So then my question would be, in terms of requesting for a reevaluation of jurisdiction, would the request be made here in Kansas? Would the request be made in California? Do I need to do both?
Better ask to lawyers in those respective states.
I will tell you flat out, they don't know. I have contacted 3 separate lawyers in California, and I've contacted 5 separate lawyers in Kansas, and not a single one could give me any definitive guidance, even after paying them their lawyer fees.
Really?
On
Okay.
how to accomplish a UCCJA jurisdiction change.
Oh, that's interesting.
It was very interesting and actually quite frustrating, which is because I have been trying to get jurisdiction changed since well before he filed the motion. And because I could not ever get a straight answer from any lawyer in any state, in either state, he was able to file this motion he snuck in and filed the motion because he knew I was trying to get it transferred, and I couldn't get any legal help to get it transferred.
Didn't he file his motion in California before you filed your action in Kansas?
I had filed an initial thing, and it was in Sedgwick County, and it was filed incorrectly.
Okay.
I had contacted lawyers here. They didn't know how to do it, and they filed it in Sedgwick County, even though I don't live there, and they filed it incorrectly. And so then when it kicked back, then I had to figure out how to file here. So then I filed here and I filed there. I guess, I mean, it would be very, very surprising. You know, even the temporary orders still state that the children's primary residence is Butler County. So the location of their residence is not actually what is in contention. It would be the location of the visitation, because the current orders still state that their primary residence is still in Kansas.
Well, is that being challenged in California?
No, it's not.
Okay.
He's not challenging their location of residence. He's actually not challenging anything. The orders state that their primary residence is in Kansas, is in Butler County, and that they are to visit their dad in California. And the only thing that is being challenged is the location of the visitation. I am challenging the location for them to be able to, for him to come here to visit them so that they can still do sports, so that they're not missing. Right now, they have them missing 27 days of school a year. I mean, yes, I wish I was kidding. They wrote orders based on a California school calendar, not a Kansas school calendar. It has them missing extensive amounts of school. It has them flying back and forth continually during school. It's just not healthy for them. So the only thing that's being challenged is I'm saying, please follow a Kansas school schedule for visitation, and please have the visitations here so the kids can have jobs and play soccer and have their regular lives. That is the challenge.
Well, it's certainly possible the California court may see it your way. And if so, you'll be comfortable with the California court orders at the end of this trial.
Correct.
That's certainly possible.
Correct. I may or may not want to be making a request for a change in the orders, but I do still want to make a request for jurisdiction to lie here so that when the time comes that the orders need to be revisited as the kids get older and what they're involved in changes and all of that, that this court is the court that then subsequently is the one that hears any further issue.
Look,
So,
you should ask the California court for that ruling, it would seem. That if
okay.
we really want the California court to, at the end of this, relinquish future issues regarding child custody and parenting rights to the state of Kansas, you could ask for the court for that ruling at that point.
So then what I will do is I will prepare an RFO, a request for order, to California for because I did this, but because this motion was already in process, that RFO was denied without prejudice.
Mhm.
She's basically, Judge Hamilton said, see me after the trial.
Mhm.
And also said, maybe you should, I actually already had the motion in process in Kansas as well. So I will now refile an RFO and have this revisited. Because this case is already open, then it is my understanding that I don't need to refile an additional motion here.
No, actually you do.
I do.
Where I'm leaving things is that I'm just going to grant a stay. And if you want to properly and appropriately assert Kansas jurisdiction based on post-trial circumstances, you'll need to file a new motion asking the court to do so. There has to be something that takes place between now and August the 29th where there's a proper request that would warrant the proper exercise of Kansas child custody jurisdiction. And it could be based on a California relinquishment at the end of this trial. If so, that needs to be put in the order that they are going to relinquish jurisdiction to Kansas for future proceedings. That it could be very simple. But
okay.
You will need to do something to prompt reopening, essentially, of this case. It's going to remain open in a technical sense till August 29th. If nothing's filed, we'll review it at that point. If there's nothing filed that would warrant proper jurisdiction of the Kansas courts or bring a new matter before the court that's proper, then the court will just simply dismiss this case. So
Okay.
I think you misled. You are going to have to do something else.
Okay, so I will file motions in both California and Kansas. Judge Hamilton has made it crystal clear that she will not hear anything regarding jurisdiction as part of a custody hearing. She made me even so in the pending custody hearing, I filed all the necessary documentation and declarations to make the request for a change in jurisdiction as part of the current motion, and she refused to hear it and made me file a separate motion for that. Then heard the separate motion and turned around and said, I'm denying this because this other motion still exists. So we will finish with this motion. We'll finish with this motion. Whatever happens, happens. And then I will file both in California and in Kansas a request for a jurisdiction change. Assuming I'm basing that based on the assumption that the children's primary residence remains in Kansas.
Okay. Well, so that once again, just so things are clear, the court will not be entering any orders today other than staying future proceedings in Kansas, leaving the case open until August 29 of 2025 to see if there would be some motion before this court or some new request for relief where we would properly exercise Kansas jurisdiction at that point. So that's where we're going to leave it today. And then we'll see what the outcome is in California. And if you feel that circumstances warrant some request to Kansas to leave this case open even further.
Thank you so much for your
All right.
time. I very
All
much
right.
appreciate it, Your Honor.
All right, very well. Then if there's nothing further at this time, the court will be entering a written order documenting what we've talked about here today. And that will be sent to both parties, obviously. And until then, the court grants a stay until August 29, 2025 for further review by the court to see if the case will stay open. Very well. Then if there's nothing further at this time, we will conclude this Zoom meeting for all participants.
Thank you so much, Your Honor. Have a great week.
Security.
Yes.
Who, if anyone, do you have there with you?
I have Kalik Roberts.
Okay, we'll do that one next.
And Your Honor, that one might take a minute as there are witnesses present. I don't know if there's any of the other ones, are there any faster, but just so you know, that one might take a few more minutes.
Judge, so for the status, it'll be pretty quick, but then the state's filed a motion to revoke his bond, so that's the part that will take a bit.
When was that motion filed?
Your Honor, it was filed
Recently.
May 16.
Right.
I'm sorry, when?
May 16.
Okay. Not sure why we weren't made aware of it or why I don't have a copy of it. Okay.
Judge, do you want me to email you one or?
Yes, please, to my Gmail, please.
Yes, ma'am.
Okay. What about Justin Tyler Wiggins?
Your Honor, he's he was in custody at one point elsewhere.
Mr. Watts, are you representing anyone?
Your Honor, the only person I have this morning, or this afternoon, excuse me, I think is Mr. Wiggins, who is at the Sedgwick County, or excuse me, Johnson County Jail. I don't.
August 18th, at what time? I'm sorry, Mandy.
At 2:30, I'm assuming.
Okay. All right, so we've set that out till we can get a Larned report on him. And now we're back to Roberts, because I think that's the only one that we have left. All right, we're gonna go on the record in state of Kansas versus Kalik Arshad Roberts, 2025 CR 42. Mr. Roberts appears at the Butler County Judicial Center with security. He is on bond with AAA bail bonds, $10,000 surety. Ms. Norris is appearing on behalf of the state, and Mr. Favre is appearing separately from his client by Zoom for preliminary hearing control and a motion to revoke or modify bond. That was in fact scheduled for today. Okay, Mr. Favre, announcement to the court.
Judge, in regards to preliminary hearing, we would just ask that a preliminary hearing be set at this time.
All right. June 25th. I've got 11, 3, or 4.
I think, yeah, Judge, I think that we have Schofield at 2 and 2:30. Is that right, Mandy?
Yes.
Okay, okay.
2 to 3. Mhm.
Let's do 3 then.
Okay.
Yep.
Ms. Norris, does Wednesday, June 25th at 3 o'clock work for you?
That should be fine, Judge.
Okay. Mr. Roberts, if you're still on bond, you need to come to the courthouse just like you have on each occasion. Check in and go up to the second floor, courtroom A, for your hearing.
Yes, ma'am.
I think I'm just gonna schedule, since there are civilian witnesses, until 5, so I won't schedule anything at 4. And that is in person. All right. Now, with regard to the motion to revoke bond, Ms. Norris, will you proffer what you believe has transpired that would warrant his bond being revoked today?
Yes, Your Honor. The defendant had previously been ordered not to have any contact with the victim or the property where she lives, which is an address on Tanglewood in Derby, Kansas. And there is a police report which is referenced, let's see, in the motion 25-07060, wherein it was reported that on April 22nd, the defendant was at that property, did cause damage to a garage door at that property. I believe actually got into the backyard and took a photograph of the victim through a window and sent it to her on the cell phone. This was reported to law enforcement. We have Officer Mason Stotts here from Derby Police Department, who was one of the responding officers. And then we also have Maria and Barbara Oglesby, Maria being the named victim in this case, and Barbara being her mother, whom she lives with at this Tanglewood Road address. And I would note for the court, I did have opportunity to speak to Mr. Favre earlier today, but I guess I would have to do an oral amendment to the motion. I was noticed up that the defendant was at the victim's house earlier this morning, which all of which is against both the contact on 4/22 and today is against the bond conditions that were set forth by this court. And like I said, there's been additional law enforcement contact regarding this victim. So, Your Honor, that is what the state intends to proffer.
Okay, Mr. Favre, have you visited with your client about these allegations, and are you wanting folks to testify and have a hearing?
Judge, briefly, I did. I didn't realize we had a motion to revoke until earlier today. Spoke to Mr. Roberts. After we had a further discussion, he admitted to me that he had indeed been over there. So we are not going to request that people testify. He would stipulate that he has gone over there. His version of this is that he believes that he and Miss Ogilvy are still in some kind of relationship, and that is both their desires, or at least that he thought that was until recently. I think he thinks now that's not the case. And he has said he will stay away. He also believed that he misunderstood the no contact order. He thought it was for a limited amount of time and not during the whole duration of the case. I'll just inform the court, in addition to those things which he told me, that I have had a lot of conversations with his family and with Ms. Norris about this as well. But he has some mental health struggles that he's working on right now, and his family is helping him work on. And I think that's playing a large part in this. But he has had strong family support. I've been able to reach his family to discuss where he's at and his needs right now. So he has no prior felonies. This is just, he's struggling right now with some mental health, and I think he misunderstood. But yes, he would stipulate and that he has had contact.
Okay.
And
Ms. Norris,
I apologize.
so there's an admission that by counsel that his client is stipulating that he had violated the no contact order under the bond. What are your recommendations?
Your Honor, obviously, we have concerns for the party's safety in this particular matter. Like I said, there was some criminal damage that occurred on that April 22nd incident. And Your Honor, it's, like I said, my understanding that there was, again, some contact this morning after or during which there were concerns about safety based on kind of the behavior of the defendant while he was present and right before he arrived. Your Honor, I don't really know what he's doing for his mental health. But if that is something that he is struggling with, obviously we would like for him to address it. But at this juncture, Your Honor, this is at least 2 times, and this is since the last court date, which was March 17th. Your Honor, I stay be requesting that the court revoke defendant's bond and that he be held, or that the court revoke his bond and that the court set a significantly higher bond for purposes of public safety and the safety of the parties. But at minimum, Your Honor, I would request that he have a GPS unit and a fairly significant exclusion zone. I don't believe that he lives in Derby. I don't think he should be in Derby, period. Certainly not on that street near that house before something even worse happens to the parties. So obviously, definitely some concerns about safety. So I would request that the court revoke and set a new bond, and that the court set GPS as a mandated requirement. Obviously, if the defendant can make that, then, again, he can, well, and even if he's in jail, he needs to stay away, and no contact means no contact. No Insta, no Snap, no text, no calling, no drive-bys, no nothing. I'm not sure how the court can make it more clear.
Well, I wish that when he had his first appearance, we would have put him on GPS then, but at any rate, can you explain to me since we haven't had a preliminary hearing, the nature of the relationship between these two parties, if any?
Your Honor, it's my understanding that until this incident, they had been in a Maria Oglesby and Kalik Roberts, the defendant, were in a dating relationship. They were boyfriend, girlfriend.
Okay, but these charges weren't charged as domestic violence related charges.
Your Honor, I think that it was maybe just overlooked that there is no DV tag on any of the charges. I would actually at this juncture move to have the tag attached on counts 1, 2, 3. Because Maria Oglesby is or was his girlfriend. They had been in a dating relationship and actually were in a dating relationship at that time when this is alleged to have occurred January 31st.
Okay. Who was at or working in the nursing home when it had to be evacuated? Where was that?
She was, Judge. Miss Oglesby was.
She was living in a nursing home or she was
No.
working?
Working.
Okay. And is that where the two of them met?
I don't believe so, Your Honor.
Okay.
I'm not sure. I know where they met. I just she was working at a nursing home at the time of the alleged offense. That was her employment.
Mr. Roberts, how old are you?
I'm 23 as of the 14th.
Ms. Norris, does he have any prior record as a juvenile or an adult?
Your Honor, he has a suspended driver's license according to when we ran his DL a few months ago. For the most part, though, no, he just has some traffic.
Mr. Roberts, where do you live?
901 West Davis Drive. It's off the intersection of 47th and Seneca in Wichita, Kansas.
How long have you lived there?
Say about 4 or 5 years.
Is that with family or by yourself?
With my mother, actually.
Okay. Are you working?
Textile and aviation, actually, yes, ma'am.
How long have you been there?
I want to say it's about a month and a half, 2 months now.
What is your mental health history? Have you taken medications?
Yeah, I've been admitted in St. Joseph once because I've tried to commit suicide. I've been on antidepressants. That's really about it.
Where have you went past to get prescriptions and help? ComCare?
Yes, ComCare, and then there was another one. I do not remember what it's called. I was about like 11 years old, so it's been a while.
Were you in the juvenile court system for child in need of care?
No.
Okay. How long?
Judge, I
Yes.
apologize. I was going to say, my impression speaking to Mr. Roberts and his family is that they are a very coherent family. Like I've never had a problem getting a hold of brother, sister. And he, as he said, he lives with mother. He has this brand new job at Textron. So he has a good support network, which I know that like not everybody that comes in here does. But this mental health incident that he had that started this case, it's kind of different than what he's had in the past. So they're kind of still working on what they're doing with it. But also because he's trying to maintain this brand new job, it's just been slow going. And it's a very good job. He's only a month and a half in. So Anyway, I've spoken to him about addressing this mental health, but I just want to bring that to the court's attention because part of what we're trying to advocate for is that he be allowed to maintain this job with an ankle monitor and a modification of bond. And just to inform the court that he does have the kind of support network that not everybody has. So we just kind of want to put that out there.
All right, Mr. Roberts, what Textron plant do you work at?
I don't know the exact address, but it is on the west side, I believe, off of Maze Road. I haven't got set in there yet. I'm still in training. That's off of Greenwich. I don't know the address of that one as well, but they just told me where I was located.
How did you meet Ms. Oglesby?
Just via text, and then we just met up at just a random spot that we used to know.
What?
Via text, and we also met up at a spot that we used to know, like we used to hang out at together.
Okay. Well, what do you not understand about serious felony charges and being ordered to have no contact with someone and not to be on their property?
I do understand, Judge. I apologize. I feel as if I love her, so she reached out and I answered. So it wasn't the best decision, but that's where I was at with it.
Well, it's alleged that you've threatened her, so those aren't acts of and damaged property, motor vehicle. Those aren't acts of love or kindness. I know they're allegations, but it's a simple no contact order until you can get to trial.
Yes, ma'am. And that's also, as Joseph said, I kind of just thought it was up until the 17th and like that court day, and then it was over. Like, so I had misunderstood what the jail had given me.
Well, how is it that you went a couple of months with no contact or no issues? And there were a couple months before that, and then all of a sudden, you're showing up at her house and taking a picture of her and going into her backyard and doing stuff like that.
So
what triggered that incident?
It's just more, I was never in the backyard, but there's arguments, I mean, just off and on about just stuff like respect and things like that, and it just adds up, builds up, and then it just kind of like goes overboard. And like we argue like any other normal couple, but
Well, you shouldn't be arguing because you shouldn't be having any contact.
Yes, ma'am.
At all.
Yes, ma'am. And as I said, it's more of a passion kind of thing, and I understand that that's no excuse and it's no any kind of viable answer.
Ms. Oglesby, do you have anything that you would like to add or say?
He's done a lot of damage at both his mother's house and mine.
And Miss Oglesby, can you identify yourself for
I'm
the
sorry.
Thanks.
Barb Oglesby. I like to dispute with Mr. Farr saying that he has a support structure and that his mom is just as afraid of him as I am. And I don't feel comfortable saying a lot more in front of him.
Okay.
As well as my daughter.
All right.
Was
And
the
Miss
court
Oglesby,
addressing the
Maria's
mother or the-
on here as
Yeah.
well, is she not?
Right.
I'm sorry.
And Maria is?
Maria is his ex-girlfriend. Barbara is Maria's mother.
Okay.
Barbara's not the alleged victim, it's Maria that is.
I apologize. Maria is on with the phone number.
Thank you.
Well, I tell you what, I really hate to do this with you having a new job. But I don't know what else to do than to revoke your bond until we have a prelim and I see what the evidence is and figure out what appropriate bond should be set for you, because my fear is between now and then your emotions are gonna overcome you and you're gonna show up at the house. So yeah. I don't know, with felony charges pending and the possibility of a conviction and you'd have, and an ankle bracelet you'd have to be wearing, that you're gonna make it through orientation or probation anyway. I'm gonna revoke your bond in order that you be placed into custody as a sanction for revoking the bond. I'm going to keep you in custody until your preliminary hearing. I'm going to ask that the jail do a mental health assessment on you. And then depending on the outcome of that hearing, your bond will either be reinstated or you'll remain in custody. I will be adding a GPS or an ankle monitor if I reinstate your bond as a condition. But frankly, counsel, I'm not really interested in finding a violation, revoking a bond, and then just setting a really high bond that he can't make, or he has to jump through hoops or figure out how to get someone to give him some money. I'm more interested in ensuring that he doesn't violate the conditions of the bond than how much the bond is. And so frankly, I had to make a decision of whether or not I felt that GPS was enough or not. Because that's the only thing, to me, those were the two choices. Let him remain on bond and add an ankle bracelet, or revoke his bond. And my decision at this point is to revoke his bond. Mr. Fabre, do you want to hear from Maria at all with regard to?
I kind of would like to hear a little bit of that perspective. I know Miss Ogilvy's the mother has a perspective, but I wouldn't mind hearing from the daughter as well.
All right, Maria, if you could join us, please.
We ask her to unmute, maybe like from our end, if she can't do that on her end. There we go.
Hi, sorry.
Can you possibly turn your camera on?
I called the phone number, so it's on the phone. It's not like a FaceTime thing.
She's dialing in, Judge.
Maria, can you identify yourself for the court?
Maria Oglesby.
And is there anything that you want to tell the court about what we've been talking about? You've been listening in?
Yeah, I have been. I don't really want to say too much except for my initial reason I called is because I know Khalik has past mental health issues. That's something we've actually bonded over and helped each other out with. But I initially called and quote unquote got all this started because I wanted him to get admitted to the hospital and get help. And I asked the Rose Hill Police Department when they got to my job and asked me questions, if there was any way that we could take him to the hospital or get him help or anything, because this is exactly what I wanted to avoid. I initially just wanted to get him help and that be the end of that, and him just go on his way and be good and okay.
Thank you.
Thank you.
So I just want to clarify one thing if I could. I don't need to go on the record or anything officially, but he had said that you had contacted him. Is that right? Did you contact him when he was on bond?
I did. I took the initiative of contacting him. He did not do that on his own.
Okay. And I think, Judge, I've spoken a little bit, Miss Oglesby. She contacted me, spoken to his family. I know Mother's had some thoughts about, you know, his lack of support. I don't know. I can only tell what I've been told by his family. But the consistent story from Miss Oglesby and from everybody has been this struggle of mental health. And anyway, so I think what he's saying is accurate. That's all.
Okay. Well, I'm sure he is struggling, but I can't let something terrible happen. And Barbara get hurt in the crossfire of all of this because she's trying to protect her daughter. You know what? If he hadn't gone today, that'd be different. If he had gone all this time and never had any contact and just had that one incident that I felt comfortable that I could put him on GPS and order him to do some things and he would be able to do them on his own, that would be one thing. But the additional events that occurred today, plus she's the victim in the cases, from the end of January, I'm going to implement my previous order, which is for him to be taken into custody and held without bond till preliminary hearing. It's important that everyone be present during the preliminary hearing so I can hear the evidence and evaluate the case. There is a substantial chance that he may, depending on his demeanor, whether or not he got an assessment in the jail, whether or not he's got somebody lined up that he can be going to therapy with, whether or not he can return to his job, whether or not he can afford GPS. Those things, if put together in a submitted plan to me, might create a situation where I may release him and reinstate his bond with additional conditions, but not today, not today. Also, just so I don't forget, an additional order in his case is to not be in the Derby city limits. All right. All right, we will see you for your preliminary hearing and take up this matter at that time on the 25th of June. We are adjourned. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Every day in the USA, people find themselves in court.
Maria Chavez.
That's. I'm sorry.
We'll reset it once we.
Okay.
Being sentenced in the feds today.
Okay. All right. Thank you. Traylon Martin, Mr. Parker.
He's refusing to sign. Traylon Martin. The rejection.
He is going to
He
sign.
refused to sign.
He
the
did.
rejection.
Okay. We'll just go through. Can I get a rejection? One of the printed ones, please, ma'am.
He wants to hire somebody.
Good morning, sir.
Good morning.
Are you Traylon Martin?
Yes, ma'am.
And Mr. Martin, in cause number 25 DCCR 0270, you're charged with the third-degree felony offense of obstruction or retaliation from January 29th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And what is the offer that's been made?
2 years TDC judge.
And so the state has offered, if you want to enter a plea of guilty, a 2-year term in prison, which is the minimum. You have every right to reject that and have your case set for trial. But I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial, or do you want to take that offer?
Can I ask one simple question?
Sure.
I'm just trying to ask, I watched the video,
Uh-huh.
how the case started, and I was the one that was physically assaulted.
So that's what a jury's for. If you don't think you're guilty of what they're said, that
I mean,
then
I can't assault you if I'm already detained.
I don't need to know that. That's what a jury's for.
Yes.
Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
So,
And just for the record, I've explained this to him. I've shown him several different videos. Some of them are more relevant than others, and he indicates some things that there may be other videos out there that I don't know about. They're not there as far as discovery. He's indicated he wanted to hire Marsha Norman, and I told him you can reject it. If you're not guilty, then don't plead guilty and reject it, and if you can still hire Marsha in the meantime.
Mr. Nichols, is there any other discovery that you anticipate?
I didn't see any in the file from Ms. Volpino, anything else, Your Honor.
Okay.
I know she made the offer. I know that he had got a reduction on the same charge a year ago, so I don't see any reason the offer would change. They did ask for probation this morning. I did not change Ms. Volpino's offer.
Okay. So, Mr. Martin, if you don't want to accept that offer and you want it to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
Yes, ma'am. I just want to ask, I've been trying to get a job and work to see if I can just see if it'll help me out with my time as a trustee.
Okay, none of that matters right now, okay? Because here's what we're not gonna do. We're not gonna put your case on the trial docket so that you think you can get some time under your belt, and then you're gonna plead guilty later, because after today, I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time. Either you did it or you didn't do it, and if you didn't do it, then you can sign that and we'll get a jury to decide, but I don't want you to think you're gonna come back in here later and say, oh, I wanna take that deal, because it's not gonna happen. All right?
Am I eligible for parole?
I don't know when you're eligible for parole. I don't know how much time you have.
I never had to do this. That's why I'm asking
I know, and that's why Mr. Parker's, nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not us. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on.
I've explained to him how much time, based on what he's told me he has, and how much time I think he'll have to do before he's eligible. But again, I told him I can't guarantee that. But if you're not guilty, then don't sign. You please reject.
So it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial, or you plead guilty and.
I'm gonna go ahead on the sign.
Sign what?
I'm not guilty.
You can't say you're not guilty and then sign for time. It doesn't work that way. Because what happens, for obstruction, it's not assault on an officer. It's obstruction or retaliation, which is different, and there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it,
I want to go to trial.
okay, sign that for me, rejecting that plea offer then.
Okay, where?
Look, sir, pay attention, sign that.
Okay, where the at? Right there, just between right there. Okay. I got a hospital building. I got evidence of free world.
So real quick, hold on, before you go back, Mr. Parker has been appointed to represent you. With your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so I'm gonna appoint a new attorney today. They'll be out to see you very soon. Huh?
Can I pick one or y'all?
No, you're gonna get whoever's next on our list. If you have whoever's next on the list.
Hire whoever you want.
You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready, okay?
Yes, ma'am.
All right, you can go back with the bailiff. They let them wear rings. They let them wear rings in jail. They let them wear rings in jail. I just feel like that would be, if you hit somebody, that would be a whole issue. A ring, like a big old gold ring. That confuses me. That makes no sense to me at all. Mr. Wilkerson on Rebecca Rideau.
Good morning, Mom.
Good morning, how are you?
I'm doing well.
Like a big old gold ring.
Yeah, go to the.
That confuses me. That makes no sense to me at all. Mr. Wilkerson on Rebecca Rideau.
Good morning, Mom.
Good morning, how are you?
I'm doing well. I'm working on the paperwork right now.
Oh, all right, hang on just a second. I will recall it when all of that's taken care of. Thank you. Mr. Burbank on Chase Bro.
Yes, Your Honor. We're out the side.
Oh, did,
He's there somewhere, we're side up.
okay, I'll hold it till the paperwork comes.
No, it's.
I'm sorry, I just had to send it, send it to the next one.
Good morning.
We got an old pen. I know, right, but I got a pen. He's just not using it.
So is that Chase Bro?
No.
Chase Bro?
He just was here fingerprinting.
Okay. I'm sorry,
Chase, would you sign one more thing for him, please? Sure, I will. This is Mr. Brewer.
Good morning, sir. You're Chase Bro?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Bro, in cause number 22-40132, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 17th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And why is there a difference between the rejection and what we've got today?
Your Honor, this is a case that, in all honesty, we shouldn't, I am of the opinion that we shouldn't be using or wasting a jury on unauthorized use of a motor vehicle case. The defendant's taking responsibility, given his criminal history, I think 180 days is sufficient. I'd much rather focus on the rapes, robberies, and murders than try a human being case.
I don't disagree. I just think we need to do that when we do those rejections. All right. So do you understand if I follow the agreement that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I'm required to ask everyone that.
I think I'm ready.
State tenders number 1.
No.
It's admitted. Is there any evidence that Mr. Bro is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Burbank. All right, good luck to you, sir. Thank you, Mr. Coleman. Thank you, Mr. Burbank. And then you've got Augustus Simon, Mr. Burbank.
He's signing up right now.
Okay, I'll hold that till it's ready. And we're resetting Mr. Harris.
Yes, he's present, and I agree. One more resetting, Judge, to see if we can get him to Harris County.
Oh, this is that one?
He's got a capital murder.
I know, but I said last time we weren't gonna wait.
It's Ashley's case.
Did Ashley leave a note? Because we've been,
She did, Judge. She messaged me over the weekend, and I'll relay that.
I mean, either they're gonna come get them or they're not, and this has been months. Okay, hold on. They issued a bench warrant last week.
Right, it was more of just getting them to do it, Judge, with that. They finally did it, but it was only last week.
Okay. All right, so it sounds like there's a new bench warrant last
sir.
week, so
Yes,
maybe
sir.
they'll actually come get them.
That's the intent, I hope.
Okay. Who's this?
Simon.
Okay. I don't have his paperwork yet. All right. How many are y'all doing on Rito?
So we're doing 4 unagreed pleas and 1 rejection.
So the rejection, what's the? I mean, so that means y'all go, I mean, there's already been a rejection. They're set for trial, so
Yeah, so basically.
I'll call y'all back up in just a second when I get the paperwork. Okay,
The state's prepared for trial, Judge.
okay.
And so basically, she's willing to plead guilty on the 4 theft offenses. The other offense, I have some misgivings about, but we can only take that up at the appropriate time. So,
Judge, I am of the opinion that if she won't plead to all of the cases, I just soon try, file the motion, I try them all, file a motion to consolidate at least 2 of those cases that came out of the same occurrence. I suspect if we get the resolution that we're wanting out of those 2 cases, it will take care of those other remaining cases.
Well, I mean, I guess there's no reason, can she not plead guilty? Are they just open to the court?
right, those 4 thefts are open to the court. The tampering stems from having clothes that she stole under her clothes when she was searched at the jail. So that's the theory under which the prosecution is seeking. Obviously, I think that creates issues. Anybody who had drugs in their pocket and didn't give them to officers then could likewise be charged. But I also don't believe this.
And they charge them with possession of it in the jail all the time after arrest.
Right, but
Not,
not
I don't know about
tampering
tampering.
with evidence. So
She concealed it, is the state's, position.
That's fine. I don't mind whatever y'all want to do, but I think hold on a second. Because if she pleads guilty to the 4 and I reset it and get a pre-sentence report and do whatever I do, then would that potentially resolve, I guess, depending obviously on what I would do? Because,
I don't think so, Judge.
I mean,
The tampering has a heavier hammer, higher punishment range. And I think given her criminal history, she should be facing that.
okay. I'm just trying to think. I mean, she has every right though to plead guilty, right? But but if you want a jury,
I have to wait. This is not that kind of case where I would refuse to waive my right to a jury trial.
okay,
What's complicating this case is her history, Judge, and I have it here. She's got numerous previous deaths.
oh no, I'm looking at the indictment. But on those, they're all state jails. Is that correct?
That's
Even though, because all the priors were enhanced to state jails.
That's right. And I made an offer earlier on that would have resolved all of this. They rejected it, and we ended up filing a 3rd-degree tampering as a result of that rejection. So the defendant could have avoided being in this situation had she taken responsibility of it.
Okay, so do we want to go ahead and go through with these pleas then? And then it'll get numbered I mean, the cases are falling apart next week. We'll see what happens, but we could try the tampering.
State's ready on the tampering, Judge. I don't know what the court's thoughts are on letting the defendant just plead. Well, I guess that's not what she wants to do. I was thinking maybe just plead guilty to the.
If she wants to plead open to me,
you. Okay, all right.
that's what this looks like, the paperwork that's been done. So let's get the pleas done. And then if it goes to trial on the other one next week, great. If not, it'll probably get sent, these will be sentenced before, and if there's any change in circumstances based on that, then we'll.
And Judge, we're certainly not opposed to a trial before the court.
I'm sorry.
No. Trial before the court.
A bench trial.
Bench trial.
On the tampering?
Yeah.
Well, let's get through these pleas and then y'all can talk about that. And if for some reason, if it's not reached next week, and y'all both agree to a bench trial on that, then we can find time. I wouldn't think that that would be something that took a long time. So we'll, but you'll need to talk to your client about that, obviously.
Yes.
Okay, Miss Rideau. All right, you're Rebecca Rideau?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Give me a minute to get, I'll have to pull that. Ms. Rideau, in cause number 23 DCCR 0928, you're charged with, hold on, let me get to that again. If y'all want to print those other ones, it might be convenient. The next three, 210607 and then 1925. All right, in this case, which is 23 DCCR 0928, you're charged with the state jail felony offense of theft of property with previous convictions from November 21st of 2022. The indictment alleges you were previously convicted of theft September 11th, 2010, September 17th, 2010 in 2 different cases. And then again, October 26th of 2015. And then September 21st of 2021 in 3 cases on that date. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all those prior offenses and convictions true?
Yes, ma'am.
And then in cause number, they printing or do you want me to pull it up? In cause number 23 DCCR 2106, you're also charged with theft of property with previous convictions. The offense date from this one is September 23rd of 2023. It alleges those same prior offenses. And how do you plead to that charge?
Guilty.
And are those prior offense convictions true?
Yes, ma'am.
And did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And actually, that indictment, I said the 23rd day, it has been indicted, it has been amended that the offense date is the 22nd day of September. Does that sound correct? Okay. And then in cause number 23 DCCR 2107, you're also charged with theft of property with previous convictions from October 2nd of 2023. That indictment alleges those same prior offenses. And how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all of those prior convictions true?
Yes, ma'am.
And then finally, in cause number 24 DCCR 1925, you're also charged with the state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges those same prior convictions of theft. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In each of those 4 cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it's my understanding you have no agreement in your case, in any of these 4 cases, and so you're just pleading open to me. Is that correct?
Yes, ma'am.
I want to make sure you understand your cases are set for trial to begin with jury selection next week. You have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me, and is that what you want to do?
Yes, ma'am.
Sorry to interrupt, Judge. The state has filed a motion to accumulate. We will be asking the court to accumulate those cases to the extent the law allows.
Okay, because they're all different offense dates, correct? Or at least,
Some of them are, Judge.
I think they are, nope, they're all different offense dates.
So we will be moving or asking the court to accumulate those sentences.
And have you gone over that with your client?
Yes, Your Honor, she's aware that the state's asking for the charges to be stacked.
I guess part of my issue with this is, let's say I do something that Ms. Rideau doesn't like, and then she has the ability to appeal, and I don't guess there's really an appealable matter, but you never know. I don't want to waste a bunch of time and then us be coming right back here, but
And Judge, I've looked for the path of least resistance to resolve these cases. We are in the situation we're in because it's defended.
no, I don't disagree. Well, we'll get where we'll get. All right, so you understand that I can give you anything from probation up to 24 months, up to 2 years on each of these cases. And I can stack those sentences on top of each other. Do you understand that as well?
Yes, ma'am.
And you want to go forward with these pleas and get the sentencing on these done. Is that correct?
Yes, ma'am.
Okay.
In addition, Your Honor, my client has asked, and I know the response to the court given the prior answer, but I am required to ask that the court, she's asking the court waive pre-sentence investigation on these and proceed with sentencing. She also would like to be released for her, I believe it's daughter's graduation.
Yeah, it's Saturday from Westbrook.
State's opposed to that, Judge.
No, that's not happening. No. All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history, obviously there's a substantial amount of history, and so I want all of the information. So we will get a pre-sentence report done in all of the cases, and I'm not doing anything with the bond other than potentially raising it to make sure that we're where we need to be when we need to be. So that being said, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Rideau is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning, so you never know. You guys will know today after docket what the trial order is.
One final thing, if I may, on the tampering, Judge, it's filed as a 3rd degree, but I filed a repeat offender notice seeking to enhance it to a 2nd degree, given the defendant's previous robbery conviction. So I just want to make sure that all of that's.
Why did you put the tampering on me when you put the death on me?
Look, we're not, this isn't a conversation.
I'm sorry, yes, ma'am.
It doesn't matter, and they didn't put anything on you.
I mean, that's what I'm saying.
Okay, listen.
I don't understand how is it tampering? I mean,
That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure, with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of a 2nd degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Okay. And so I will number that case for trial for next week. All right. You go back with the bailiff.
Thank you, Judge.
Thank you. I'll let y'all know as soon as docket's done what the trial order is.
Thank you, Your Honor.
Yes, sir. Good. Then I don't have to worry about those. Okay. Good. Thank you. Okay. I really didn't write on these. Should I though, since she pled true to all of them? Maybe so. Did I save this? I don't know if I did the first one right either. Let me look real quick. Yeah, this has been going on forever. maybe I wonder if drug court has something like this, maybe on a,
Yeah, I'm sorry, Judge.
no, it's fine. I'm not opposed to doing it, obviously. But just based on the nature of that offense,
I think it would be appropriate.
that might be one that we could, so it doesn't sit around and wait for all the other big stuff. Let's see what it looks like after the docket, and then I'll contact them and see if they have a. So I'm right,
Did he already walk out?
oh,
Did he get his discovery?
uh-oh. Do y'all want to text him real quick? I mean, he can do it when he comes back for sentencing, but.
Or even Monday?
I feel like I got to. Okay, so I did the first one where it was supposed to be done, and then, okay. Mr. Burbank on Mr. Simon, Augusta Simon.
Every day in the USA, people find themselves in court.
Thank you. Good afternoon. We are on the record in the First Judicial District, the District of Greenwood, County, Kansas. This matter comes on for hearing of first appearance, a weekly first appearance for May 27, 2025. Who is the gentleman in the county jail, please?
Robert Williams.
Robert Williams.
Yes, ma'am.
At this time, we're on the record in 25 CR 74, State of Kansas versus Robert Lee Williams. County Attorney Jill Gillette for the state. The defendant, Robert Lee Williams, appears in person and per se. You are Mr. Williams, correct?
Yes, ma'am. Correct.
Mr. Williams, you are charged with 13 counts today.
13
And
counts.
you are Robert Lee Williams, correct?
Yes, ma'am.
All right.
That's ridiculous. This is ridiculous.
We're not going to do that. You're going to be respectful and quiet. And if you don't like the charges, you can take them up with your attorney.
Yes, ma'am.
We are on count 1, unlawful possession of the controlled substance, marijuana, in the amount of 1,360.7 grams. This is charged as unlawful distribution of that controlled substance because of the amount. It is a level 2 drug felony. If convicted of that level 2 drug felony, you could serve anywhere from 92 months up to 144 months in the Kansas Department of Corrections and pay a fine up to $500,000. In count 2, you are charged with unlawful possession of the controlled substance methamphetamine, a level 5 drug felony. If convicted, you could serve 10 to 42 months in prison and pay a fine up to $100,000. In count 3, you're charged with unlawful possession of drug paraphernalia with the intent to distribute, a level 5 drug felony, 10 to 42 months in prison possible, and $100,000 if convicted. Count number 4, possession of a certain substance, that is marijuana and or THC in excess of 28 grams. which would be violation of the drug dealer tax stamp.
Be
law.
quiet.
And you'd be looking at a level 10 non-person felony, the sentence for which is 5 to 13 months in prison and up to $100,000 in fines. In count 4, you're charged with unlawful possession of drug paraphernalia. That is a misdemeanor, a B misdemeanor, could be punishable by up to 6 months in jail and a $1,000 fine. Count 6, unlawful possession, misdemeanor possession of THC and or marijuana. Class B misdemeanor, up to 6 months in jail and a $1,000 fine possible if convicted. Count 7, transporting an open container. That is an unclassified misdemeanor. If convicted, that would be an unclassified beverage of an alcohol nature. In this case, it's alleged a Bud Light Gelada Clamato. The penalties could be up to $200 in fines and 6 months in jail. It looks like count 8 was no proof of insurance, but apparently you provided proof, as that's been, it looks like, stricken from the charging document.
There were two, Judge. It's not actually count 10.
Right. Count 8, you're charged with endangering a child, a class A person misdemeanor. If convicted, there's a $60 fine on that.
How,
On count 9, no proof of liability insurance. Third, within 2 years. That would make this a class A non-person misdemeanor. And if convicted, the fine could be up to $2,500 and 1 year in the county jail. There is a minimum fine that would have to be paid if you were to be convicted in that. The minimum fine would be $800, but the maximum is still $2,500. You do have the right to an attorney. Have you applied for court appointed or are you hiring?
I need to figure out, well, no, ma'am, I just need to, I talked to my brother, he a law enforcement officer in Belton, Missouri. He also gave me, just told me just, right now, just, have one appointed to me until he get down here. And I can try to get one appointed to me, but right now, I'm just trying to get one appointed to me as right now.
All right, deputy, did he turn in an application?
Not yet. I can give him one, Your Honor.
All right, please do. You'll need to fill that out and get that back to me today, and I'll see if you qualify for court appointed. In the meantime, Missy, when is his PHC date? You must be back here for the date she's about to give us.
20th at 1:30.
Which month? I'm sorry.
June 20th at 1:30.
You must be back here June 20th at 1:30 with counsel, and that can be by Zoom.
Is anybody get my bond reduced, ma'am?
What do you have it set at right now?
55, and I'm not from here at all.
Well, that's what
It's 60,000, Your Honor.
$60,000. You're not a Kansas resident. You're a Missouri resident. Is that
No,
right?
ma'am. No, I'm Kansas resident.
All right. Where do you live? Don't give me the address. Just tell me where you live.
1953 South Mosley, Wichita, Kansas.
All right. How long have you been there?
Almost 15 years.
And where do you work?
I'm disabled.
Okay. Ms. Gillette, state's position on bond.
Judge, I prefer a cash or surety bond.
These are very serious and numerous charges, Ms. Gillette.
Judge, I was gonna say 50,000 cash or professional surety.
And all right, $50,000 cash or professional surety is your bond. Talk to your attorney. He'll let you know if he thinks that can be lowered, but that is what it's set for at this time. And if there's nothing further, you are excused and remanded back to the sheriff. Thank you, Mr. Williams.
You did say 50,000, Your Honor, correct?
Yes, cash or professional surety, yes.
What do you mean by
Okay.
cash is for cash?
Well, the jail can explain that. We'll let you go at this time and bring in the next one, please.
So
Who's your next one, Deputy? Hello, sir. What's your name?
Drew Hallow.
Mr. Hallow, we are here on case number 23, CR 201, State of Kansas versus Drew A. Hallow. County Attorney Jill Gillette for the state, the defendant in person, in custody, and pro se. Mr. Hallow, you're here on a motion to revoke community corrections assignment. In essence, you're charged with failing to pay as directed, failing to report as directed, failing to notify law enforcement contact with your probation officer, and being kicked out or discharged from your Senate bill drug and alcohol treatment. So at this time, we need to order you to reappear in the Greenwood County Courthouse, live in person, not by Zoom, before Judge Ricky. And Missy, when will that be?
July 10th at 3 o'clock.
You must be back here live and in person, July 10th at 3 o'clock before Judge Ricky. And your bond is set by Judge Ricky at 10,000 cash or surety. He is the chief judge, and I will not disturb that bond. That is what you must make. But if you want to revisit it before that July date, contact your attorney. Are you going to reapply for attorney, sir?
No, ma'am.
You're going to hire an attorney?
No, I'm just going to represent myself.
I believe this is a felony revocation that could land you in prison. You still want to represent yourself?
I mean, there's really no, I've already pled guilty to the charges, haven't
I
I?
understand, and you've been put on probation, and I think you may have had possibly a prior revocation, but if you are revoked by Judge Ricky, you'll probably do prison time. Is that what you want to?
What is the underlying on the charges that I have?
Well, that's between you and your attorney if you get one, or you'll have to see about discovery from the county attorney. I can tell you, I believe fairly quickly that
The underlying's 10 months on count one.
10 months in prison.
So the time that I did here in Greenwood County was beforehand when I was awaiting my plea. Would that count towards the time that I have to do, or how much time would I collectively end up having to
Well,
do?
that's something for you to take up before Judge Ricky, your sentencing judge, who will be determining if you are revoked and sent back to prison. So
Okay.
I'm going to, are you working at this time?
I had a job interview and I was supposed to sign paperwork to start working on Thursday the 23rd, I believe, in El Dorado when I was reaccepted back into the sober living house that I was living at. But I wasn't made aware of I didn't know that I had a warrant. So when I went to report to corrections, when I basically tried to move to Wichita so that I could get more hours at where I was working.
All right, the bottom line, sir, is you're not working. I'm going to reappoint Mr. Chris Ambrose. Make sure you get a hold of him and discuss the matter before you come back before Judge Ricky, July 10th at 3:30. Judge Ricky has set that $10,000 cash or surety bond. I will not alter that. And you must contact your attorney if you want to have that heard any earlier.
All right. Thank you very much, Your Honor.
You're welcome. We'll be in recess. Deputy, who do you have next?
Gonna be Jessica Heath.
Very well. You'll need a minute to get her. I'll take up.
Okay.
Okay, are you Jessica He?
Yes.
We're on the record in 25 CR 75, State of Kansas versus Jessica Rochelle Heath, County Attorney Jill Gillette for the state, the defendant in person. Deputy, who do you have next?
Gonna be Jessica Heath.
Very well. You'll need a minute to get her. I'll take up.
Okay.
Okay, are you Jessica He?
Yes.
We're on the record in 25 CR 75, State of Kansas versus Jessica Rochelle Heath, County Attorney Jill Gillette for the state, the defendant in person, and pro se. Ms. Heath, in count one, you're charged with unlawful distribution of a controlled substance in an amount at least 450 grams, but less than 30 kilograms. The state's alleging you possessed 1,360.78 grams. This is a level 2 drug felony. If convicted, your sentence would be 92 months minimum, up to 144 months maximum in prison. Your fine would be up to $500,000. Count 2, you're charged with possession of methamphetamine, a level drug 5 felony. You could serve 10 to 42 months in prison and pay a $100,000 fine if convicted. Count 3, you're charged with felony possession of drug paraphernalia, a level 5 drug felony. If convicted, you could serve at least 10 to 42 months in prison and pay a $100,000 fine. Count 4, not possessing the drug tax stamp for at least 28 grams of marijuana. That is a level 10 non-person felony. If convicted, you could serve 5 to 13 months in prison and pay up to $100,000 in fines. Count 2, you're charged with misdemeanor possession of marijuana, a Class B misdemeanor. If convicted, you could serve up to 6 months in jail, where you are now, and pay a $1,000 fine. Count 6, unlawful possession of marijuana, a misdemeanor, Class B. You could serve 6 months, up to 6 months in jail, and a fine could be paid up to $1,000. In count 7, transporting an open container of Bud Light is an unclassified misdemeanor. You could serve up to 6 months in jail and pay a $1,000 fine. Count 8, endangering a child is a Class A misdemeanor. You could serve up to 12 months in jail and pay a fine up to $2,500. Count 9, not wearing a passenger safety restraint or seatbelt, unclassified misdemeanor. Your fine would be $30, no jail time. Count 10, that is count 10. And let's see, that is the bulk and remainder of your charges. Do you intend to hire an attorney or apply for court appointed?
I don't have any money to hire an attorney. I'm actually unemployed at the moment.
All
So,
right. Have you ever had an attorney in this part of the country before?
no.
I will approve a court-appointed attorney. Missy, my assistant, will give you the name of the attorney in a few days. You'll need to call back and ask her who your attorney is. Then I am ordering that you contact that attorney.
Okay.
Missy, when is her court date, please?
June 20th at 1:30.
You must be back here June 20th at 1:30 with your attorney. Actually, that can be by Zoom. And I believe your bond has been set. Is there anything further about the issue of bond?
I was gonna ask if there's any way that we could lower my bond by chance.
All right, where are you from?
I'm from Halstead, Kansas.
And are you employed?
No, I'm unemployed at the moment.
How long have you been unemployed?
It's been almost a year now.
Recommendations for bond, Ms. Gillette?
Judge, she's co-defendant to Mr. Williams. So I was recommending the same amount that his bond is set at.
So I recall we set that at 50,000. Your bond is set, Ms. Heath, at 50,000, cash or professional surety.
I thought my bond was 35.
Well, that's, if we're keeping it at what his is, that's what it is. Been raised to 50,000. Contact your attorney when you know who it is. And if the attorney thinks you can get it reduced, he can bring it back before the court. Nothing further. You are excused at this time, Ms. Heath. Thank you.
Thank you.
Anyone else in jail, Missy?
Yes.
Hello, what is your name?
Mary Hazelwood.
We are on the record in 19 CR 235, State of Kansas versus Mary Barbara Rose Hazelwood, County Attorney. Whose number is iPhone? Who are you? Okay, we took up your case, didn't we? What's your name?
Tamara Dameron.
Oh, I guess we didn't take that up, did we? We are on the record in 2025 CR 47, State of Kansas versus Tamara L. Dameron, County Attorney Jill Gillette for the state, the defendant Ms. Dameron in person and pro se. Ms. Dameron, you are charged with one misdemeanor, an unclassified misdemeanor. It is alleged that on or about March 24, 2025 in Greenwood County, you did unlawfully and knowingly use fighting words or engage in noisy conduct which would tend to reasonably arouse alarm, anger, or cause resentment in another. This is a Class C misdemeanor. The penalty could be up to 5 months and 30 days in jail. Do you wish to enter a plea or do you wish to hire an attorney?
Yes, ma'am. I would like to hire an attorney. I have contacted one. It's only been a few weeks, I guess a little over 3 weeks since I was arrested that day. So I just need a little more time to pay the deposit or the retainer fee. It's just a little bit more because they had to travel to Eureka, but that's fine with me. I just need a little
Actually, they
extra time.
don't. Let your attorney know that this will be by Zoom, so they won't have to travel to Eureka. Who are you thinking of hiring?
Brian Williams out of Emporia.
Brian Williams. Yes, I will set this for misdemeanor control. Missy, when do you want her to come back?
June 24th at 3:30.
Tell Mr. Williams this is by June 24th at 3:30.
Ma'am, may I have just a little more time than that? Maybe another week or two? That will give me at least 2 full paychecks before I come back.
Very well. Missy, what else do you have a little later on?
How about July 8th at 3:30?
July 8th at 3:30. Tell your attorney that he needs to have his entry of appearance on file and be back here with you by Zoom, July 8th at 3:30.
Yes, ma'am. Thank you.
Right. Anything further from anyone? It looks like you.
I did want to ask clarification. May I ask clarification? When I was arrested and I bonded out on the warrant, it had shown, I don't know if it shows that Leah Hobbs is the person. It doesn't show Brian Swogar and the child as the people for no contact. And Leah Hobbs is a person that another parent that had reached out to me about her child and contacted the police station to make a statement on my behalf, but she's on the list for people I cannot contact. So I have not been able to do anything further with that. And also she has 2 boys that are the same age as my boys and they participate in the same sports. I've been very hesitant on even going, because it says on the paper I cannot be anywhere near, even if it's a school function and they show up, I have to leave. So I've not even been able to participate in anything. I just didn't know about that particular person on there.
School functions are about over. Miss Gillette, what do you think about contact? Do you have any recommendations?
Ms. Hobbs is gonna be a witness due to all of her statements, as well as all the other people that are listed on it. We have a standard no contact with witnesses or victims directly or indirectly, and I believe there was also maybe letters issued by the school, I don't know. But yeah, there is a no contact with all witnesses and victims. Attorneys can contact, so if she does get her attorney filed, the attorney can contact the witness, but she is not to have direct contact.
Okay.
And
originally my son was listed on the no contact. He's not. That's been corrected. Am I right?
Is this the case where one of you has a girl, one of you has a boy, they used to
Yeah.
date, they fight?
Yeah.
You guys get into it? Okay, yeah. Yeah, I don't want you having any contact with those people. Thank you.
Yeah, no, I don't want any, not that, those aren't the people that I'm referring to, Your Honor.
Okay, well, if they're named witnesses, no contact.
Okay.
You may go.
Thank you.
You're welcome. We are on the record in Rylander 2025 CR 59, State of Kansas versus Ronald Lynn Rylander or Raylander. County Attorney Jill Gillette for the state. Is the defendant R-E-I-L-E-N-D-E-R present? Ronald Rylander. Okay, I don't believe yes, we did take up Hazelwood.
We have Ms. Burns and Bollinger on the screen with us, Your Honor.
You said that's Bollinger. Roseanne is Bollinger.
Roseanne Burns.
Burns. All right, we are on the record in 2025 TR 96, State of Kansas versus Roseanne Christine Burns, County Attorney Jill Gillette for the state. Ms. Burns appearing in person and pro se on count 1, driving under the influence of alcohol. This is a Class B misdemeanor. It has penalties that include a minimum fine of $750 and a maximum fine of $1,000 in up to 6 months in the county jail. Count 2, improper driving on a laned roadway is an infraction. If convicted, you would not have any jail time, but your sentence could be a fine scheduled of $75. Can you hear me, Miss Burns? You cannot hear me? If you can hear me, give a thumbs up.
Hello.
Can you
Can you hear me? Yes, I can hear you. Thank you.
Very good.
Your Honor.
Are you intending to hire an attorney, apply for court appointed, waive attorney, and represent yourself?
I believe that this case was dismissed. I don't know what's going on anymore. I had a court-appointed attorney, I believe, because I couldn't afford an attorney myself, if that's what that means. And I wasn't drunk. I thought that I blew a 0 when they blew me alcohol.
All right, well, let's talk about attorney. Who did you have before?
Pawn, Mr. Pawn.
Mr. Paul, maybe? Richard Paul?
Yeah.
Okay. Have your financial circumstances changed since he was appointed?
No, I still cannot afford.
All right, Richard Paul is reappointed. Be sure and call him and give him the new court date. Missy, when will that be?
Let's set this one July 18th at 10 o'clock.
You must call Mr. Paul and be ready to go. July 18th at 10. Both of you must appear here by Zoom.
You got it. That's no problem. Thank you very much, Your Honor.
And your bond, did you sign bonds? Let me look here. Looks like you were summoned in.
She was summoned in on this, Your Honor. We had to wait for we waited for the KBI lab results before filing.
Recommendations for bond then?
Judge, we summoned her. I'm fine with having her processed on an OR bond. She's come in on her summons. I would just say like $1,000 OR bond, and she can just be fingerprinted at the sheriff's office.
I will issue an OR bond, but since it's driving under the influence, I'm going to make it $4,000 cash or professional surety. Conditions: no alcohol, illegal drugs, and go out to the sheriff here in Greenwood County and get your fingerprints taken and post that bond.
Judge, are you appointing her Mr. Paul?
And I will appoint Mr. Paul. Where do you live? What town?
Roseanne, are you asking me?
What town do you live in?
I mean, Eureka, but I don't understand. Do I have to spend $4,000 to get a fingerprint now?
No, you just need to sign a bond. You'll lose that money if you don't come to court, but you don't have to put anything up front, only if you fail to come to court. So just go out, sign the bond where you promise to come to court, and get your picture and prints taken again if need be.
I'm in a wheelchair and I don't have my legs or capacity to use an arm. Didn't I get fingerprinted? I don't.
Well, if you got fingerprinted before, they would have dismissed the action and refiled it after they got the alcohol and drugs. Is that right, Ms. Gillette? She said they dismissed it. Do you show she actually dismissed and refiled?
It was never filed here.
Never filed? Okay.
We just agreed to summons her if her test was positive, and it was, so we summoned her instead of
Arrested her. They didn't take you to jail at any point, Miss Burns?
I did go to jail for 5 days.
On this case?
Yes.
All right, will you contact the jail to get your fingerprints taken, and Missy can check. If they've already done it on this case, they probably won't have to do it again.
So just contact the jail, make sure there's fingerprints there, or go there and get fingerprinted.
Right, and make sure you call Mr. Paul and give him the new court date and time that you need to be back here with him by Zoom.
All right, July 8th at 10 o'clock.
Was it the 8th, Missy, or the 18th?
The 18th.
Okay, so 18, 1/8. All right, if there's nothing further, you'll be excused and with the condition that you make those phone calls, Miss Burns.
All right, thank you very much. You guys have a nice day.
Thank you, you too.
Thank you.
You're welcome. We are in recess. We'll now be on the record in Bollinger, 2025 TR 171, State of Kansas versus Packer Aiden Eric Bollinger, County Attorney Jill Gillette for the state. The defendant appearing in person and pro se. Sir, you're here on one count of driving a vehicle with illegal or no tags. This is an unclassified misdemeanor. The maximum fine could be up to $2,500. The sentence could be 30 days to 6 months.
Judge, you're muted.
We're on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This matter comes on for our Tuesday, May 27, 2025, misdemeanor docket. And at this time, I would call 2024 CR 186, State of Kansas versus Kelton Garrett Butner. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Your Honor, the defendant appears in person with counsel Bob Johnson.
Thank you. This matter does come on for sentencing. Ms. Gillette.
Yes, Your Honor, we have received the drug and alcohol evaluation from Crosswinds. He's recommended to complete an outpatient treatment program per the recommendation. The defendant had pled to amended count 1 and count 2 in the complaint as count 2 being a driving under the influence. Second, there is a 48-hour minimum. We're recommending the defendant serve 48 hours and then be placed on supervised probation. The underlying term being recommended as a 12-month underlying term suspended after the 48 hours for 12 months of supervised probation, complete that treatment, pay his standard court cost fine. The minimum fine is recommended by the statute. His booking fee, any cost of his treatment, and probation fee, his attorney is retained, so there's no need to make any Robinson findings pursuant to needs. And we would ask that he just continue to follow all the other recommendations of standard probation.
Very well, Mr. Johnson's recommendations.
Your Honor, I would concur with that. I can advise the court that Mr. Butner has already began his treatment. He has a meeting tonight. He is employed. He understands the 48 hours. We would ask the court to consider to allow him to do that on a weekend so he doesn't miss employment or have the chance of being terminated. I went over that with him. He understands probation and what he'll need to do, but we concur with the state's recommendation on the sentence. I think Mr. Butner is well aware of conditions of.
Counsel, I know they waived the 48-hour requirement on the first. I thought I heard you say this was a second.
Yes, Your Honor.
I don't recall them changing the 5 days to 48. Is that your recommendation, that they've changed the 48 to 24 on the second?
I think on the second, they have to serve 48 continuous, then can be released and either placed on house arrest or probation. I believe he understands he's going to have to do the 48 hours. He would just ask.
Well, he's also going to have to do, if he doesn't do all 5 days in jail, he's going to have to go immediately on to 3 days house arrest.
Yes, he understands that, Judge.
Okay, all right. And then what was the recommendation on count 2, Ms. Gillette? I don't think I heard that.
Your Honor, that is the child endangerment. I am recommending the, it's a class A, the same concurrent 12-month underlying suspend for the 12 months probation. They have identical minimum time or maximum time frames.
And was this child endangerment part of a DUI?
This is the reckless driving part of it.
And you don't believe that? Okay, you're recommending how much time for him to serve on the DUI?
They both have recommended 12-month underlying sentences suspended after he has his mandatory time for the DUI for 12 months of supervised probation. Judge, there is a statute that allows you to up the circumstances on a DUI if a minor child's in the car, if it's just on the DUI. But in this instance, there was some driving that was in a reckless nature that would put the child in danger. So
isn't there some extra time that has to be ordered because of that endangerment?
Because there's 2 separate ones here, Judge. We're asking for the 12 months concurrent.
You don't think it's mandatory that I go 13 months?
That is an option to put it as 13 months with an additional 30 days.
Yeah.
But I'm recommending that he took a separate charge due to the reckless driving.
All right, back to you, Counselor Mr. Johnson. I
Yes, Your
interrupted you there.
Yes, Your Honor. I don't think there's any mandatory time on the endangerment charge. We're just asking that he put on the 12 months, have him do the 48 hours on a weekend, placed on probation. Obviously, if he hasn't learned his lesson, he'll learn it in jail for 12 months when he is violated, if that's the case. However, he has already began the terms of his probation by starting the treatment.
All right, Mr. Johnson, at this time on count one, and that's the DUI second, no. On count one, child endangering, your sentence is 12 months on count and no fine. On count two, driving under the influence second, concurrent 13 months. And I'm going to order the $750 fine on the count two DUI. On probation, I will grant a year of reporting probation. You must call probation immediately after this hearing at 316-322-4153. You will make payments at the rate of 1/12 of the total due each month. In addition to the $750 fine, there will be $108 court costs.
Judge, this is one.
That's 158, yes. 158 court costs, $45 booking fee, and $60 probation supervision fee. You will serve 48 hours in jail, followed by immediately house arrest for 3 days with electronic monitoring, or 72 hours, I should say. You must wear the bracelet or ankle monitor at all times. And that's to be installed upon release from jail. You'll only be, what kind of work do you do?
I'm a mechanic at a Amazon.
Okay. You'll be allowed work release. And you'll be allowed only work release. You are ordered to comply with your alcohol and drug evaluation, including completion of your treatment. You are ordered to to follow all standard conditions of probation, as well as the special ones I've mentioned and the DUI victim impact panel. You are to tell me when you're going to start the jail. I'll give you up to 7 days to check into jail and get this started. When do you want to check in?
Ron, we're gonna have to get the house arrest set up. I don't know if he could do it this weekend and we can get it set up by then, or maybe next weekend if the court would allow such.
Well, I will work with you on that a little bit.
Could we start it, could he do it the second weekend in June so we could get the house arrest set up? I think that'd be the 7th, is that right? Or the 6th?
Well, that'd be the first weekend in June, wouldn't it? Or
Well, the first is Sunday, so yeah, I guess it'd be the first full weekend in June.
all right, just give me a day and I'll go with it. What day?
Let me get my calendar up. He could check in Friday the 6th after work and then be released Sunday night on house arrest.
All right, you are to check in no later than 7 p.m. on Friday, June 6th. And you are to go immediately to 72 hours house arrest after that. And I noticed that CSO Jessica Morgan is here. I've told him to call Butler County. Is that what you want him to do? Or do you want him to just come see you?
Tony Bauer is in the office, and so he just asked that he come to the second floor and he will get him the paperwork.
All right, instead of calling, come on up here to the second floor when you're through to Tony Bauer. the probation officer. Anything else I've left out, council, that I need to address?
Just that the hours need to be hour per hour.
Right, 72 hours, hour per hour. All right, if nothing further, we'll be in recess. Thank you, Mr. Johnson and Ms. Gillette. Thank you, Mr. Buettner, and I wish you good luck.
Thank you, Judge.
You're welcome. We'll be in recess on Buettner. Okay, we are now going to be on the record in Kerr 2025 CR 41, State of Kansas versus Kelby Dawn Kerr. Jill Gillette for the state, Richard Paul for the defendant, who also appears in person.
Hi.
And counsel, how does your client wish to proceed today?
Judge, I have I've got a summer intern who just finished her 1L year sitting here with me, so we just have to it's a long ploy to get people here, but we're working on it. So
I appreciate that. Keep working on that. Yes. All right. Well, that brings us to the record in 2023 CR 135 and 2024 CR 82, each captioned State of Kansas versus Lydia Lucille Stubbs, Jill Gillette for the state, and Chris Ambrose for the defendant. Is that Miss Stubbs in the county jail or county courthouse? I believe it is.
yes, Your Honor, it is.
Now, we were working on May 20th with warrant to show cause on these two cases. And I think if I recall correctly, we started out with a possible stipulation, but not. So,
And, Your Honor, if I may give you an update with where we're at. I've had a chance to speak with Ms. Stubbs as well as Ms. Gillette about this. If the court would be willing to, the plan today would be entering a no contest stipulation, so a no contest statement. And then upon entry of that, I believe we're going to have a recommended disposition to the court in which Ms. Stubbs has served 6 days in custody awaiting this. My understanding in speaking with Mr. Gillette is the state defense will be jointly recommending that she be allowed to have that 6-day period served as be considered a sanction, that she be placed back on probation, that she immediately, which she's working with Corner House in Emporia, begin drug and alcohol treatment services through Corner House in Emporia. And then she sign all necessary releases and she stay in touch with the probation officer, make sure that she keeps good contact information with them at all times.
and that's your agreement, Ms. Gillette?
It is, Your Honor.
All right, Ms. Stubbs, you understand you have the right to an evidentiary hearing, and the burden would be on the state to show that you violated your probation. Is that correct? I can't hear you. You're gonna have to get in front of the microphone.
Yes, Your Honor.
And even though you have the right to that hearing, you're going to waive that hearing today, is that right? And you're not admitting that you violated, but you're stipulating or agreeing that that's what the evidence would show if the witness were to testify. Is that correct, Mr. Ambrose?
Yes, Your Honor.
And that's your position, Ms. Stubbs? You have to get in front of the microphone.
Yes.
Thank you, Ms. Stubbs. We're keeping a record of this, so you need to make sure you speak nice and loud so we've got a good recording of it, okay?
Now, Ms. Stubbs, you understand that there is an agreement between the attorneys, but that is not binding upon the court. I don't have to follow that. Do you know that?
Yes, I know.
Okay. And Miss Morgan, if this were to go to trial, I won't put you under oath for the, is this yours or Miss Seeley's? This is Miss Seeley's, isn't it?
No, Your Honor, it's mine.
All right. If this were going to go to hearing, can you just give me a synopsis of what your testimony would be? What the violations were, in other words?
She has not made any payments. She hasn't gotten a drug and alcohol evaluation. She hasn't provided proof of employment, and she was seen with Mr. Connor in the community.
Mr. Connor, the co-defendant, and I think that's what we set this over for, is she was denying that. But you would testify that there is evidence that she was?
Yes, Your
having
Honor.
contact? Okay. All right. Well, I will find that there is evidence that the defendant has violated her probation that was granted to her June 7th of 2024, at which time she was giving a controlling sentence of 12 months and was granted 12 months of reporting probation. What would be, I've heard what the attorney's probation recommendations are. Ms. Morgan, I was thinking that you had made a recommendation in your request to revoke that you didn't think she was amenable to probation. Am I remembering that correctly?
Yes, Your Honor. However, she did call me after court last time we appeared. So she did call me, and also you ordered her to show up to the courthouse. So I'm willing to give her another chance on probation.
Ms. Stubbs, when I heard last time's information and I'm hearing today, I'm thinking that it's very well justified to just revoke your probation and have you serve your 12 months in jail. But because the attorneys and Ms. Morgan are willing to give you another chance, I will do so too. But don't expect me to give you another one because these are pretty significant violations. And if you come back again, there are no guarantees that you won't serve the whole 12 months. In fact, there's a probability that you will. So at this time, the defendant's probation is revoked in both cases, but reinstated with the order that she have a 6-day sanction in each. She will get credit for time served in each and be reinstated on probation with all previous conditions, as well as make sure that you get that specific condition of your drug and alcohol services that counsel mentioned. Anything else we need to take up, counsel?
Judge, 6 months from today's date for probation.
To reinstate it?
To extend her for 6 months from today's date, just because I don't know when all of her expiration would have been. So her probation would be 6
months. Extend her probation to 12 months from today. Okay. Do you want her to come up and see you, Ms. Morgan, or do you have an appointment?
Your Honor, I am not actually in the office today. If you will have her, Ms. Stubbs, call me tomorrow at 9 a.m. Also, Your Honor, I do want clarification about the no contact with William Connor. Is that still in effect?
Absolutely. All prior conditions. And I mean no contact. All right, we'll be adjourned. Thank you.
Thank you, Judge.
You're welcome.
day in the USA, people find themselves in court.
Okay.
You know, if someone pops up and I'm looking, I'll be paying attention.
Okay, we'll put you in a room. That's
When they join. Perfect.
okay, we'll put you in breakout room 1. Okay, the first one here was Thomas.
You didn't have to put me in now. I just meant when they come in. But if it's easier now, I will sit in my room
Okay.
Oh, no.
and behave.
Morning, officer.
Morning.
We've got several of your people here. One of them is Mr. Thomas. And Mr. Thomas. I don't see Mr. Thomas.
One moment, I just have to close the door, Your Honor.
This is 25 BE 01695. The ticket was issued on the 6th of April at about 1:57 in the morning. In the area of Berkeley near Woodward and 12 Mile Road, you were cited for speeding. The ticket was issued 63 in a 45. The options you have this morning are 3. You can admit responsibility, deny responsibility, or admit responsibility with an explanation. How do you wish to proceed?
I would like to admit responsibility with an explanation.
What is the explanation, please?
Your Honor, I have been a part of coming to Royal Oak for, since I would say since Barnes and Noble was on Main Street, coming there to do my graduate studies. Actually, went to Michigan State. As a result, I got accepted into the French program. I received my bachelor degree in French studies as well as international relations. And I joined the United States Peace Corps, did my tenure in West Africa, and come back to the United States here. And I can tell you, Your Honor, I just, coming to Royal Oak for such a long time, never heard of the city of Berkeley. And so I was coming from.
Let's talk about Woodward Avenue on the 6th day of April at about 1:57 in the morning.
Correct. So I was I feel like, the officer used kind of a bully tactic, Your Honor. Like I said, I was coming from Berkeley. I was driving on one lane, one road. I noticed my car is a very old, it's kind of an old car. It's over 20 years old, no tinted windows. I noticed a very bright light as if I was being tailgated. And so my response to that said, well, I don't want, because I was lost. I was coming from South Freeway. I was kind of bewildered. I'm not really knowing the situation or not knowing exactly where I was at. I was using the GPS and I was trying to figure out why can't I get on the freeway. And so there was a car behind me that was driving that was in my tail. I was being tailgated with bright lights. So I did kind of speed up because I knew I was in the area that I was unfamiliar with. I sped up just to get, I didn't want to be a nuisance to the driver behind me, not knowing that was the police officer. I did ask the police officer, hey man, when I was, pulled over, I didn't realize, to be honest with you, I still didn't know where I was at when I got pulled over because it was very dark. And it wasn't until I looked over and recognized the restaurant, OWL, to realize, okay, I know where I'm at. And, before that, I was asking the officer, hey man, I was just on my GPS, I'm lost. And he didn't seem to care about that. And
why would he care about that if you're driving 63 miles an hour in a 45 zone?
Because like I said, I was trying to speed. I sped up only because, someone was behind me. And
you're blaming the officer who was measuring your speed with making you drive 18 miles an hour faster than the speed limit.
Correct. And so, like I said, I didn't know.
This is correct. That's great.
No, it's not. I'm not trying to blame the officer. It's what I'm saying is, I didn't know where I was at. I was being tailgated. From my peripheral vision, I was being tailgated with bright lights. I'm just trying to make, distance between myself and the car behind me. And, I have a clean driving record. And, I was just trying to, I was trying to figure out where I was at, and the police officer did not, tell me. I didn't realize that the freeway was blocked, or there was, 696 is no longer, operable during that date and time. And so I do apologize, I wasn't trying to, be a nuisance or anything like that to the community, or try to speed through the community. I was really just trying to get home and, start my day, start my next day. So I do apologize. Like I said, I do hold some accountability, and that's why I'm just, giving you, my
accountability
explanation.
Okay, the bottom line is that civil infractions have no intent to do evil as an element. Civil infractions are mistakes. The speed limit on Woodward Avenue is 45 miles an hour. The speed at which your vehicle was measured was 63 miles an hour. You described the circumstances are you weren't sure where you were going. You were kind of lost, although you had GPS. GPS also tells you the speed limit on the road as well as the speed at which your vehicle is moving. And yet with all those cues, you didn't know where you were for sure. And then you blame the officer for putting his lights on in the back of your car for making you speed. You rightly admit responsibility, and the fine is $200. You can pay it online or by mail, or you can pay it at the courthouse counter.
May I also, if I do have to pay it, may I ask that it does not, include points? I do have a clean driver's record, and I would like—
Points don't come from the court. Points come from the Michigan Secretary of State. Court, I can't make the points change for any particular infraction. A 5 over ticket's going to get the same number of points no matter where it is, or 18 over is going to get the same number of points wherever that comes from in the state. The court has nothing to do with the points. That's a creature of the Secretary of State, solely and exclusively within the control of the Michigan Secretary of State.
And how many points are we looking at? Am I looking
That's
at—
between you and the Secretary of State, sir.
So it can be 0 points is what I'm saying? Because
it's not 0.
So so that's what I'm asking, if I can get, if you can, be courteous enough so I can, at least, pay the fine and I can drop the points.
We have to be courteous and say that what happened to you on the street didn't happen. We have to be courteous and say that your violation of law didn't happen. It's not going to work. We're done. Okay, Mr. Cummings.
Hello, good morning.
Good morning. This is 25 BE 01337. It's a ticket that was issued to you back on the 17th of March for driving on expired plates or tabs. When did you get the new plates or tabs?
That would be, I don't have an exact date, but I know it was probably
You
about
have
a
the new
week.
registration with you?
I do not. It's in my car right now.
You have the receipt that they issued. We have. Please unmute. Mitch Wazinski, please unmute.
Hello, good morning.
Morning. This is 25 BE 02008. This is a speeding ticket that was issued on the 20th of April, about 10 o'clock in the evening, Woodward near 12 Mile in Berkeley. You were cited 65 and a 45. You can admit responsibility, you can deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
So can I explain what happened?
The three choices you have are you can admit responsibility, you can deny responsibility, or you can admit responsibility with an explanation.
Admit responsibility with explanation.
What is that, please?
So we were driving on Woodward and there was this car next to me. I don't know what kind of car it was. And he originally went to go pull over them. And then he said he didn't stop. So he just came after me. And I definitely was speeding, but I don't think I was speeding that fast.
So you're admitting responsibility for something you didn't do.
Well, I mean, I was going fast. I was
You were
speeding.
cited for driving 65 in a 45. Were you driving 65 in a 45 or not?
No, I wasn't driving 65.
Raise your right hands, please. Are you vertical or horizontal?
Vertical.
Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do.
Ms.
I
Mazinski,
do.
are you going to take the oath?
Yeah, I do. Sorry.
The officer will testify first, please.
Your Honor, on April 20th at 10:02 p.m., I was southbound on Woodward, directly behind a black Jeep Grand Cherokee and a silver sedan that were side by side, rapidly accelerating in a drag racing manner. I had obtained front moving same direction radar reading of the vehicles at 72 miles an hour in the posted 45-mile-an-hour zone. I had attempted to stop both vehicles. One fled, and the Cherokee had yielded to the right and stopped. I am certified to operate my radar device, and it was checked before and after shift with no problems.
Ms. Wazinski?
So I remember exactly what he's talking about. We were driving down, but my car, it's just a regular 2019 Jeep Cherokee, so it's not like loud. Like I can't like really rev it or accelerate it. It doesn't really make any noise because it's just a regular Jeep. So, but I know I was going a little fast, but I don't think I ever went up to 65 or 75, whatever you guys said it was.
We guys didn't say anything.
The
Police officer
officer.
testified under oath.
Okay, sorry about that.
So you know you were speeding, but you don't know how much. Correct?
Correct.
Well, the officer does know by how much. He measured your speed with radar. He's certified to operate radar. He put the radar unit through test at the beginning and at the end of his shift. It worked at the beginning. It was still working at the end. There is no reason to believe that it broke and somehow fixed itself in the middle of his shift. The speed that your vehicle was measured at was 72. The officer elected to cite you for 65 instead. I do believe that you're responsible for the reasons I just stated. The fine on this is $200. It can be paid online or by mail, or you can make a payment at the courthouse counter. Thank you.
Thank you.
Have a good day.
You too.
Mr. Bevel. Okay, Mr. Bevel, you're in court. Please take off your hat. This is citation 25.
All right, y'all set? Do your arraignment.
Mr. Whitehead, you have the chance to speak before you're arraigned, you'll speak with Mr. Gonzalez, your attorney here. And the court is not a party to your conversation with your attorney. It's a private conversation between you and him. It'll be in breakout 3. And the attorney will meet you in breakout room 3. And he is in 3. That was Mr. Gonzalez. Which is usually a good sign. And 2. And we've got Mr. Whitehead back. This is 23-02252, people of the state of Michigan versus DeJuan DeCarlos Whitehead.
Ready, Your Honor. Juan Gonzalez appearing on behalf of Mr. Whitehead, who is present via Zoom. He's also consenting to having this hearing via Zoom. Date and time set for an arraignment on a bench warrant. We'd ask the court to recall the bench warrant. And then my client indicates he can pay the fee within 30 days. If not, I would just ask for a show cause date.
bench warrant. We will reset the show cause. Mr. Whitehead, if you have this paid off before the show cause hearing, you do not need to appear at the show cause hearing.
Okay.
In the event that you don't have it paid off, then you do. But bear in mind, if you don't come to court and they reissue a warrant, they add another $75 to it.
Okay.
Yeah, and I explained that to him, Your Honor. I believe it was a $30 balance, but because of the fees and all that, it went up.
Oh, jeez. So he's had it down to $30?
That's what Mr. Whitehead says. Is that correct?
Yes, $30. That's all. $30. That's all I owe.
Well, Judge Meineke set a bond at 25. Looks like $25,000 cash surety or 10%. I'm going to modify that. Mr. Whitehead, do you have any cash with you now at all?
I got a couple dollars to eat. That's all I have.
I'm going to go back to 195 personal. If you can't pay it, don't skip court. Show up and tell the judge. I do not have access to the entire record, so I'll have to deal with what's before me, and that's the warrant. The bond I've reduced considerably, and we'll reset the show cause. For your address, we've got several for you.
15546 Oak Brook Street.
Okay. You have a phone?
He does.
Check your
617
712 8702.
Okay. I think we can give you a text reminder of the court hearing.
Yes, please do.
Okay. Then you're on a personal bond now. Thank you.
Thank you.
Good luck to you.
You too.
Thank you, Your Honor.
Do we have anyone else in jail?
We do, we just don't, they're not ready.
Just one or two?
One. And just one. We have.
Ryder, there's a personal bond on that?
Yeah, it's a personal bond.
Thank you.
195.
Anyone else over here you'd like to see?
We've only got one left, but we don't have the paperwork on Mr. Ayers.
Okay. Okay. We're all set.
All set. Thank you.
Thank you.
Mr. Gonzalez, Mr. Ayers appears to have been booked yesterday at 9 o'clock in the morning. And the charges appear to be OUIL and Tracy Broom. See what they're on the docket about. They're not on the docket. If somebody uses another person's computer, the screen name doesn't show as the name that we're looking for.
Yeah, this is related to my case, Mr. Murphy.
Yeah. And I just want to see it. Okay, your name is Tracy Broom?
Yes,
And what case do you have?
I'm here with Douglas Murphy.
Okay, that's what I was checking.
Mhm.
Douglas Murphy, I haven't seen you in years.
No, I haven't been in trouble in years.
Okay, this was originally set for April, and then it was adjourned. Where does it stand today?
We are near completion. When this first started, it was in January. We had some really nasty weather, and I was having to dig things out of ice. Unfortunately, we had a flood last year, and our things were packed out, removed, and then brought back to the property. And that was the overload of stuff. It's not garbage. It was items that needed to be put away.
Sorted through and put away.
Yeah.
Mr. Venice,
Yeah, this resulted from a complaint from a neighbor. The backyard is just completely full of stuff. Just numerous things, items. Some of it is like pallets, just a lot of plastic totes filled with miscellaneous stuff. It's just scattered throughout the entire rear yard and driveway. This complaint did come in mid-December, and I've been in contact with the property owner, Mr. Murphy, and Ms. Broom, trying to resolve this and get this cleaned up. So this has been an ongoing thing since December, and here we are, we're in May, almost June. And there's been some progress, but then it sometimes I've got pictures every time I do a recheck on it, and it's hard to compare. There might be a few things moved, something missing, something new there. It's just not getting done. But I was trying to be sensitive back in December and the cold weather and the shorter days, daylight hours to get this cleaned up. But as we've gotten into spring and we've had some nicer weather, this is actually the second ticket on this. First ticket was just paid, but it's still not cleaned up. I have photos of it from a week ago, but even driving by on Friday, it's still not cleaned up yet.
Mr. Murphy, can this be done in 2 weeks?
I'll be honest with you, I'm disabled. I'm blind in one eye. I can't walk. So it's up to Tracy here. Everything's up to Tracy.
And I would disagree. I'm sorry, Dave, but I think that your frustration with the neighbor is causing you to project.
Let's deal with the yard, Ms. Broom. Can it be cleaned out in 2 weeks?
Well, yes. I mean, there's a lot of progress made. I mean,
Okay, let's just deal with what can be done.
Yes.
2 weeks.
Yeah.
Okay, we're going to adjourn this 2 weeks, and then it needs to be done.
Okay.
Okay.
Yep.
See you in 2 weeks.
Okay.
Thank you.
Thank you, Your Honor.
I like that.
You're good to go.
That he's not.
It's I got a picture here if you can see that. That's from last week. I don't know if you're able to see that from here. I'm holding
I can see it.
And there's a lot of outdoor items. I mean, there's
that one just because you're closer. Okay. If he wants to call you as a witness, we can deal with that at the time. Okay. And so Ms. Ringner, am I saying your name correctly, first of all?
Yes.
Okay. And then Mr. Jackson, could you raise your right hand? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. And how is it you need an order against Ms. Ringner?
So just give you background history, what's going on. I met her, I think, March, April, 2 years ago. At that time, me and Dallas was broken up and I met her. Subsequently, we began our relationship again. And I tried to break my relationship off with Miss Ringner. I told her I didn't want to talk to her anymore. Blocked her.
Say it again, please. A little bit louder. I missed that.
I told her I didn't want to talk to her anymore. I blocked her from calling my phone. I blocked her on social media. But one night she showed up at my house. She parked around the corner, crept through my backyard. I was in my home reading, and she tapped on the door, and I was, surprised that she was there. And she started telling me that she was pregnant, asked me if she can come in. And I said no, because she's making commotion on my backyard. But I'm a local realtor, so I don't want the noise, the confrontation. And I let her in. She spent the night. the next morning, she asked, what are we gonna do? I said, hey, you need to go your way. I'm gonna go mine. And at that time, she said, no. I said, what do you mean, no? And she said, I'm not leaving. And I said, well, hey, it's 8 o'clock in the morning. I gotta go to work. You gotta go. And she's like, no, I'm not leaving. So I tried to pull her out. She was hitting me and fighting me, wouldn't let me escort her out of my house. I also tried to pick her up and take her out. She's kicking, punching me, wouldn't leave my house. She called the police and said, this man is putting his hands on me. I called the police as well. When they came, I told them my story. She told them theirs. I got arrested. Subsequently, the charges were dismissed. But also during that time, she came to my hearing the next day. Unbeknownst to me, she took pictures of me getting put in a police car. She took pictures of me in custody that day. She came and picked me up at the jail, and we kind of touched bases, but eventually we continued to see one another. Again, I tried to break the relationship off. Sometime in October, she showed up at my work. And because she couldn't text me or call me, she was emailing me that she's in my parking lot. And if I didn't come down, she was going to come up. Well, she stayed true to her word. She came up and started talking to me. I left my office and went outside because obviously I'm in a real estate office. I don't want to discuss my personal business up there. I went and I just decided to leave because it was just causing too much attention. She put herself in between my door and the car, so I couldn't close the door. Eventually, I left, and I was working on the project, Your Honor. Sometimes I buy houses and flip them. I left the office and went to that project. I had no idea where she was at, but while I was in the house, just checking on the contractor's work, I heard some noise. She showed up there. I asked her to leave. She wouldn't leave. I was blocked in. And because of the previous situation that happened, I went across the street and told the neighbor, hey, I also recorded it. I told the neighbor, like, hey, there's someone here and I just want you to be a witness to what's going on because it didn't work out the last time, right? And so a couple months after that, we're hanging out again. Shannon had been drinking, I had not. We were driving back from her house, from South Tacoma way back to her house. And I was asking her about a conversation she was having with a gentleman inside one of the places we was at. And she just went berserk, started attacking me while I was driving, ripped out my contact out of my eye, scratched my face up. We almost crashed 3 different times. That night, I recorded her screaming and yelling. And then most recently, so there was a death in my family in Tennessee at the latter part of last month. And so prior to that, there have been confrontations. I know she takes anxiety medications. She also said she was taking weight loss medication. I have emails to support this that said it makes her irritable, mood swings or whatever, but because of the, her attacking me, all these accusations, I just told her like, hey, I don't want to, this is done and over with. I'm going to spend time with my family. My family's mourning right now. And I left. Between the 3rd and the 16th, I have not had any contact with her, but she has literally texted me 177 times. She can't call my phone and she can't get on my social media, but she's called me through WhatsApp 150 times. She sent me 20 emails, and inside these emails, she's threatening me. She's telling her kid's father, who's part of a motorcycle gang, what's going on, and she's having meetings with him. She's been to my house twice. She's reached out to my girlfriend multiple times. She's reached out to my girlfriend's kids. She's reached out to my friends. She's threatened to, call my mentors in the real estate world to supposedly take me down. She's posted things on Facebook of the arrest that I told you about, even though there's no conviction and the charges was dismissed. She posted that incident of me being arrested on TikTok and wrote this whole narrative that was just totally false. So I'm here because this needs to stop. I have not contacted her, and what she's doing right now, I feel very uncomfortable with what's going on. I mean, I know she takes anxiety medication. She blames it on her weight loss medication, but she's being completely irrational. And to top all this off, she has a weapon, and I feel totally vulnerable and unsafe.
Let me hear from her. And Ms. Ringner, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. What's your response to what I heard from Mr. Jackson?
So Mr. Jackson, yes, we met back in 2023. I didn't know about Dallas. I didn't know about he was dating another woman long-term also. I didn't know about these women until a year and a half into our relationship. And that's when things started spiraling, is when the lady Bridget messaged me, and Ronnie happened to be sitting in my office. So to back it up, Ronnie is the one that comes to me. So he can sit here and say all of these things that he wants to. I leave Ronnie alone. Ronnie comes to my home. Ronnie comes to my office. Ronnie comes to where I'm at establishments with my friends. So it's quite opposite of what he's saying. So when he put his hands on me back in September, when he went to jail, yes, I went to his house, but he comes to my place all the time. So he can't say, well, you can't come to my house, but I'm only allowed to come to your house. We're in a relationship. So yeah, I was there. Yes, I was pregnant by Ronnie. He can sit here and spin the narrative all he wants to. I showed him the proof of all of that stuff. So from my chart, we talked, we got into an argument the next day, typical normal stuff with Ronnie, deflecting, doesn't want to have accountability for having multiple relationships with women and all of these things. And so he got frustrated and he grabbed me by my ankles, dragging me around. His neighbor in the back saw everything. She was up there with her phone. He motioned like he was going to kick me in my face. He just ragdogged me everywhere. And I said, if you don't stop, I'm going to call the cops. He's like, call him. I got money. I'll bail myself out. So I called him. They came. They arrested him for the video that he showed. The officer came in and said, we're arresting him for the video that he showed because we believe he was the aggressor. So if I was this bad person, I didn't want to leave him alone, then why did I ended up in the ER from him hurting my neck from handling me. So if I was the aggressor and he didn't want nothing to do with me, then why was he calling me from jail, apologizing, taking accountability for stringing me on, for lying to me, for doing all these things? Why did I pick him up from jail, right? That night I took him home. We went and had dinner after he got out of jail. I dropped him back off at home. I came home. I refused to answer his calls. He showed up at my place. So Ronnie is quite the opposite, because he has this toxic relationship with every woman that he's with. So if I'm this person, then why does he keep showing up? I don't beg him to be with me. I move on with my life. He shows up. So, and for the court case that happened back in September where it got dismissed, I wrote the prosecutor and asked them to please not go forward with the case. I was working with a victim advocate through that. So, and then to the incident that happened when we were at an establishment and we got in my car, that month prior, he had already put his hands on me. He was threatening to slap the shit out of me. Listen, Ronnie will come off as he's, this secure man. He's not. He's very jealous. And so we started tussling in my car. I also have voicemails because he's infatuated with phones and things like that. And so he was calling my phone, and I have that voicemail, and I could have submitted that, and I still can, of him that night, October 5th. So the things that he's saying is quite opposite. We talked to each other mutually through WhatsApp. I submitted a video where he was calling me from my home through Alexa. And now all of this makes sense to me, because he was telling me that his girlfriend, who is there now, was his ex, and he started trial on the 22nd of this month for assaulting her and taking her cell phone and her daughter. So he's telling me that I just need you to stay with me. I need you to be with me. I just need to get through this court case. I don't want to be with her. I should have never messed with the girl in Bremerton where my life was, and all of these things, right? So what Ronnie's doing is playing both sides here. And so he can't have it both ways. So back in April, I was fed up because I just felt like things were shifting. He was lying to me. And I said, listen, if you choose to go be with her, go be with her. Leave me alone. Right? He's the one that keeps coming back. So it's really disheartening for him to sit up here and say these things, because he this is the opposite. He's like, no. I said, well, maybe we can reconcile after your court case. This is really hard for me to handle, knowing that you have to be a part of her life when you want me to be a part of yours. I said, let's just pause this. He's like, no, because I know I'll lose you, this and that and this and that. So back on April 12th, something came up, and we were arguing about something, and I threatened to call her and say, you know, I'm just going to tell her that I'm in the picture and all of these things. And he became so irate with me that he you know, physically grabbed me. I started recording, which I have video of that. And I said, I think I submitted it to your court, but I also submitted it to Superior Court, because we have a court case on Friday. So all of these things, I started documenting all of this stuff with him, because I knew that Ronnie does not know how to tell the truth.
Okay, can you stop? Did you say you have a court case in Superior Court also?
So it's a restraining order, and Lacey PD has been trying to
court. You have a court case in Superior Court.
So not a court case. We have a no contact order, right? So a restraining order.
Can you let me answer my question, ma'am?
Yeah, go ahead. Sorry, it's cutting out.
Are you asking for an order against him?
No, I got one out of Pierce County in Superior Court. Lacey PD
Mr. Jackson.
Against Mr. Jackson, yes. So Lacey PD, the judge ordered Lacey PD to serve the restraining order. Lacey PD has been unable to contact Ronnie. He refuses to call them back. So I'm asking the court today why he's there, if he can please be served, because our court date for that is this Friday, the 30th.
Did you know that?
Yeah, I talked to the officer, and I told them that I would be here today at court. I have the voicemail. I talked to her. I told her I would be here today at court. And I told her also that Ms. Ringener was retaliating because I filed for a protection order. Yes, I did talk to them.
Okay.
Judge, and the other thing is, I also filed charges on Ronnie for the assault that happened April 12th and April 20th out of Lakewood. I live out of Lakewood, so it goes to the Lakewood courts. So that's in the process with the prosecutors. And actually, the officer that took the original report met with me again last week for an hour and got additional information from me and more evidence. So at some point, he's going to face charges for those 2 assaults here out of Lakewood. As far as retaliating against him with the restraining order, I let Ronnie know that I was down at at Pierce County Courts putting a restraining order on him. He then went and put one on me. So I don't force Ronnie to be with me. I don't do any of these things. He plays between the 2 women, the 3 women, the 4 women, however many women he has. And he plays victim to this. I don't own a firearm. And even if I did, I would never brandish it or be malicious about it. The only person that has used a weapon against someone is Mr. Jackson, who shot someone and was charged with first-degree murder, found guilty, spent 23 years in prison. And he's only been out 5 years, and he's already put his hands on 4 women since he's been out. He has zero accountability for what he causes and creates. So I don't go beg Ronnie to be with me. He shows up at my home, 1 o'clock in the morning, 3 o'clock in the morning, 5 o'clock in the morning, shows up at my office, all of these things. So it's really disheartening to see here, but I knew that Ronnie was going to come in and spin a narrative to fit him. And that's okay, because whichever way you decide today, Your Honor, I will abide by that. It doesn't affect me if this is on me. It's just another way of him trying to control me if we run into each other or something like that, because Ronnie is super vindictive. And he's already told me that if I crossed him and I put what he's built since he's been out with his real estate at jeopardy, that I would see that dark side of him. His girlfriend, who's sitting in court with him today, I had a conversation with her the day that, I don't know, probably almost 2 weeks ago, maybe. And I told her that I was filing charges, and she said, Ronnie deserves to sit in jail. And maybe that will give him a chance to think about what he's doing. But she also said to me, be careful, I'm glad it's you and not me, because he knows people. So Ronnie is very calculated. So the real estate and public image that Ronnie, the facade is not who Ronnie is in the background. Ronnie, I believe, is a very undiagnosed narcissistic, but he's also very calculated, to the point where he had an issue with one of his general contractors recently within the last 6 or 7 months. And Ronnie, dressed in all black, found his address because he's a real estate agent, found his address, dressed all in black, and went to his house and was standing in his yard. And he laughed about it. And he was sharing that with one of his real estate buddies like it was cool. But that's just the mindset of him. So if he feels threatened that he's about to be exposed or any of those things, this is what he does. He runs this narrative. I have never begged Ronnie to be a part of my life. He continues to come back. And I'm glad that it's unfortunate that it came to this, but I'm glad at the end of the day that it did, because this nightmare for me is over. I just have to worry about my safety going forward in this court cases and this no contact order on him. I don't have to worry about dealing with any of his women anymore. I don't have to worry about dealing with his manipulation, his gaslighting, any of these things that he does. I'm so thankful that I do not have to be a part of that nightmare anymore. So for Ronnie to sit up here and say all of these things, Ronnie blows up my phone, but more or less Ronnie will show up to wherever I'm at. So he's also threatened to send an intimate video of him and I to my minor child because I wasn't answering his phone, in which I submitted all of that to the court, the text messages and things like that. I also witnessed him punch his girlfriend who's sitting in the court with him today. He's in cases with her in Kitsap County right now, and her daughter. So for him to sit here and try to spin a narrative about I'm this awful person and things like that, that's who Ronnie is. At the end of the day, I know the truth. He knows the truth. He's spinning a narrative to try to save his image. But the image is he's very twisted. He's very cruel. And I'm just glad that I do not have to be a part of this toxicity and all of these things that he has going on in his life. Ronnie's never going to change who he is. His girlfriend that he's with now is going to have to deal with other women. And I feel sorry for those other women that cross paths with him, because they have no idea what is going to happen in their life and what he is going to do. So again, Your Honor, whatever you decide is not going to affect me, because I have no intentions of ever having anything to do with him. He's an abuser, mentally, physically, emotionally, and he sees nothing wrong with it. And he gaslights you to justify, I've been in prison for 23 years. This is why I act this way, or I don't take accountability. He's a 50-year-old man, but he takes zero accountability. And so the public image and the private Ronnie are completely, completely different. Is there toxicity in our relationship? Yeah. But you know where the toxicity came from? All of the lies, the cheating, and everything that he's done and created in this relationship. So I don't really have nothing else to add to that. I just want to make sure that he is getting served while he's there, because we do have court on Friday morning in Superior Court for this, for my restraining order. So I'm just asking the courts to please make sure that he is served with his restraining order while he's there today, since Lacey PD was having difficulty getting a hold of him since the 17th.
Okay, so there's a couple things. I'm going to kind of work backwards there. You know, I'm not really, I can tell him when the court date is, but I can't serve him, because it wouldn't be appropriate for me to do that. And combined with the fact that I don't have, I don't have the documents to serve him with. I will tell him that there is a court date. Were you aware of that court date?
Yes.
Okay, and what day, what time is it?
I have no idea.
Okay, what day is it?
I believe it's the 30th.
Okay, so ma'am, just answer the one question. What day and time is your court hearing?
The 30th at 8:30 in the morning.
Okay, so you need to be in Pierce County Superior Court at 8:30 on May 30th. All right.
Okay.
And so I've listened to the testimony, reviewed the file based on, I've heard Mr. Jackson testify. I've heard Ms. Ringner testify. You know, she said the one word that kind of came up is that she had mentioned a couple times, which I tend to agree with, is toxic. And it seems to me like this seems to go both ways. This might be one of those instances where no contact orders are appropriate both ways, where both parties need to stay away from each other. And so, but the only one in front of me right now is Mr. Jackson's petition against Ms. Ringner. I am going to grant the order. It's going to be in place for 1 year. And so, ma'am, you're just not to contact him. And so, which kind of sounds like what you want. And
absolutely.
Jackson, again, I'm not going to think too much of it. I have no, I'm not following you folks around. I don't know what's happening. I hear one story from here, I hear another from her. But even though you're not part of this order, it wouldn't be a very good look for you to go track her down and make any contact for her if you start to use this offensively, which people do sometimes. You're going to be subject to a court hearing in Pierce County, and if an order is entered there, you'll be expected to comply with it. And like I say, I think it's clear to me that you folks just need to flat stay away from each other. But I'll grant the order here today. You can wait, you can get a copy of it. And then Ms. Ringner, you're free to go. And then, did she provide an email where we can email it?
No.
You have an email where we could send the copy of the order, and you can
Yes,
put it in. Or you can get it off the Thurston County District Court website.
Okay.
And if you want to get it off the District Court website, you're free to go. We'll give you a
All right.
copy of the order. Now it'll be in place for 1 year.
Perfect. Thank you.
Sure. Then Ms. Meach, I'll have you come back up. So Ms. Meach, raise your right hand, please. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
How is it you need an order against Ms. Cole?
So can I talk about what she wrote?
I want you, you're asking for an order. Tell me why you want
Okay,
one.
so, I have never broken into her home. I have not harassed her. This harassment started last year, October 1st. She knew we were not friends no more. I stopped being friends with her due to the emotional and mental abuse she caused me while we were living together. And she's irresponsible. We had a phone plan together. She didn't pay her bill. I cut her phone off, told her I didn't want to be friends with her no more, that this just couldn't go on no more. October 1st, she texted me. I replied back. She wouldn't stop, so I just stopped texting her. I blocked the number. October 3rd, she texted me off of a different number. I didn't respond at all. I blocked the number. October 5th, she texts me again off of a different number. So then I proceed to block that number. So then I started receiving phone calls October 10th of 2024 from multiple different numbers from Jordan. 3 different numbers from her. And then one of the numbers was actually, she's a caregiver for the state. It was her client's mom's phone number, because I had their number saved in my phone from when I would go over there when we were friends. The harassment, calling and calling constantly from different numbers didn't stop until February 22nd. And that was due to me changing my phone number. I feel like if I wouldn't have changed my phone number, the phone calls would have continued to happen from multiple different numbers. On April 3rd, I was coming back from Port Angeles. I went to Port Angeles to visit my sister and my niece for spring break. I was at the bus station. I had about a 25-minute wait until the bus to Olympia.
This was in Shelton?
Yeah, this was in Shelton at the transit center.
Where she lives?
Yeah, where she lives. I was waiting for the bus to go back home. And all of a sudden, I see her rolling past me and she starts screaming things out her window. She called me the B word. She said, you're a dirty B. Stop talking to my ex-boyfriend, you B. And I yelled back and I said, leave me alone. You're the one that's dirty. I don't want to talk to you. So then she had turned up the road. So mind you, when she's yelling this stuff at me, her client's in the van with her. So she leaves for roughly 2 minutes. I see her come back. So when she comes back, she's coming from the opposite direction of the Safeway parking lot. And that's with one of the videos that I submitted. Rolling down, she turns into the parking lot, and you can see on the other side of her fence that she stops her van right there. And I'm at the bus station and she can clearly see me. And then she starts driving and she leaves Well, she comes back after she leaves for a third time, and she parks in the Safeway parking lot and just sits there, knowing that I'm at the transit station, knowing that I don't drive and that I catch buses to go where I need to go. She stood there. I have proof. There's a picture of me standing at the Shelton bus station that she took while she was sitting in the parking lot. And in the video that I sent you of her just sitting in the parking lot, you know, being parked, you can see in the video that she pulls her phone out of the window and takes a picture of me. I'm like, why? So that's why I recorded, because I was like, I felt harassed.
And when was this? This is in February?
This was April 3rd. And then April 8th, I didn't actually know that I'd received this Facebook message until a week later, but on April 8th, someone by the name Jasmine Turner messaged me on Facebook. Well, the very first picture that she sent me was a picture of her bathroom. That's how I know it's her. It's not this Jasmine girl. She made a fake Facebook profile to hit me up and harass me. Also, how I know she's been harassing me is one of the pictures in the TikTok video she was posting about me, saying horrible things about me, humiliating things that weren't even true, was actually my Facebook profile picture. I changed it to that on February 1st. And she made that post February 2nd. So I feel like in a sense, she's also stalking me. I am going through a lot of emotional distress. She knows that I have mental health disabilities. She's very aware that I'm in a vulnerable state in my life because I lost my dad not like a couple years ago, but it's still fresh to me. And I don't have my mom. She decided to text her ex-boyfriend that she's talking about in here. He actually sent me screenshots of her sending messages to random men. And these photos have my 7-year-old son and my 8-year-old niece in it. She don't know these random guys that she's sending their pictures to. So she's endangering my child's safety and my niece's safety at this point. The reason why I want to put this protection order on her is because I want the harassment to stop. I want her to stop going on social media and cyberbullying me. My son is a vulnerable kid. He has disabilities and he's scared. Every night before he goes to bed, he asks me, Mom, is the door locked? Are we safe? That makes me feel horrible that this person is affecting my child's well-being and his mental state. My child was with me when she was screaming at me outside her window door, April 3rd, when that incident happened.
The Shelton bus?
Yeah, my son was there with me. And he was scared when we got on the bus. He's like, Mom, we're not going to see Jordan anymore, are we? She scares me. I feel like she's going to hurt us. And I'm like, I will make sure that won't happen. I was like, I'm going to try to put a no contact order on her. But he's terrified to the point where I have to deal with that every night of him asking, Mom, did you make sure to lock the door? Are we safe? And on Sunday, I ordered some cameras. They're being delivered to my apartment. I'm setting cameras up. I got the okay by my landlord. Also, something recent did happen. Saturday, me and my son had left. We went to the park and then we went to dinner together. I come back and there's dents on my door that weren't there prior. So she is the only person that I know that has an issue with me. Like, I just moved to Olympia 8 months ago. I know her. She knows where I live. She helped me move my stuff there when we were okay. And then I have 3 other homegirls, but I don't have no issues with them. They have no reason to come to my apartment and put dents in my my front door.
Okay, hang on a second. Ms. Cole, I need you to position your camera where I can see you. Thank you. It's important to me to know that you're on the Zoom call.
There was an incident February 2nd. She had called me from a 564 number. And then my son had come to me. He's like, here, Mom, like, you have a missed call. So I looked, I had a missed call from a 564 number on February 2nd. So February 9th is when my son came to me and he was like, you have a missed call, Mom. So I called that number back thinking, okay, maybe it's an important phone call. And they didn't answer. So then the 564 number called back and it was her. She was like, what are you doing calling me? I was like, you're the one that called me on February 2nd. I was like, stop calling me, stop harassing me. There's no reason for this. I've left you alone. I have not said nothing about her on social media. I have not said nothing about her that is bullying or in a negative way. It's people coming to me and telling me what she's saying behind my back. And then I have, of course, proof to prove what she's saying about me are lies. And that's why she's upset, is because she's going to people telling them that I never did anything when I lived with her. I was lazy. I was the reason why her house was a mess. I broke her couch and broke her floor, which I'm sorry, but there's no possible way for me to do. But I sent them.
Let me hear from her, ma'am.
Okay.
So Ms. Cole, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, I'll hear from you. She says you're calling her all the time, and there was an incident down there, which I read about in the petition at the Shelton bus stop, where you kind of got on her a little bit, and so go ahead. I'll hear from
Okay,
you.
so that incident, I actually have proof. My client has there's a, what is it called? The doctor's office right there.
Right.
So we went to the doctor's office for her, and then we left down to her bank.
Out the window, she said.
I was not doing anything. My nephew was in the car with me. I wouldn't use profanity with my nephew in the car. The reason why I took a picture of her is because she was taking a picture of me, and I was on the phone with my ex-boyfriend, and he said, well, she's been telling me that she was going to put her hands on you. So I had evidence of, just in case she tried to run up on me, because she does have a violent history. I've seen her fight people before, but that's a different story, different time. But that day where she seen me, I had running around to do. It was around the first of the month, and my client and I had bills to pay. And I'm sorry, I live in Shelton, so all my stuff is in Shelton. So I have to go from the doctor's office to the bank, to the other bank, to the other bank, and then we went to get Domino's, and then we wanted something to drink, and then we did a whole bunch that day. So it wasn't me harassing her. It was me trying to figure out what we were doing at the time. So in the time crunch, because I had to bring my nephew back to Bremerton where he lives. I was not stalking her. I wasn't harassing her. I have random people telling me she's giving my address out. I want one on her as much as she wants one on me. The whole time that she said that my client's mom was contacting her, that wasn't me. She's an elderly lady. I want nothing to do with Rhonda or her child. It's causing PTSD in my life and my friend's life, and she's getting into my relationship, causing trauma between me and him. I just want it to be over with. It's causing too much. This is like high school drama that doesn't need to be. She just needs to leave me alone. I need to leave her alone. And then she said something about Saturday. I was out in Aberdeen visiting my fiance on Saturday. I have witnesses and proof of that. I just want to be left alone as much as she wants to be left alone. She keeps my friends keep contacting me, telling me she talked about my house, showing pictures of my house when I used to live a mess before I got my house. My house is still in the process of getting remodeled. Just a whole bunch, I don't know. It's just all nonsense, drama. She needs to leave me alone. I need to leave her alone. I left her alone. She just needs to leave me alone. She needs to stop contacting my ex, which is my friend. I don't know. I'm just over all this. It's anxiety. I'm a vulnerable adult. I have a learning disability, so some of the stuff she's saying I can't comprehend very well. And I haven't been the same ever since I lost my brother. So.
Okay. Well, I agree with you on a couple of things. First of all, you referred to this as kind of like high school drama, which is kind of true. You also said, I need to leave her alone. She needs to leave me alone. I agree with that also. The only thing in front of me here right now is her request for an order against you based on the testimony combined with what's filing. At this time, I'm going to grant that order. You're just not to contact her in any way.
And I do have a question on that too, because I have,
Can you let
sorry.
Could you place.
Yep.
And again, that's based on the pattern established by Ms. Meach. And, you know, if you feel like you assemble evidence that requires an order against her from doing things that you don't approve of her contacting you, you're free to do that. Sounds like you tried to do that once, it didn't happen, but if additional things develop that you think it's appropriate to get an order against her, you are certainly free to do that. But based
Yeah.
out, this is just going to make I'm drawing a bright line here to make your life easier. She's just not a part of your life. There's not something, you don't post anything on Facebook about her or any other social media site. There's no reason for you to talk to mutual acquaintances. Apparently you were friends at one time, but clearly no longer now. But you just need to move on. She's just not a part of your life in any way, shape, or form. There's nothing to comment on.
Okay, yeah. I'll ask somebody else. But all right, thank you.
Welcome. You can get a copy of that off the district court website. Ma'am, we'll give you a copy of that right now.
And how long is this order?
1 year.
All right, thank you.
And then Ms. Lowe could come on up. And then Ms. Ehart and Ms. Alderson Potter can come on the Zoom call, please. So these are two separate orders. And then Ms. Ehart, am I saying your name correctly, first of all?
Yes.
And I'm here this morning to handle a couple of conflict cases that Judge Meyer couldn't hear. So I'm going to start with those. The first one that I have is Peterson versus Kernodle. Is Brian Peterson present? All right. Yeah. Would you have a seat at the table there, sir? Right. And then I see that Mr. Cover is representing Mr. Kernodle. And this is number 25-138. And I want to ask before we do anything else, are the parties ready to proceed today? Are you ready, Mr. Peterson?
Yes, sir.
Okay. And Mr. Cover, are you ready as well?
We're ready, Your Honor. Thank you.
Okay. Then I do intend to go forward on this matter, but I do also want to address another matter that I did not realize I was going to be here for today. But I want to check in with the parties and see what their state of readiness is. So that's Daniel and Sarah Funey. You're here and you're ready? Yes, sir. Okay. And the respondent in that case is Mike Burnham. Okay. And Mr. Burnham, are you ready to hear that case too? Okay. I'm going to tell you ahead of time here that I'm not as familiar with your case because I didn't know ahead of time that I'd be hearing that one as well. So I will be hearing from the parties, but all right. So we'll go back to Peterson and Kernodle then. Thank you, sir. So this 25-138, Mr. Peterson is representing himself. Mr. Kernodle is present with counsel, Mr. Cover. Mr. Peterson, you're the petitioner in the case. So you're going to present your case first. They'll just give you both here a little bit of an outline because I want you to know what to expect. There we go. Trying to get my electronic file to open up. I think I finally had some success here. All right. I want the parties to know, generally speaking, I follow the statute that governs these petitions, and that the statute generally inclines the court toward hearing and deciding the case based on declarations and not so much live testimony. I also want to make sure the parties understand it's not necessary for you to repeat everything that you've already provided to the court in writing. And if there are additional matters that you haven't provided notice to the other party for, that may result in a delay of your case. So if you brought things with you that have not previously been disclosed to the court or to the other party, that may cause a delay that you didn't expect to happen. It's also possible that I could decide the case even if there's new material that hasn't previously been disclosed, if that's what the parties want me to do. All right, so we'll get started here. First of all, Mr. Peterson, can I have you raise your right hand, please? And do you swear the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Peterson, go right ahead, sir.
Yeah, I got this restraining order because this has been an ongoing thing with this guy. He flips me off every time he sees me. His wife flips me off even when my kids are with me. I don't know if you guys got a copy of the police report, but I was assaulted, shoved, punched in the face, and then Mr. Knuddle apparently went for a gun. And he hasn't been, I think it's into the prosecutors right now, but they're deciding if they're gonna file charges against him, but it's all on video. I mean, I have the police report right here. I don't know if you have a copy of it.
Well, Mr. Peterson, I want to make sure you understand that the court doesn't do any research or seek out any evidence of its own.
Okay.
So we haven't gone out to get anything or conduct an investigation of your
Yes, sir.
case. All that there is in your case and all that's part of the record is what you've provided to the court and what Mr. Kernodle's provided to the court or will provide today. So what I have is what you filed with the
Yes,
court
sir.
previously. And that includes your allegation that on, I believe it's May 5th, that Mr. Kernodle had assaulted you by punching you and that he had at least partially revealed a gun that he retrieved from a vehicle.
Yeah, it's all on video surveillance.
There isn't any video because you didn't provide any of that. So
They wouldn't give it to me.
I just want you to know, if you're referring to other matters outside the record, those things are not going to be part of how I decide the case.
Okay.
Okay. But I am aware, though, of the allegations that you did make here in writing when you originally filed this case. And then if you want to expand on that or give me additional
That's all I have
details
to
on
say
that.
about it. I just want to be left alone by the guy.
All right. And you said that your relationship or previous relationship was competing business owners. Is that
I
what
work for
understand?
his wife or his girlfriend is a Nisqually tribal member. And they're business owners. Technically not, because all their stuff's expired, but he said not, I can't be turning any of that in. But anyway, so yeah, I was subcontracting down there and getting bids and he wasn't, so he hasn't liked me since then. And then they offered me a job, so I work for the tribe now.
Mm-hmm.
I no longer have my business.
Okay. Does your work bring you into contact with Mr. Kernodle at all?
Just at the fuel stations. Well, he's down there because his wife's a native, so yeah.
Okay.
I said, I just want to be left alone. That's it.
Sure.
But you're not 7-year-old and a 9-year-old. I'm just trying to live my life.
You and Mr. Kernodle aren't neighbors or anything like that?
No, sir.
Okay. You worked in the same industry and that sort of thing?
Yeah.
Okay. So what precipitated this contact on May 5th? How did this come about?
So I haven't seen him in a while, and I've seen him in the store. I asked him if he got a new trailer. He says, don't talk to me, punk. I said, I think I might have called him boy. He goes, oh, let's take it out to the park. Let's take this outside. And then I immediately, when I got my stuff, I went directly to my truck. I didn't look at him at all. Didn't stare at him. He runs over to me. It's all documented, so you guys just don't have it yet. But anyway, he comes over, shoves me, punches me in the face, and then he thinks he's getting jumped, so he runs to his truck and appeared to be grabbing a gun. He says, I got something for all of you.
Mm-hmm.
And that was it. Then he takes off.
Okay. And that's kind of what got you here. That's what got you to file
Yes, sir.
this. Yes, sir. Okay. Is there anything else you feel like I need to know before I hear from Mr. Knodel? No, go ahead. Okay, Mr. Cover, I'll let you present that in any way that you'd like.
Thank you, Your Honor. Frankly, this is a nuisance case about gossip. We're not in receipt of any sort of police report. We're not in receipt of any sort of footage. There were comments made in court last time there was some sort of case going. I looked at the jabs. I asked the court to please look at the jabs. There are no pending matters related to any of this. Not sure what's on that police report. It's all hearsay. According to my understanding, I used to be the prosecutor out there, is there's not a police report and not a case. Your Honor, the allegation here is, for all intents and purposes, assault in the second degree with a deadly weapon. And we have nothing. We have the word of Mr. Peterson. We don't have his word that his children were actually present, though he saw fit to add his children to the protection order. Your Honor, on page 3 of the petition, it states their relationship. They're competing business owners, and that is the real crux of the issue here. Your Honor, I'm also, I'm just looking at the allegations that were made here. Your Honor, first of all, there's no pattern of harassment here. And if there was, we just heard Mr. Peterson say that he was the one to approach Mr. Knodel. We also heard Mr. Peterson say that Mr. Knodel thought he was going to be jumped. And the reason for that is because Mr. Peterson had his work crew with him, but none of them are here to offer any declarations, to offer any statements, to offer anything to support the gossip that has been put before the court. Your Honor, it frankly just doesn't meet the standard for an exception order. And I would suggest to Mr. Peterson that if he wouldn't have approached Mr. Knodel, there would have been no encounter at all. Your Honor, and really that's the only thing that happened according to the record that we have, is that Mr. Peterson was bothering Mr. Knodel again, as he has done over a period of time. He has walked around the Nisqually tribe gossiping about what allegedly happened here, but he put nothing before the court. I don't think I need to belabor this anymore. We don't have enough here to show that there was any annoying, alarming, harassing conduct engaged in by Mr. Knodel. Frankly, the annoying, alarming, harassing conduct was engaged in by Mr. Peterson and his crew. But we didn't feel the need to call the court about that. And I'll be here if anybody wants to do something about that police report. But that was 22 days ago. I asked the court to deny Mr. Peterson's petition, and I yield back. Thank you.
Okay. Well, I'm not obviously going to make this decision based on what may happen with any prosecution that could come later once a police report is given to a prosecuting attorney's office. Maybe it already has been, I don't know, but they're going to make their decision independently. I'm really concerned about the allegations here that Mr. Peterson has raised, because they're substantial, and if true, then they would be potentially a basis to issue an anti-harassment order. Mr. Peterson has alleged that Mr. Knodel physically assaulted him, and then he also alleges that essentially as part of the same transaction that Mr. Knodel displayed firearm as part of a threat towards him. And of course, that's significant. And Mr. Cover made reference to that those could be felony crimes, and those could potentially cause a prosecutor to file those charges in Superior Court. And that may happen. Like I said, I don't know. That's a decision for another entity to make, not this court. But what I have to do is decide whether, by a preponderance of the evidence, that Mr. Peterson has proved that unlawful harassment has occurred. And he can do that by establishing a course of conduct that reasonably leads to him being, placed in fear or intimidated that any threats might be carried out. But another way he can do that is to allege that a firearm was displayed without then going on to show that there was a course of conduct or a pattern. And again, if I'm persuaded by preponderance of the evidence, then that would be a basis to issue the order. And Mr. Kernodle, on the other hand, denies that he did these things and further says that the only reason that Mr. Peterson brings these allegations today is because there's hostility between the parties based on them being competing in the same business. Based on what I've heard here today, what I've read in the petition that's previously been filed, I do find by preponderance of the evidence that unlawful harassment has occurred because there was a physical assault and a display of a firearm. So I am going to find that there's a basis to issue an anti-harassment order, and I'm going to do that. So I'm going to execute the order now. Mr. Peterson, you will not have to serve this order any further on Mr. Kernodle. He's here in court today.
Your Honor, so if my, you know what, never mind, we'll handle the next step. Thank you, Your Honor. Your Honor, I just need to ask, on what basis is the court making a finding that a firearm was used?
Based on testimony of Mr. Peterson.
All right, great, thank you.
I'm further ordering that Mr. Kernodle surrender any firearms in his possession, both because he did, according to my findings, display a firearm, and he is a person who is ineligible to possess firearms under the law due to previous convictions.
Your Honor, I'm also asking for the same terms as the temporary protection order, that he may purchase fuel at the Nisqually markets on the Nisqually reservation as long as he has no hostile contact with Mr. Peterson.
I'm having trouble hearing you there. Your audio was kind of cutting in and out.
Your Honor, I'm asking that your order be made on the same terms as the temporary order, that Mr. Kernodle be allowed to obtain fuel at any Nisqually market and have no hostile contact with Mr. Peterson.
Yeah, I'll make a notation then.
Can I add to that, sir?
Sure.
So he asked Judge Meyer to restrain the order to get fuel at the Nisqually markets because they're business owners, but I did some research. They don't have a bond insurance, and they didn't renew their business license also. So.
Doesn't matter. He's the spouse of a tribal member. He's got more right than any non-Indian to be there.
That's fine. Like I said, I just want to be left alone. That's it.
Okay. Yeah, I've added that.
Thank you, Your Honor.
The orders issued, we'll give you a copy of that since you're here, Mr. Peterson. And we'll prepare. We're going to prepare and send a copy of the order to surrender firearms. This order is effective for the next year.
Thank you.
Yes, Your Honor. I'll watch the email.
Because of the feedback. It's almost like there's a secondary sound source coming from underneath the desk.
This one?
Thank you.
Okay, then I do intend to go forward on this matter, but I do also want to address another matter that I did not realize I was gonna be here for today. But I want to check in with the parties and see what their state of readiness is. So that's Daniel and Sarah Funey. You're here and you're ready? Yes, sir. Okay. And the respondent in that case is Mike Burnham. Okay. And Mr. Burnham, are you ready to hear that case too? Okay. I'm going to tell you ahead of time here that I'm not as familiar with your case because I didn't know ahead of time that I'd be hearing that one as well. So I will be hearing from the parties, but all right. So we'll go back to Peterson and Kernodle then. Thank you, sir. So this 20. Good to go. Okay. All right, then let's go back to Funey and Vernum. You can come up to the table, both of you. And this is number 25-144. And you're Mr. Vernum?
Yes, sir.
All right, and you are the Funeys. Am I saying your name right?
Yes, sir.
Okay. Now the Funeys are the petitioners in this case, and Mr. Vernum, you're the respondent. And Mr. Vernum, can I confirm with you that you have received the petition that was filed by the Funeys along with the notice for the court date?
Yeah, I got it all in here.
Okay, very good. And are you ready to proceed with the hearing today?
Yeah.
Okay, very good. All right, then I'm going to get started. I'm hearing that coming up. Just a second. I'm having a little technical issue here. There's a source of sound coming out. Here's something. So we're going to do a little mic check right now. So we're having some technical issues with the sound, so just bear with me.
I'm sorry.
That might be better. Okay, appreciate it. All right, that's a little bit better. All right, Mr. Vernum, I see you seem to be struggling to hear. Do you want a hearing assistance device?
That won't help me, sir. I have a really bad ringing in my ears from a fall that I had in 12.
Okay.
And
yeah, we've got, they're like
they don't work,
earmuffs that they won't work for you. Okay. All right. All right, where did I leave off? All right, I was going to swear the parties in and let the Funeys start, and then I'll hear your response and Mr. Vernum, and then make a decision. So can I have all three of you raise your right hands, please? Do each of you swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Sir, yes.
Okay. All right, so Mr. and Mrs. Funey, you are the petitioners in this case. I'll let you present your case first.
Okay. Well, this all really started to come about when Mr. Vernum could not stop killing animals in our yard. My wife and I have witnessed him shooting animals in our yard on multiple occasions. We had to stop having contact with him. At that point, he decided we were his enemy and went to all our neighbors to slander us, saying I'm a racist, that I beat my wife. He proceeds to constantly, openly flip us off and grab his crotch. He lives right across the street from us. So when we come out in our yard, he comes out, he berates us with insults, calling my wife a whore, calling me a felon. This is on a daily basis. He is, I mean, this is just a tip of iceberg, actually. We've lived across the street from him for 20 years, and we've been trying to avoid any conflict with our neighbors and trying to keep peace in the neighborhood. And Under the direction of sheriffs and my attorney, I'm here today to get a restraining order. Mr. Vernum decided that he would come out at 5 a.m. in the morning in the dark to intimidate my wife 4 days in a row. At 5 in the morning, he stood on the corner of his property where my wife has to pull up to the stop sign, flipping her off 2 days in a row. I installed cameras to catch that. And then he went out there in the same spot and put up a sign that said "whore." And immediately after she passed, he took the sign down. I told my other neighbor that we're all on a corner here at the stop sign about it. And she came out and she also witnessed him do that, put the sign out and then take it down right after she passed. He thinks his First Amendment rights allows him to invoke violence and provoke people. And I think the court knows that's not the case. And I would like them to grant this restraining order to protect myself and my wife because we are in fear of our lives. Not only does he have weapons, but he has used them.
And Mrs. Feeney, would you like to say anything?
Yes.
Add anything?
He's intimidating my family. He yells and tells people that walk by that we're racist. I feel like I have to have my phone on record when I'm leaving to go to work every morning. He is continuously harassed. There's not much more than what my husband has said that I absolutely fully agree with 100%.
And even with
he has a problem with authority. He disrespects authority. I just want to live in my home or in my yard with peace, be able to do my yard work without hearing him yell "whore" from across the street, talking to people that walk by, yelling "whore," calling us racist. And I want it to stop. That's all I have to say, Your Honor.
I'd like to add that after he was served a restraining order, he had no problem disrespecting the court and breaking the restraining order every day since. We have video footage. We didn't get a chance to submit it, but we do have it every day, berating us, saying whatever he wants.
All right, before I hear from Mr. Vernum, is there anything you feel like you left out or anything you need
I
to?
do want to add one more thing. The day that he shot at a cat that was in my driveway, it did damage my garage door, and my kitchen window is 2 to 3 feet from that garage door. So every time I do dishes, I feel like I have to keep an eye out to make sure that the shooting doesn't happen again and I get shot.
Okay, Mr. Vernum, I'm gonna turn it over to you to tell me your side of it before I make a
Your Honor, you
decision.
see this? Okay, I got a sign I made in 14 and hung in 15. I've been hanging them since. I got a witness here that's done that. First of all, if I may approach the bench, I have witness statements here on things. I'd like the court to read these today, please.
Are these things that you filed in the court file yet?
I just got this Friday, Your Honor. Okay. One of these is where he threatened to pull a gun on an African-American in front of my house the other day. One of these is where an 86-year-old neighbor of mine stopped in front of his house. He called her a whore. This is where this whore thing started, Your Honor. And he come out and he chest butted me 3 times in front of this woman, and I was trying to protect her. I've been making Trump signs and I hate Democrats. That's what this is all about for me. This man come in, when he moved into our neighborhood the first week, it was a Friday at 6:30, I heard yelling in my garage. And I just got my son out of rehab because my daughter had just been butchered. 19 times she was stabbed. And he started drinking and he wanted to fight. This hand right here is broke because I slammed it into the wall, so I didn't have to fight my son. I can't do much with this hand. It's deformed. In October 13th, after my son had killed himself, 7 years after, 10 years, 8 months, 4 days, and 7.5 hours after his sister, This man came over to my house. I'd been in the hospital prior and the doctors told me to quit taking the medication group death was giving me. It was killing my gut. So I started smoking pot. I hadn't smoked it since the 80s. And I was getting it from a friend of my son's that I've known. This guy sells pot. So he told me when we were kind of friends that I could buy it from him. One day he found out that I was buying pot from my friend Josh, and he come over, and that's why this arm's bad. He ripped this arm out of the socket. I went to get the phone. I went to call 911. He grabbed the phone out of my hand and crushed this and slammed the phone and threw me on the ground. He broke my false teeth. I had to glue this up here. I went to Sybil's house to use her phone. She wasn't there. When I came home, he was gone. 2 minutes later, his woman is on her knees begging me not to call the law on him. Begging me, please don't. Because he's a felon, Your Honor. I don't have a criminal record. I've never been in trouble. I'm 68 years old. I got a harassment order on me from a lie from some punk in my neighborhood that pulled a gun on me. Now, I told him after the incident where he ripped my arm out, I tried appeasing him. And then one day he come over and he wanted to know if he could use my backyard to park cars because he works on cars. So I let him. And then I find out that he's being audited by the Department of Revenue where I work. And he wanted me to talk to one of my revenue employee friends to see if we could get this thing dismissed. And I told him to get off my property. And I haven't spoke to him since 2020, January. And as he left my yard with his trailer, he ran my gate over and never even offered. Now, I did shoot a cat in the yard. It killed 3 of my birds. And I apologized to him. I said, I'm sorry. It won't happen again. And I'll pay for any damages. And nothing was up. This was years ago. Now, I'm making signs and I'm going home. I dislike Democrats. I put them up for all politicians. And I can go home and make a sign that says your name on it, Judge, because you're a public figure. I do it. This is what I've been doing. I wish you would really read this where she put in here about him threatening an African American a few weeks ago. I saw this. He threatened him with a gun and called him the N-word. My great-great-grandmother was African, and I'm proud of that. I have Lakota Sioux and Apache blood in me. And this guy is a racist. I know you won't read this?
You can bring him up and give him to the clerk.
You won't read it?
No, I'm going to take a look at it.
Now, he was part of this. I've lived in my house 46 years. I'm going to be going on my 47th. I'm dying right now because of what happened to my children. And I don't really care if I die. I've lost my immune system shot. That's why my teeth fell out. In 2006, and he was part of this, 2 of my other neighbors got together and got a harassment order or something and lied about my daughter's dog, said it was killing other animals, and he was part of this. And they all split and they lied. They all lied. And I'm still living here. They're all gone. He's turning my neighbors against me. My neighbor Sybil, who he was talking about, I do carpentry work. That's what I do. I fix things. And this is what they bought me 2 years ago when I fixed kitchen cabinets for them that they couldn't find. And now this woman that gave me this shirt, he's turned against me. Her husband is one of the ones that lied and had my daughter's dog killed, murdered, as I say it. And you see, I had all my neighbors backing me then. I got nobody backing me now except Marie. Marie knows me. She's known me since 15. We're just friends. My other neighbor that he's talking about, that Sybil, I've been mowing her lawn for 15 plus years, and now I can't mow it. I've been putting my garbage in her garbage. I can't put my garbage in there anymore. So the other month and a half ago, I went to my friend Brian, who I've known for 60 years. And he said, yeah, put your garbage in there, no problem. Saturday, I went to get him to come to court here, and he was going to go with me. An hour and a half later, he told me, get the F off my property. I never want to see. This is a man I've known for 60 years. And now all of a sudden, he doesn't want me around. That doesn't make sense, Your Honor. This guy scares people. He threatens them. He's threatened me. He did this to my arm, Your Honor. I mean, I heard it as an L&I accident on November 3rd of 13, and it was almost healed up. I can't ride my bike. I can't do nothing because of this and this. I have 3 collapsed discs. I have what they call IBS. Do you know what that is, Your Honor? And I have a bacterial infection in my intestine that has put me in the hospital many times. And there's no cure for it except death. And right now it's going crazy on me. My prostrate is double the size of what a normal prostrate is. And they're giving me medication for that too. But it's not working because of what this guy's doing. I have, like I did to Judge Buckley in 6, I'm using my First Amendment right to make signs. I do not use anybody's name. And as far as standing out in front of my yard, I go out at 4 or 5 in the morning to move my truck out of my driveway because my house has been hit 7 times because of this. My garage door bashed in, my truck bashed in, and all my signs taken. Marie can tell you that. So I protect my truck, but I go out in the morning because that's the best time to look at the dippers right in front of my house, right above my front door. And that's what my children and I used to do when they were little. And that's what brings me in touch with my children, if that makes any sense to you. But as far as harassing them, no, I don't talk to them. I haven't spoken. They sit in their kitchen window and do this. I can't whistle right now. And they make little cat calls. I clean my yard up. I do my flowers almost every day, weed. And they sit there and they make all these noises at me. And then when I go to Rachel and Dave's house, they stand there and they go, why are you still living here? Nobody loves you. And you know what that is a reference to, Your Honor? He's making fun of my dead children. But I didn't do nothing. I never said nothing. And I'm going on the First Amendment. That's what I'm doing in my front yard, is my First Amendment right to express myself without any violence at all. No violence. This guy's the violent one. This guy. He's yeah, I mean, look at his, I mean, when I had Fred pull his rap sheet in 04, I couldn't believe what he had been in trouble for. I mean, this guy's a psycho. He doesn't care about anybody else. He chased a kid one day that rode his bicycle through his yard. The kid fell off his bike, got road burns. 5 minutes later, this big burly man in army fatigues came up. And a bunch of these little kids, he used the N-word because his kids were white and black in front of this guy and pissed him off. And this guy picked up a rock the size of his hat and was going to throw it at Dan. And I spoke up and said, I can't believe you're doing this. And I had to speak up for him because it was wrong what the GI was doing, going to throw the rock at him. This guy uses the N-word like it's his vocabulary. And he don't care about hurting anybody. It's ludicrous. Like I said, I've lived 46 years in my house. Both my kids are dead. And you don't have, there's nothing. I haven't been violent towards anybody. In 1990, I was kicked out for molesting my kids because my wife got tied up with some jerk out of California. Somebody like him, a felon. And I won my kids. I fought and raised them by myself until my daughter was murdered, and then everything just fell apart. everything. And I tried with my son to keep him alive. I tried and I tried, but he blew his brains out. And that's all I've got to say. You guys are probably gonna, I'm going on the First Amendment, Your Honor. That's all I got to say.
All right, thank you, Mr. Burnham. Okay, well, Mr.
Hold
Burnham,
it.
I want
Marie,
you
would you
to,
like to speak for me? You don't have to if you don't want to.
I just want to know, I've known him all those years and we've never had any issues or anything, you know, he's always been courteous to me and, you know, nothing. And we're just friends. I live down the road from him with my daughter.
thank you, ma'am.
Thank you.
Right. Mr. Burnham, there's not gonna be any decision made that's based on your signs. There's nothing about that that affects the decision that I make regarding this. It's my scope of a decision here doesn't have anything to do with your politics or anything to do with the signs you make or how you.
That's what this is about. It depreciates the value of his house, he tells everybody, Your Honor.
Yeah, Mr. Burnham, at this point in the case, this is where I speak and where I'm tell you
sorry.
my decision, and I expect to not be interrupted.
I apologize.
Thank you, sir. Right, so in this case, it's clear to me at least by preponderance of the evidence that there has been harassment going on, that Mr. Burnham has repeatedly over a course of time contacted especially Mrs. Funey with the express purpose of alarming, harassing, intimidating, and annoying her. And it is manifestly obvious that it's had a reasonable effect on her, or it's had an effect on her that is reasonable.
My signs don't quit. You can give me a restraining order if you want. You do it all. I don't care. I'm going home and I'm doing it democratically, okay? I didn't touch this woman and I never said a word to her.
Mr. Burnham, if
she calls me an old man.
Mr. Burnham, you're out of order here. If you leave the courtroom, that's not going to prevent the effectiveness of this order.
Well, I take medication and like I told her this morning,
Mr. Burnham, have a seat, just have a seat and wait until I get this order done. We'll make a copy for you and then you can go.
I don't believe this.
Every day in the USA, people find themselves in court.
Anyway. Should be set. Yeah, I am. I'm right. So, sir, are you David Bishop? Okay, we got Mr. Bishop in the booth at the county. See, Mr. McClellan's on the phone, so we'll hang on a second. Mr. Swenson, is Mr. Bishop your client?
I'll be handling it, Your Honor. It's Mr. Sabian's, but Mr. Sabian spoke with him and gave me notes.
Okay.
You should expect Nisqually soon, Your Honor.
Oh, great. Thanks, Mr. McClellan. So this is Mr. Bishop. Pending probation issues on a theft that's pending trial in the county. Mr. Swenson?
Your Honor, my understanding is Mr. Bishop is stipulating to it was a violation previously found.
No, we're still waiting Mr. McClellan, this is all about the county theft alleged from May 15th.
Correct.
Okay.
So at this time, Mr. Bishop is stipulating to a violation on that case, Your Honor, and I believe there's an agreed sanction of 30 days.
All right, on both matters, then let me hear from Mr. McClellan. I'll turn back to you, Mr. Swenson, then I'll hear from Mr. Bishop. Mr. McClellan?
That would be the city's request and 30 days total, whether that's imposed concurrently on both or just on one, but 30 days total is a sanction. He should be, I think, serving currently. That's why he's in custody serving from the Lacey theft. So 30 days would be the city's request.
So he's serving a sentence on one of these already?
Yes. In fact, he came in on a warrant return or on that new booking when I think the court imposed 45 days on May 12th, but the judgment sentence actually checked PR, so he was released, I think by mistake, and then unfortunately committed a theft, or allegedly what's being alleged is at least a violation, which brought him back into custody, and the court recognized that he's supposed to be serving that time. So he's doing that now. So I'd ask for 30 days consecutive to his current sentence.
Okay, so I see that on the case, the 4A case, there was a sentence, May 12th, 41 days to be served on or before May 12th, and he was released. That doesn't make sense, right? And so now back in serving that. Okay. All right. Well, Mr. Swenson.
Sorry, Your Honor. This is a bit of a complicated situation. My understanding was that the 45-day sentence had previously been served. I wasn't aware of the mistake that the jail had made. So
Look at this, set it to another day. It's not really going anywhere if he's still serving a sentence.
yeah, I think.
Makes sense.
Well, I'll let Mr. I guess Bishop. You want to handle this today, Mr. Bishop? Okay.
Well, we've got a number of cases and people have to talk, and we finally have Nisqually. So I'm going to set this over and everyone can kind of piece it out. You're not going anywhere. You're serving your sentence. So this week, next week, when would be a good time for the court to set this and making sure that physical point defense is appointed to both matters? Later this week on I don't know when a good time is for Pacific
Your
Point
Honor, could we
Defense.
set this to next Wednesday?
Okay, next Wednesday would be, what is that, June 4th?
Yeah.
Okay. All right, actually, it's a little complicated. I'm gonna set Thursday, June 5th, because none of the sitting electeds will be present. Or actually, will Brett be here? Let me, do you have an ability to look at is Brett doing the in custodies on June 4th? Can you look at that? Actually, we might be able to do it June 4th.
Yes, forward finding.
Oh, wait, I'm sorry, you said June 5th.
June 4th.
Oh, June 4th is Wednesday and it's also.
Okay, so let's do it on the 5th. Is one of us doing things?
The 5th would be you.
Oh, me? Okay, I'm gonna set Thursday, June 5th at 1:30. For that sanction hearing matters, and then everybody can get this unwound and figure out what he served and what he hasn't served and what applies and what doesn't apply. So Mr. Bishop will be back next Thursday. Those were for sanction hearings. Oh, because he's already stipulated. There. All right, so Mr. Williams, you're unmuted. And Mr. Williams, I'm going to turn to Ms. Kamari here. We got a warrant return. Actually, let me turn to the city first on this warrant return.
Oh, yeah, that's correct, John. There was a warrant issued back in March, $5,000 each case at a complaint review hearing where there was no proof of any domestic violence treatment. So the city made a motion to revoke on that basis, and he's actually also in custody. He'll have a prelim this afternoon for a felony allegation of a felony violation of no conduct order. It's so we're here on the warrant return for the treatment noncompliance, but also the city will be filing a separate supplemental motion to revoke to include the new law violation.
Okay. All right. So what are you asking on this warrant return?
City's request would be the booking bail, the $5,000 each. It's been a complicated case over time where there's been a lot going into this, and with the victim having different positions along the way, but ultimately there was resolutions that required treatment, and that was kind of the hope to have that in place to help with the no conduct order. At least for our case, I think that was rescinded last year, but there's been other orders since, and now allegations of violating that order and no treatment. So I think that unfortunately the concerns that we've been dealing with in the past are continuing. So I'd ask for that 5,000 each case.
And Ms. Kamari, on behalf of Mr. Williams?
Your Honor, I've not yet had an opportunity to speak with Mr. Williams. I request a breakout room.
All right. So, Mr. Williams, we're going to put you together with Ms. Kamari, criminal defense attorney from Pacific Point Defense, and we'll come back.
Thank you.
And in Nisqually, what's your name? In orange, what's your name?
Brian, with an I. H-A-H-N.
Okay, Mr. Hahn, all right. Mr. Swenson, are you ready to work with me to talk to at Pacific Point Defense? So we'll see you on July 8th.
Okay,
And that's it for today.
thank you.
PC not provided. So no conditions set. All right, so back to Mr. Williams and Ms. Kamari. We're here on these warrant returns, warrant returns, post-conviction matters, no proof of domestic violence assessment or treatment. I don't know anything about a new law violation. I just have heard tell, so I don't have any facts to support that. Ms. Kamari?
Your Honor, I don't have any facts regarding that new allegation as well. I've represented Mr. Williams since the beginning of his cases in 2023. And so we've been working together for a while. There are a lot of dynamics with this family. The mother of his children has mental health issues. And so he was trying his best to navigate those when the previous charges came up. He currently has 2 children at home, and then there's one that left the home when these charges initially started. So a 13-year-old son and then a 15-month baby. And so because of the mother's mental health issues and other issues, Mr. Williams has been the primary caretaker for the children. And it's my understanding, and you can see in Jabs that there was a protection order protecting her or him. And it's my understanding that it was protecting him and the children against their mother. So the mother was the respondent. And because he is in custody, the children are now with her, even though they shouldn't be. That's my understanding. And so we're asking for his release since he is the caretaker of those children. And then regarding the treatment, it's been very expensive. And my client's currently not working. If he's kept in custody, he cannot afford bail. And so at this time, we would request release on his personal recognizance. Should additional measures be required, Your Honor, then we request that electronic home monitoring or some other restrictions be imposed if the court's aware concerned with any further violations.
So, Mr. McClellan, do you have any facts supporting whatever may be occurring in Superior Court? If I were to put you under oath, I could hear something.
Yeah,
If not,
I do have
PC
that.
declaration.
I have a copy of the affidavit of probable cause I can provide to Ms. Kamari and Your Honor, where I can read it.
Well,
pretty
probably
short.
best get it to Ms. Kamari and then get it to me
Okay.
through Ms. Garza.
Oh, so he's still beating. I think that what happened is.
Bless you. Allergies.
I just emailed that, and I know the email can be pretty slow in the courtroom, so I can also provide a copy into Laserfish now that Mr. Kamari can also have a copy.
What? Sending the probable cause statement from the Superior Court case. So how did you send it?
So I sent an email to Ms. Kamari and
got it.
Garza, but I can,
No, that's fine. That's what I thought I heard.
but I noted that sometimes those emails get delayed to the courtroom. So if it doesn't come in soon, I can provide a copy into Laserfish as well.
Thanks. So let me take a moment to review this from the Superior Court case 25-1-675-34. This is the declaration of the prosecutor. So of course, it's in the light most favorable to the government here. Going back to May 23rd, about 3:30 in the afternoon.
The reason why they included that is because before this was sent out, you have the hospital. But everything is this make they add this so they know which hospital. This was filed at that time. So he needs to be saying, this in the district court, needs to be seen.
Court file. Yeah, good.
In the moment, like, regular superior and very superior want to do.
Ms. Kamari, did you receive that information?
Your Honor, I'm reviewing it now.
Okay.
Small amount of prejudice on the district court.
And then I just have one follow-up piece of information to share, Your Honor.
Are you ready?
Yeah, if the court's ready just for a brief response.
Ms. Kamara, have you had a chance to look at that information? Ready for me to turn to Mr. McClellan?
Yes, Your Honor.
Okay, Mr. McClellan.
And as Ms. Kamara pointed out, she's worked with Mr. Williams for some time, and the city has worked with Ms. Kamara and Mr. Williams on a number of cases. So I do know there's a challenging dynamic that has taken place, and I see that, and I recall that there was a case where Ms. Williams, Christine Williams, was had allegations of assault against Mr. Williams in order, but what I see is the active orders is, of course, one that does have Ms. Williams as a protected party, and that and another order that does have Ms. Williams and the children, I think, as protected parties, and Mr. Williams is the respondent in that's 25-2 30394-34. So I think right now the children are actually protected from contact.
Yeah, I'm looking at that order. So anything else, Ms. Kamari?
Your Honor, I did not mention that Mr. McClellan just mentioned that Mr. Williams' wife, the protected party for this protection order, there are charges pending against her with my client as the alleged victim. So again, just going back to the dynamics and making sure that the children are properly taken care of. Mr. Williams has done his best to try to take care of his family and then assist his wife with the severe mental health issues that she faces. And so that we would ask that he be released and additional restrictions put on him.
With help to pay for the DV assessment, I need help paying for it. But I can pay for the restrictions and all of that stuff as well.
So I see in Thurston County Superior Court on Thursday, there's an order, or there's a hearing at 9 o'clock. And that order says that you're not to have contact with the kids nor with your wife, ex-wife. I'm not sure what the relationship is there. And there's that hearing on Thursday to discuss that. So you're not to have contact with any of them to begin with. And then
Yes, yes, ma'am.
I see that what's alleged here from Christine Williams, that's what's pending up there. So, and throughout all this, it's been going on for almost a year, 9 months. We haven't had compliance with this court's orders and to stop some of this behavior. So Mr. Williams, what I'm going to do here is I'm going to release you because my interest is that you get to that Superior Court hearing on Thursday and get that dealt with. I'm going to set a sanction hearing because you're out of compliance with the court order, not having done domestic violence treatment or assessment. We're going to have a hearing on that. You're not to violate the law. You're not to possess a firearm. You're not to violate these orders.
Yes, ma'am.
And it says no contact with the kids, no contact with her. Thursday is that hearing. If you want to be heard by the Superior Court about that, you best show up and be there. So if you don't, you don't, but that's what's allowing you to do that. So we're going to set a hearing, a sanction hearing on both of these. Specific point defense is appointed. 4 would be good. We'll do those on Thursdays or do we do the sanction hearings on the regular calendar on a Tuesday or Monday? Okay, I see nods.
I think
All
they've
right,
been trying to
8th.
set them at 11 on Tuesdays.
Okay, we'll do July 8th at 11 o'clock. I'm writing it down for you. And so, Mr. Williams, we've got mailing in Lakewood on 150th Street. Is that going to get to you?
Yes, ma'am. Yes, ma'am.
Okay, did you want a text message reminder?
Yes, ma'am.
I think we've got a number. Let's see what that is.
Thank you, Your Honor.
You're welcome. I'm sorry, what? So we've got a number that's 3638 at the last 4. Is that going to get to you?
Yes, ma'am.
6368 6368 at the last 4. All right. So you're back July 8th, 11 o'clock. You've got an attorney through Pacific Point Defense. So that's it for today.
Thank you, Your Honor. Thank you,
You're welcome.
Kamiri, and thank you, prosecutor.
You're welcome. Take care.
Thanks, man. Thank you, Kamiri.
You're welcome.
See you soon, okay?
In orange, what's your name?
Brian with an I. H-A-H-N.
Okay. Mr. Hahn. All right. Mr. Swenson, are you ready to work with Mr. Hahn?
I am.
Okay, so we're here. There's an arraignment for an allegation of criminal trespass in the 2nd degree and then other cases that he's recently pled to. So Mr. Hahn, so it's Brian Hahn, Brian K. Hahn, is that right?
Brian K. Hahn, yeah.
All right, what's your date of birth, sir?
8/2/60.
Thank you. So have you gotten a mailing address yet?
No, I don't.
Okay, that's all right. So Mr. Swenson?
Your Honor, defense is stipulating the probable cause for the purpose of today's hearing only and asking to enter a plea of not guilty. I did review the nature of the charge and Mr. Hahn's constitutional rights with him before court, and he has no questions at this time. He is seeking court-appointed counsel. I believe he's, well, he would qualify based on the information he provided.
Okay. So, Mr. Hahn, I'm going to appoint Pacific Point Defense to represent you after today. That's Mr. Swenson's office. on all matters before the court today. And accept your plea of not guilty to that allegation of criminal trespass on May 23rd, just the other day. And then I'm going to hear from the lawyers about release conditions. And so first, Mr. McClellan, on behalf of the city.
Well, the city is making oral motions to revoke for those backup matters 5058 ending in 1984 and 5916. And each of those cases all involve the same location, so it is challenging. I know Mr. Hahn just resolved the case back on the 15th of May, and it was a situation where the city was recommending 10 days total between the new law violation and the backup matters, not wanting to incarcerate Mr. Hahn at great lengths, but and the court went with credit just 3 days, and in a condition not to go back to this place. I think Mr. Hahn acknowledged that and indicated he had other places to go and he would stay away. So it's unfortunate that he's now alleged to have been back at that same location so soon, and it's presents a challenge for what's appropriate release conditions. On the backup matters, the post convictions, I'm asking for $500 each case, and then no objection to a PR in the pending case. But I think just violating the terms of probation, alleging to be at that same location he's been convicted multiple times. I have concerns with him following through with that sentence and any release conditions to that effect.
And so the 740 Slater Kinney, is that the place
That's
that
the Plaza Park, referred to as the Plaza Park West. It's at the Fred Meyer complex.
Okay, West. All right. So, Mr. Swenson?
Your Honor, I'm asking the court to release Mr. Hahn on his personal recognizance today. He is entitled to the presumption of release, and given the nature of the charge and the allegation here that he was sitting in the grass at the park, essentially, I don't believe that bail is appropriate. I believe that Mr. Hahn stays in the Olympia area and could show up for court as required. He indicated he could either get a ride from somebody or he's familiar with the bus system. But either way, I think it'd be appropriate to give him a chance to resolve this out of custody. The only history I see in the last 5 years involves similar charges, Your Honor, and I understand the city's concern, but the specific allegations in this case are not overly concerning.
So, Mr. Hahn, you can't go back to that Park Plaza Park West. You can't go back there. You can't sit on the lawn. You can't sit on the sidewalk. You can't be there.
Okay.
Is there a question you have in your mind about being able to go there?
I'm very sorry. I'm very hard at hearing.
Hard of hearing? Is that better?
I gotta get a little.
How's that doing? Is that a little bit better?
That's better.
Okay, sorry. So, you can't go back to the Park Plaza West. No going there. No sitting on the lawn. No enjoying it. You're not allowed there. Is there any question about that?
Okay.
Don't go back. You've now been arrested how many times? 3, 4 times for going there? How about you don't go there and then we don't have to arrest you and keep you in custody? What do you think?
Well, I visit with a couple of friends,
And you can visit elsewhere. You got to find a different place to visit.
Okay. I'll find.
Okay, don't visit there.
I'll find a new place.
Find a new place. So I think we're understanding each other. Your friends can't invite you there without you getting arrested. So find a different place to visit.
Okay.
All right. So I'm going to release you. You're going to be back in court. I'm going to hand you a court date and you've got an attorney. So let me turn to my clerk and get that date. Pretrial and probation issues. Let's do it later. He's probably gonna take the bus or something. Okay. So you're gonna be back on July 8th at 10:30. So after the holiday, July 8th at 10:30, and I wrote it down for you. All right?
Okay.
So Mr. Hahn, can you repeat that back to me?
I'm very hard of hearing, Judge.
So July 8th, what did you hear?
July 8th, what did I hear? Fireworks.
All right, 10:30 in the morning on
Yeah.
July 8th, right?
Yeah.
Okay, I wrote it down. You're gonna get this in hand. You be back in court July 8th at 10:30. We can give you a hearing device.
Okay.
Okay, see you then. Stay
Okay.
out of the Park Plaza West.
Okay, see ya.
Bye. Put in there, it needs a hearing device. It would. All right, and in Nisqually, your name?
Natasha, Stacy.
All right, Miss Stacy, you're here for an arraignment. And, all right, so Natasha Lynn Stacy,
Correct.
what's your date of birth?
12/15/1984.
All right, let me turn to Ms. Kamari.
Your Honor, I've gone over her rights and she has no questions. We're waiving formal reading of the complaint, stipulating to probable cause for purposes of today's hearing only, and asking the court to enter a plea of not guilty. She is requesting court-appointed counsel. She currently makes approximately $2,500 a month, but she supports 3 other individuals, and she's currently on maternity leave.
All right, well, Ms. Stacy, I will appoint counsel to represent you, and I'm going to appoint Ms. Langley to represent you after today. And the facility there can get you information on how to be in touch with your new lawyer. I'm going to hear from the lawyers here, the prosecutor and Ms. Kamari, on your behalf about release conditions and enter a plea of not guilty of this allegation of harassment. So, Mr. McClellan?
Thank you, Your Honor. She's not opposed to Mrs. Stacy being released on her personal recognizance. Conditions to include no criminal law violations, not possess a dangerous weapon or firearm. The alleged victim was on earlier, and I believe I know he was in contact with Mr. Herrera there. My understanding is he's pretty strongly opposed to the order and questions some of maybe what's been represented. So given what the city's reviewed in the report and the information from Mr. Herrera, I'm not asking for a no contact order today, but there's other conditions I would ask the court to impose. Thank you. And he's there, I believe,
Mayor?
ready to address
Oh,
the
I'm
court.
sorry.
Oh, I just meant if there's questions of Mr. Herrera, I know that he's still on Zoom.
Okay, Ms. Kamari?
Your Honor, we do request release on personal recognizance and that no order be put in place. Ms. Stacy and Mr. Herrera have been together over 21 years, and they live together and have an almost 4-month-old, a 19-year-old, and a 17-year-old together. And so there are the allegations that are contained in the police report are minimal. And as Mr. McClellan said, there is some potential information that needs to be corrected in there. And it is Mr. Herrera's he would not like a no contact order be put in place, but I'll defer to him to explain that further.
Ms. Herrera, would you like to say anything about that release condition?
Your Honor, I would like to not to have a no contact order. I never felt threatened. There was never any physical altercation, and I don't feel that my safety is in jeopardy at all. And like the attorney said, we have a 3-month-old, and she's on maternity leave too, and so I feel like she needs to come home to her family.
And I do in fact see that you've been convicted twice of assaulting Ms. Stacy. There have been
That's
orders
right.
from you,
Yes, Your Honor.
2006 and 2014. And we're talking 11 years ago, most recently. So, Ms. Stacy, I'm going to release you. There's no reason to hold you in custody. You don't have any history. And one of my orders are is you don't violate the law and don't possess a firearm. Surrender any firearm you have in your possession and don't possess any going forward. And then you come back to court. We're going to set that court date today. Now, I've got the address here for mailing on Wiggins Road. Is that going to get to you?
No.
Okay. Did you
I
collect?
think that Wiggins Road was on my ID.
Yeah,
My address has changed. I haven't changed my ID address.
Okay. Do you have a other mailing address that you could provide?
The 6850 14th Ave Southeast. Apartment D, as in dog.
6850 14th Avenue?
Correct. Southeast, apartment D, as in dog.
And that's Lacey. Got a zip?
98503.
And text message reminder, would you like that for the next hearing?
Yes, please.
Oh, you got that? We've gotten that, so we will send you a text message reminder. So what time should we set this hearing?
June 30th.
So Monday, June 30th, 9 o'clock in the morning, you're back in court. Ms. Langley is your attorney, so good idea to contact her before then.
Monday, June 30th.
Monday, June 30th, you're back in court. And there is no contact order. All right.
I appreciate that.
That's all for today. You can be on your way.
Thank you.
You're welcome. All right. That was here for the hearing, yes. But Langley's appointed. And your name? And your name?
Chelsea Ptoshnik.
There you are. All right, Ms. Poshnik, then we're here about an allegation from the city of Lacey of simple assault and domestic violence. And so it's Chelsea Lene Poshnik?
Yes.
All right, what's your date of birth?
11/1/87.
Okay, let me turn to Ms. Kamari.
Your Honor, waive formal reading of the complaint. If I remember correctly, we are stipulating to probable cause for purposes of today's hearing only and asking the court to enter a plea of not guilty. She currently receives TANF, and that's her only source of income, so we would request court-appointed counsel.
All right. So Ms. Poshnik, I will appoint an attorney to represent you after today, and that'll be an attorney from Pacific Point Defense, one of Ms. Kamari's office. And then I'll be setting another court date, giving you a notice of that today. And I'm going to hear from the lawyers about release conditions pending that the resolution of this case. So Mr. McClellan, on behalf of the city.
Thank you, Your Honor. And I believe so the alleged victim, and this is Kaida Pierce. I think she's on. I know that Mr. Hilliard, Dan Hilliard, spoke with her before court, and I think she does support an order being entered in this case. The city's can appreciate the concerns she shared. We're a little reluctant, kind of learning some more information going forward. The allegations here involve roommates The report indicates that essentially Miss Tochnik was they were living together and she was either being kicked out or being kicked out. The city's kind of investigating whether there was a tenancy there that would require a little bit different process, but her property was being taken out. And it sounds like she reacted to that. There's different versions of who physically started what. And so I think there's some challenges to the case that we want to make sure we're very comfortable with before we go too much further. But I think for today's purposes, we are going forward and asked for conditions not to have any criminal law violations and not possess a dangerous weapon or firearm. And if they're to the extent that she's not lawfully allowed at that apartment, then we're asking that she not go back there. But there may be more of a civil process there that takes place that we're just not aware of in detail yet. So I'm reluctant to ask for that order to effectively result in an eviction when maybe that's not already been lawfully done. So that's the information the city has. And if Ms. Pierce wishes to address the court, she may have more to share with the court. And I can certainly prepare an order if one is entered.
Okay, so I see there's a Kaida on Zoom. Is that Kaida Pierce?
Yeah.
And you don't have to talk to me at all, but is there anything you wanted to say? If so, but again, you don't have to say anything.
No, ma'am.
Okay, so let me turn to Ms. Kamari.
Your Honor, we do request release on personal recognizance, and that the other conditions just be no criminal law violations and no firearms. I'd just like to reiterate what Mr. McClellan said.
So did you collect any updated mailing address for your client?
I did not, Your Honor, and she couldn't remember her phone numbers.
Did not remember that? Okay. And Mr. McClellan, is it the 37th Avenue? Is that the apartment where this is alleged to have occurred?
Yes, Your Honor.
Okay, all right. So, Ms. Poshnick, I'm going to hand you a notice of your next court date. Since we don't have a good phone number for you, we can't send you a text message reminder. If you remember that, you can always call the district court and give us that number and we'll do that. And certainly you're going to want to establish contact with your attorneys, and that's going to be important to let them know how to contact you by phone. You'll be released. Your job, don't violate the law, don't possess a firearm. I'm not going to make any order of no contact. If there is an eviction process going, that's up to the landlord to deal with in Superior Court. But given the facts I have here, I'm not going to issue an order. I'm going to set a court date. And as I said, we'll hand you a notice of that. What date will we set?
July 8th.
Okay. July 8th at 10:30 in the morning, you'll be back in court. And in the meantime, you can contact Pacific Point Defense to talk all about this. So you're prepared for that July 8th date.
Great, thank you, Your Honor.
That's it for today. And you can be on your way. You can let them know you're done. You're welcome. Shannon Hamilton back. We're just waiting for all the rest of the attorneys. And Ms. Langley, Mr. McClellan. All right, so we're back with Shannon Hamilton, and I also added the other two matters that are set on for, I think we've got confirmation June 2nd. So Ms. Langley.
So, Your Honor, I believe we have an agreement for resolution of these matters. I've sent over a plea form.
Okay.
So the idea is going to be, while we wait, I guess, that she is going to plead to the new charge. And the new driving while suspended, which is the
okay. plea to that, and then the possession of controlled substance.
I don't know where we are with that.
It'll be dismissed with the plea to.
Okay, all
And then-
right. So
And then
you're
the-
working on, yep, go ahead, sorry.
Yeah, no, I sent the form to the city, so, I don't think I counted, credit yet, but, I think the idea is the hope was that she would be released today and given till Thursday afternoon to get back on EHM, or EHM is gonna be off the board, so.
Okay, all right. All right, well, let Mr. McClellan look at that. Are you ready to go forward with this, McClellan, once you have a chance to look at everything, or?
Yeah, I'm just moving it over into Laserfish, and I'll let the court know as soon as it's in the judge's folder.
Okay. Right. Are they asking about the Lacey cases or the county case? We just set to June 4th. Well, we just set to June 4th, and they should have gotten a judgment sentence and all the conditions the same, so you can just tell her that. Right, and that's fine. Yeah, ask her. We're just set for June 4th. Or 5th. Which one's it? June 5th. It was June 5th.
No, plea form is ready now, Your Honor.
Okay, let me go look at that. All right. All right, so Ms. Hamilton, I'm looking at your plea of guilty to driving while suspended in the first degree going back to February of this year. Now, do you feel you had enough time to go through all this with an attorney to plead guilty to this?
Yes, ma'am.
Right, and in this plea are all of your rights to have a trial and to understand those rights.
Yes, ma'am.
Do you know that you're giving up your rights to have a trial in this case if you plead guilty?
Yes.
Is that your choice?
Yes.
All right. And you understand that the attorneys here, it looks like they're recommending the mandatory minimums in this case because of a 7th driving while suspended in the first degree. 180 days is a mandatory minimum that I have to impose. I don't have any discretion there. The law says that shall be imposed if you plead guilty. To understand that's what's being recommended in electronic home monitoring.
Yes, ma'am.
Okay. Do you know I don't have to go along with that?
Yes.
So in the way you serve it or how much time you serve, I could serve up to 364 days in jail. Do you know that?
Yes.
Okay. And do you understand that if you plead guilty to this, that you will have further license revocation several years beyond where you are right now?
Yes.
Okay. Asked you to make a written statement. Here is what you've done wrong. It makes you guilty. And you're saying that on February 10th of 2025, you were driving a motor vehicle in the city of Lacey, knowing that your license was revoked as a habitual traffic offender. Do you accept that as what you did wrong?
Yes, ma'am.
All right. Now, has anyone threatened you with harm or made you any promises that have caused you to plead guilty?
No.
Okay. Well, how do you plead then to that February 2025 driving while spent in the first degree?
I'm guilty, Your Honor.
Okay. Well, I will accept your plea, and I'm doing that finding you know what you're doing. You're doing this voluntarily and intelligently, and doing this understanding the consequences of pleading guilty. And I see that your statement there supports this plea. And we'll move on to sentencing. You're already serving a sentence on the 2A case. And then let me turn to first Mr. McClellan, Ms. Langley, and then I'll come to you. So, Mr. McClellan.
Yes, thank you, Your Honor. This, city kind of struggled a little bit on what made the most sense here. So she had that EHM and I think had a violation that has her back serving in custody, and there's this new driving offense that obviously is we recognize has a 180 day minimum, which is what she's pleading to. There's just the discussions have been whether or not EHM would be appropriate, and the city's agreeing to it with the resolution today. That last case was from 2022. It didn't resolve till 2025. It was a long process. We were kind of motivated to have a quicker response, given that it occurred while she was on probation. So I think our position is that we're not objecting to the balance of her other sentence on EHM now with 180 days consecutive to that EHM, with the understanding that if she's not compliant, there's that risk that she would serve quite a bit of time in custody without options. And so hopefully that's, if it wasn't already a motivation for Ms. Hamilton to make sure that she complies with condition on EHM, then this is now another 6 months on top of what she was looking at or serving. And so with that understanding, I think we're comfortable recommending that EHM. Hope that she can take advantage of that. And I believe she's aware that if not, then we'd be looking to request the court revoke that opportunity.
So Ms. Langley?
Thank you, Your Honor. Kind of the key to making this work for her is the city's agreement that she can be released and have till 5 o'clock on Thursday to get back on EHM or turn herself in. It's as she explained to me, it's much more expensive to get yourself on while you're in custody and have to have them come to you than it is to just go get hooked up. And that would be prohibitive for her. So I'm hoping the court will go along with this. I think she understands that if she doesn't, first of all, get on EHM in time and then completely comply with it, she will be sitting this entire sentence. So I would ask the court to please adopt it. Thank you.
Well, and then Mr. McClellan, you're dismissing the possession of controlled substance?
Yes, with upon acceptance now that plea on the DWS-1, I move to dismiss the unlawful possession case.
Okay, all right. And so Ms. Hamilton, anything you'd like to add to all this?
No, I do, but I don't right now.
Okay.
Sorry.
All right, so I'm being asked to give you another chance to get onto EHM of your own accord. We did that before and you didn't. So,
Oh,
you know,
I do have
what your
some
plan
things.
is to get this done in less than 2 days?
Yes,
Right? Okay. So you've got about 158 days to serve on the other matter. This is going to be consecutive or in addition to that. I'm going to go along with it, allow you to do all this on EHM. You got to get it hooked up no later than Thursday, the 29th. So that means that you'll contact that agency. They'll send a letter to the court saying that they've got you, and then you do it successfully. It's a long time to be on EHM. Obviously, don't violate the law and follow all of their requirements on EHM. But that'll keep you out there, and if you have a job, that's great. Have you go to work. But we'll do that. And this is your opportunity to make this work right.
can I ask you a question?
Sure.
Is there a way to make sure that I get my jail time credited towards it already that I've already done?
You've done 22 days, I see. So
Well,
you've been in since, and I'll turn to the lawyers. We've got 12 days from the original sentencing and then 10 more days from the 17th of May. Am I right there? Looking to the lawyers?
So,
Yeah,
Okay, and that's applied against the previous sentence.
okay,
And then this one is another 180 days on top of that because they're going to be one after the other, not concurrently, not at the same time.
right.
Okay, so first things first, you'll get released and then you get that EHM provider going and make sure they let us know by Thursday that they've got you.
I will.
And then just serve it.
I will.
And don't violate the law, don't drive without insurance and a good license. And obviously you're not allowed to drive and it's going to be a long time. So you're gonna have to try and find another plan there.
Okay.
Okay, any other questions?
No, thank you, Your Honor.
Okay, you're welcome. That's it for today.
Thank you,
The
Anna.
possession of stolen property is dismissed, and I just took a plea on that one.
I'm
So
done, correct?
You're good to go.
All right, thank you.
Sure. So 5A-129-189 is dismissed. 5A-211-770 is a plea. Just reimposing the sentence that was issued February of 2025.
Was she released now?
No. Well, she's released to start EHM on Thursday. You can read my order. I'll help you later. So what do you need?
Okay, so he's saying.
Well, why don't you tell me and then I can just figure it out. What's the problem?
So Mr. Bishop was
Right.
originally seen, this is the order from the 15th.
Right,
Where he got sentenced.
right.
And
So
been
he's
in
serving a
custody,
sentence.
And he's been in custody, but we got a new order today,
Right,
saying hold without bail, and we can't
Yeah.
do both. He either is sentenced or he's
when's his
held.
release day?
June 8th, I believe.
All right, and we're set for, I don't want to release before that hearing. Oh, so they haven't heard it over in the other courtroom. Okay, so they need to see her. All right. All right. Oh, hello, and Miss Qualley, your name?
Gonzalez.
All right. And it's like we issued a warrant, probation warrant a while ago, and Mr. McClellan?
I think, the cities would be asking for the booking bill of $2,500 cash or bond. That warrant's been out since September of last year. The issue being on probation, non-compliance with treatment, and there's pending new law violations. I believe that there may be deferred Mr. Camiri may be moving forward with a stipulation to non-compliance and a sanction.
That's correct, Your Honor. We'd like to proceed today.
All right. Well, the issue here is no treatment. There's conviction for that possession of controlled substance way back in January of 24. And I see that City of Yelm, I have benefit of their report under penalty of perjury. But we never received any treatment, compliance, substance use of treatment. So are the parties ready to go to sentencing today, or?
We are, Your Honor, and I just wanted to make clear for the new, for the two open cases, Yelm and Thurston counties, we would be including those, stipulating as general prohibition, not the specific cases or specific charges within those cases.
All right, so that those events were violations of the court order along with not doing treatment. Okay, I can take that. So, Mr. McClellan, then on that, finding of non-compliance with the court order, what is the city asking the court to do?
The city's gonna ask to impose 10 days as a sanction. She had served 1 day back when this resolved in January of last year, and of course these charges are challenging. It involves a number of maybe other factors going in that we try to address, and the treatment was imposed ideally to help prevent future law violations. So having that theft, having other drug charges, and not being in compliance with treatment, I think treatment itself, she's not been compliant, but I'd ask those conditions to remain. I guess defer to the court. I think probation really was only taken for 1 year initially. I know that she may be on probation with other courts, but there's no findings yet. So I know there's some more time that could be factored in, but I'd ask for 10 days as a sanction in this case.
Any other conditions, or simply close the case after that's done and let Olympia or Yelm and our other part of our court take care of it?
Yeah, I mean, if there was any jurisdiction left, I'd ask, hopefully the treatment component can still be complied with, but if not, then no objection to the court considering closing the matter.
All right. So I know there are folks in the courtroom. I don't know if anybody wants to say anything. And if you do, I'm going to need you to come up to the table, and then I will turn to Ms. Solas herself. But if you don't want to say anything, you don't have to. But I just want you to know that. Yeah. Okay. You got appointed. So why don't you have a seat, and then just have a seat and let me know who you are. And she can hear and see you as well.
Okay, I'm her mother.
Just have a seat, and then let's get going that way. So you are
Lisa Alexander, I'm her mother.
okay. So anything I should know or not know, or what?
Yeah, we would really recommend inpatient treatment. If there's any way possible.
She's been dealing with this for years now.
I can see.
She had a baby.
She had a baby in a barn last
And so who are you?
Father,
Okay, and your name?
Daryl Zolas.
Okay, all right. So she knows who's here.
We have tried to get her in, or Lisa's tried to get her in.
And she needs mental health treatment too.
She's hearing voices.
Hmm.
And they have to be some of her old friends that she thinks she's hearing voices from.
She thinks someone put something in her ear, a listening device, and that they put
She's
it in her
very
son's
paranoid.
ear.
Well, we have
there's-
ordered her to get into treatment before this, and then the warrant went out for a long
She's
time,
not
and
gonna do that.
yeah, I can't pick her up and
I
put her.
understand.
But there is a process through Superior Court potentially that they can involuntary commitment, but I don't have that ability, unfortunately.
She's gonna die.
Yeah.
if she doesn't get help.
And there may be some ways you can pursue something through Superior Court. They have greater powers than I do at the district court level. So, Solas, anything you want to say about all this? You're shaking your head no, is that it? Okay, now you're saying yes. Can you speak to me about any of this?
I don't have anything to say.
Okay. So you've got a couple other cases that we still are going to deal with. Unfortunately, we're going to have another hearing. This is the City of Lacey Municipal Court right now. We're going to have another hearing in courtroom number 2 across the hallway.
The other waiting on her.
Yeah. And so what I'm going to do here, Ms. Solas, is I'm going to impose those 10 days. Yep.
If I may.
Sure.
We are requesting the 10 days, but then the case also just be closed at that point. She has gone through a significant amount of stuff during the last year, dealing with a stalker and other issues. And so she does have a son that she has visitation with. And so she's working to try to get a better relationship with him and more additional time. Her family is in the area, and we would just ask that after this time is imposed, that the case be closed. She does have already 7 days credit for this matter. So then at that point, with good time, she should be released. So we would just request credit for that time and then close the case.
So from May 25th, she came into custody on the warrant. That's what you're.
Yeah, May 25th, Your Honor, but then she also was in custody July 11th through July 15th for this case. And from what I could see, that credit had been used for any other sanction or.
Back in on July 18th. Mr. McClellan, any different assessments?
Yeah, I couldn't see when she came into custody. I know that there was a warrant out from May of last year, and then she was released on the 15th of July when she appeared. So I don't know that would have been the 11th. She came in.
According to the Nisqually roster, she was booked on the 11th.
That would have been a Thursday. I don't know if there's a reason she wasn't held or heard on that Friday, but yeah, if the roster reflects that, I'm not disputing anything Ms. Kamiri said.
Okay, so I was trying to figure out. So Ms. Olas, you're going to be seen by the next jurisdiction, the next judge, and today, and those decisions will be made there. On this case, I'm going to impose that 10 days. You'll serve it out, close this case. I don't know what the city of Yelm is going to do with their warrant. But if you get good time, that's up to the facility to make a decision about. But you have 3 more days to serve here unless they decide you get good time towards this. But the next stop is the next court, and they'll make a separate decision on those matters. You don't have any, in the city of Lacey matter, you don't have an obligation here. So that's it for today.
Your Honor, how much credit are you giving?
The 7 days you told me?
7. Okay. Thank you, Your Honor.
Okay, 3 more days. All right, so I'll just direct you over to courtroom 2, and then they'll take it from here. Good luck to you. So any information about Mr. Clark and Mr. Oldright, or just waiting?
I was informed they were single cell.
Okay.
And for trials, you do have to appear in person.
Yes, Your Honor. Okay.
Okay, you're all done. Thank you.
All right. Thank you. You all have a great afternoon.
You too.
Your Honor, we can address Mr. Thomas Osbach, present on Zoom.
Mr. Libby, you know where Madison is, right across the river from you?
Madison, Indiana?
Yeah.
Yeah.
Okay, you should have piped up. I know where it is.
Can we clarify the tenant's last name, please, Your Honor, just because it's spelled without an S there, and I see it spelled different, couple different ways in different places.
Everything I see is ASBACK.
I saw CH in one place, so.
Cat, it's ASBACK. Oh, Wait, and you just have A-B-A-C-K, so let's get that correct. Is it Asbach or Avak?
It's Osbach.
So are you missing an S on your sign in there?
Yeah, I just not seen that.
Okay. All right, now I think we have it corrected.
I think I've been told everything.
Your Honor, Mr. Osbach is on for arraignment for an allegation of driving a license suspended in the 3rd degree. There are 2 backups for prior allegations of DWS3. Mr. Pazdurka is currently assigned to represent Mr. Osbach in those matters. For this matter here today, we'll acknowledge receipt of the citation, waive formal reading for their advisement of rights, and a plea of not guilty. Stipulate to probable cause for purposes of today's hearing only, given our appointment on the other 2 matters, asked the court to appoint counsel here. I did review Mr. Osbach's rights with him. I don't believe he has any questions.
Thank you. And Mr. Osbach, you don't have any questions for me about your constitutional rights?
I think I've heard it a couple times, Your Honor. If you'd like to recite it to me, I'll be willing to listen.
Well, you signed the form on your rights, so I'm assuming you reviewed it.
Yeah, I did.
Okay. Yeah, if you have specific questions, feel free to ask.
Okay.
And 14005 Tilly Road.
Yeah, it's a alternative mailing address for me.
Okay, so that's not where you reside?
No. I'm kind of couch surfing right now, Your Honor.
Okay. How about the Alonda Lane? Is that a good address or not a good address?
That's just the mailing address where my brother's at. He brings me my mail, all the really important stuff, like coordinates and stuff.
Okay, so where do you prefer to get it? At Alonda Lane or on Tilly Road?
The Alonda Lane is probably safer.
Okay, all right, we'll continue to use 2310 Alonda Lane. Right, and is the state making a motion to revoke the prior driving suspended thirds?
Yes, Your Honor, the state has some concerns about, I mean, he is here today. I recognize these are D3s, but again, this is a short period of time where he's picked up 3 D3s. Does look like he was arraigned on the 2 backups after this new one.
All 3 are predisposition?
Yes, Your Honor. The first one is from February 1st. That's the 032. The next one's from February 26th, and this one's from April 12th. The state is asking for that some bail be imposed. Again, recognize these are D3s, but given extensive warrant history and the series of charges in a row, the state has concerns.
Ms. Miller.
Thank you, Your Honor. Obviously, these are nonviolent offenses. Mr. Osbach is dealing with some very serious heart issues. That's part of the explanation for his presentation today that Your Honor might have noticed. No objection to the court imposing something like pretrial services supervision to keep him on track and coming to court if there's concerns about failures to appear. No objection to the court imposing a do not drive period condition if the court is considering bail. But for these nonviolent offenses, we'd ask the court to allow Mr. Osbach to remain up here. Since Your Honor might be taking a look at it, we did discuss what Mr. Osbach needs to do. He was already aware and he is working on that.
Does he know what court has the judgment against him?
He apparently is in receipt of some information via PDF. He's just been having a hard time opening it and reviewing it. So it sounds like he's quite a ways into the process of.
It looks like it's this court. I mean, he had a hit and run crash property damage from June of 2024. So that would likely have resulted in a civil judgment, I guess. office. Okay, bottom line, Mr. Osbach, I'm not gonna put you into custody, but you're not gonna drive.
Okay. Can I have an explanation, Your Honor? I mean.
Well, yeah, hold on a second.
Working at temperature.
Yeah, I don't want you to admit anything that convicts you of the charge, so Ms. Millar would really hope you don't say anything right now about driving.
Okay. All right.
Dates and such. So your license is suspended. You have to have SR 22 insurance. You have to pay a total of $170 in fees to the Department of Licensing, and you have to take care of the judgment against you. All those things have to happen before you have the option of driving a car. So since I suspect that's going to take a while, I'm going to tell you, do not drive.
Okay. My contact.
So you're going to have to.
Excuse me.
You're going to have to get people, ride the bus, you know, whatever, get a bike, good pair of running shoes, but.
Yeah. All right.
All right. Okay.
I appreciate it.
All right, sit tight and I'll give you a new court date.
All right, thank you.
I'll look. What is it? So everything. Yeah, it looks like the other two are already on that date. Okay, you're coming back, as you know, on the 11th of June at 8:30 in the morning. So that's coming up in a couple weeks.
Okay, that was 8:30.
8 on 11 June, and we'll send you text reminders. Did we get? Okay, so we'll send text reminders to the cell phone number we have. All right,
Okay,
Mr.
All right, Ron, thank you.
Yeah, bye-bye.
Bye-bye. All right, this is off here.
Just doing one GNS on the arraignment case since the others already have hearings. So. Vehicles.
Yes, Your Honor. We also have Mr. Tracy Blue on Zoom, and his matters are 8 and 9 on the calendar.
All right. Mr. Blue, good afternoon.
Good afternoon.
And it's Tracy Lamont Blue.
Correct.
And Mr. Blue, 1420 Fawns Road, apartment A2.
Correct.
And the cell phone number on the screen. And Mr. Blue, you went over your constitutional rights with Ms. Viejos. Do you have any questions for me about those rights?
No, sir.
And Ms. Viejos, any objection to probable cause?
No objection to probable cause, Your Honor. We will be requesting TCPD to be appointed, and we will be entering a not guilty plea.
No probable cause and a charge of driving suspended first degree. Enter a not guilty plea for Mr. Blue to that charge.
And Your Honor, if the state
And is the
could,
state making a motion to revoke from the driving suspended second degree conviction?
yes, Your Honor. So on both cases, the state is asking for bail. He's on probation for that. It was a D1 amended to a D2. The only conditions were no new law violations, no driving without valid license and insurance, and essentially here we are. Probation doesn't end until the end of this year. He also has recent warrant history. I counted 11 in the last 5 years, including ones from this court. In addition, conditions of no new law violations, no driving without valid license and insurance.
Right, thank you. Ms. Villegas?
Sorry? Oh, sorry, 1,500 on each case, so state's request.
Your Honor, I understand the state's concern, although the bail amount would be excessive in this case, considering Mr. Blue is indigent. We would ask that it be no more than $500.
Working at Patina,
Correct.
full time?
Yes, sir.
And do you have any dependents? Looks like you have 2.
Yes, I take care of 2 kids and my wife.
I will appoint counsel to represent you. I'll order that you pay $100 to help defray taxpayer expense of providing service of counsel based on your income. Counsel will represent you on both matters. Case ending in 632, which is the new charge, and the case ending in 093, which is your driving suspended second degree charge that the state's made a motion to revoke your suspended time on. And Mr. Blue, I'm not going to put you into custody, but you got to stop driving.
Yes, sir. It was honest. It was an
yeah.
honest mistake that my wife was sick. Made a quick trip to the store and it turned out the way it turned out. I take full responsibility for it. So I'm just,
Okay, I'll let you talk to your attorney about that going forward, but I'm just letting you know, unfortunately for you right now, that's not an option,
Yes, sir.
Emergency situations, you're gonna have to figure out a different plan to accomplish that. And, your license to drive is now suspended as a habitual traffic offender.
Yes, sir.
And what that means is it's a mandatory jail sentence if you get convicted. So,
Yes, sir.
and it goes from 10 days to 6 months. The next
Yes,
one would be 6 months. So just know that.
Yes, sir.
That's a long time in jail.
Yes, sir.
So you just have to figure out a plan that doesn't have you driving.
Yes, sir.
Okay. And I have you saying that on record now about 4 times. So I don't think there's any doubt about that. And I don't want to have to play it back for you if you're back here on another one and they'll say, boy, listen to your words. You said
Yes, sir.
you weren't gonna drive again. Okay. All right.
Yes, sir.
We'll give you a court date here in a moment. No criminal law violations. Do not drive unless you have valid license and insurance. And you'll come back to court on the 16th of July at 8:30 in the morning.
The 16th of July at 8:30.
Yeah, and we'll send you text reminders of that with the
Yes,
cell
sir.
phone. Okay, you're all done for today. Thank you.
Thank you.
Yep. Ms. Vihos.
Your Honor, those are the only two matters I have prepared so far, but I do see a few more folks on Zoom that I can go speak to, as well as in the courtroom.
And folks, your name? Thank you.
And simplify.
And they still got they still have this, they still have Winslow set in, put in our courtroom. Right, Mr. Stashevsky.
Your Honor, present with me is Mariah Knight. This is the first chance I've had to speak with Miss Knight. If I could just have a brief couple moments here, Your Honor.
It's just a return from a missed pretrial on May 14th. Just warrant service.
Yes, Your Honor. Oh, yeah. And I do note for the court's attention that on May 2nd, Ms. Knight did call the court inquiring about the date.
What's the state's position?
To be fully candid, Your Honor, firstly, it's not on my calendar, so could the court provide the cause number for me?
Yes, 17228. And it looks like this was warrant service today, so somebody hurried it up onto the calendar.
There it is.
Yeah, but she just missed on the 14th, and that was a pretrial hearing.
And I would also note for the court that the defendant's parents, the defendant's, I believe, mother is in the court today. The state is asking for $10,000 bail due to the past criminal history and the multiple FTAs. The state has concerns whether she will attend to future hearings. This concern was expressed by the court towards the end of the last year, and the defendant has failed to appear in this case multiple times now, I believe 3 since initial arraignment. So the state would renew its request for $10,000 bail, but I would just, again, note for the court that the defendant does have family presence. I would defer to the court as to whether or not the court wishes to hear from.
But let's make sure that we have good contact information. So Ms. Knight, we've got a mailing address on 78th Avenue Southeast. Is that a good mailing address?
Yes, Your Honor.
Okay. All right, and the last court date was May 14th. Is there any explanation for why she wasn't here that court date?
Your Honor, I would like.
Your Honor, Ms. Knight believed that the date was May 4th, and I think that's why you see her call the court on May 2nd asking about the date, is she had transcribed it wrong, Your Honor. It was not 5/4, it was 5/14. And I do believe that's why she
did.
called.
Yeah, we did get a call from her on May 2nd. Okay, and you're her mom?
That's correct.
Okay. All right. Do you know anything about why she wasn't here on May 14th?
Well, technically, she doesn't ever attend court hearings on time, and that's been for years and years. Both of them get on Thursday County. I went and had to retrieve my car last night, and it was full of paraphernalia, drugs, a bong. I have pictures of all of that. She was supposed to go to the store, and she didn't. And she has turned my property upside down. It is just a huge mess. It screams Tweaker lives here. She's picking up drugs and in massive pairs by the number of needles. She's out of control. My car was just stolen by her boyfriend, and it ended up in Vancouver. And when she went to retrieve my car, the police officer did a search of that vehicle. And in that vehicle, she looked through the purse, and there were keys that had been shaved that are normally for the purpose of breaking and entering into vehicles. They also found a couple of bags, ID and mail that did not belong to anybody. So I'm suggesting that I concur with the $10,000 bail. At this point, she's yeah, I'm taking care of her son, the needles, the traffic, the people that she has over to her home. She's living on my property right now. I'm going to be filing a restraining order, a no contact order.
Is that the property on 78th?
I need to make that happen.
Is that the property on 78th?
That's correct.
Okay. All right, Mr. Stashevsky, can you tell me how the warrant got served on this night?
The court.
Am I off mute?
Yeah, you're off mute.
Okay, so last night I was supposed to go to the store on the West Side Safeway, and I'm not sure what happened, but I ended up completely, totally out of it, which is not normal. I ate food, and then I couldn't like comprehend who, where, what I was or anything, and I was able to let a lady know that I wanted an ambulance to come for me, and so the ambulance did come for me, and until I was able to get balanced, and he says he tried doing like a brief diagnosis of, he thinks I'm a diabetic, and because my blood sugar was at 47, and they stayed with me until the police officers got there. I did tell them that I had a warrant because I had missed court, and that's why I came into contact with the police.
Your Honor, just from a defense perspective, it was difficult to hear all of what was shared with the court. I would note that based on Ms. Knight's employment information that she shared with me, that $10,000 bail would be tantamount to a no bail hold. That is not something she could realistically afford to post. I note, in addition to the fact that she called on May 2nd inquiring about the court date, that she has no other active warrants at this time. I believe some of the information that was shared with the court would not necessarily be properly considered under the criminal rule of limited jurisdiction regarding conditions of release. And then we would request for a PR in this case, Your Honor.
I'm sorry, I missed
All right, I am going to go ahead and release Ms. Knight and have her report back to pretrial services. Let's get a new court date, a pretrial hearing date for her. Okay, that is unhelpful and inappropriate conduct in court, which you already know, and I'm going to ask you not to repeat that. Do you understand? All right. New court date? All right. June 25th at 9:30.
Yes, Your Honor, I'll be there.
Okay, so it looks like they got Mr. Winslow redirected.
His cases were moved to
Check it if I didn't. All right, Mr. Stashevsky, I'm ready for you.
Thank you, Your Honor. Present with me is Doran McCrade. Ms. McCrade is numbers 9 and 10 on the calendar this afternoon.
Got it. All right. And good afternoon, Ms. McCrade.
Good afternoon.
And today you're here for your arraignment on a charge of driving under the influence and a charge of resisting arrest that are alleged by the state to have occurred on May 23rd. Mr. Stashevsky.
Your Honor, I discussed with Ms. McCrae her constitutional rights. I do believe she understands those rights. We are seeking the appointment of Thurston County Public Defense, and I do believe public defense would be appropriate in this context statutorily, Your Honor. For the purposes of today's hearing only, we are not contesting probable cause, and we would request that the court enter a not guilty plea on Ms. McCrae's behalf.
All right, Ms. McCray, I'll enter your plea of not guilty to both counts. Appoint the public defender for you and the state's recommendation on release.
Your Honor, the state's recommendation is the state has no objection to personal recognizance at this time. However, the state would be requesting that the court impose both the standard DUI conditions as well as the mandatory ignition interlock, given the DUI conviction out of Thurston County from 2018, as well as the DUI conviction out of King County Superior Court in 2003. The state would also request the imposition of a scram device, given the repeated DUI offenses. State would also request pretrial services to ensure that the defendant follows up with future court dates and is able to get the scram device provided at county expense. I would also note the fact that, Your Honor, that the defendant has, to be fair, the past resisting arrest charge in 2018 was dismissed with prejudice. But I would also note that the same charges repeated here for resisting arrest and DUI. The state believes that heightened DUI conditions are necessary to protect the community and doesn't believe personal recognizance should be a problem given the lack of warrant history.
All right, Mr. Stashevsky.
Your Honor, in relation to, well, a couple things, Your Honor, just noting that the allegations in terms of the resisting arrest appears to be allegations related to tensing her arms, being confused and being fearful. So I just want to highlight that for the court, given some of what was shared regarding the fact that there's no real warrant history. I don't think at all. There was from 2003 that had expired warrant history, but no warrant history since 2023. I don't believe that reporting to pretrial services is necessarily needed. Your Honor, defense would have no objection with an ignition interlock requirement. Defense would contend that that would be the least restrictive means of release, and that a scram or ankle monitor would be overly intrusive given these facts. And Ms. McCrae has shared with me, and she might be able to share with the court as well, that she does have some health conditions related to blood pressure and circulation and nerve feeling, and there is concern that an ankle monitor would exacerbate that medical condition, Your Honor.
All right, Ms. McCrae, today I will release you on your personal recognizance. Conditions of your release while the case is pending are: don't violate the law, don't drive unless your vehicle is equipped with an interlock, don't drive without a license and insurance, don't go to any bars or taverns or consume any alcohol, marijuana, or non-prescribed drugs, and don't refuse a breath test. Report to pretrial services. I am going to order you to have a scram, and you can have that on the substance use monitoring program. If any issues develop about whether that's actually appropriate for you physically, then those can be brought and we can modify your release conditions if that's appropriate to do. And I'll give you a date to come back for a pretrial hearing. Okay, your court date is July 16th at 9 o'clock. So on Winslow, we don't need to see him. Those are just put on as backups. He already has future court dates set on those. Okay. That was just Lacey warrant service that he's seen for over there. These were just pending cases. They didn't have warrants.
Tobin was already heard. And I take-
All right, Mr. Stashevsky.
Your Honor, present with me is Mr. Irwin, and that is Mr. Casey Irwin.
Yeah, Your Honor.
Numbers
All
4
right.
through 7.
So it looks like he missed court on May 14th, and all these cases had the same court date.
Yes, Your Honor.
All right, so what happened that Mr. Irwin didn't make it to court?
Apologize, I'm just reviewing my notes here, Your Honor. Mr. Irwin just shared that he just did not know that it was on May 14th, Your Honor. I note that Mr. Irwin has a 2-month-old, and they are in between secure housing at the moment, Your Honor. They don't have secure housing, and so I do believe some of the life stress potentially implicated knowledge and awareness of the May 14th date.
All right, what's the state's position?
Your Honor, I would note that the defendant, according to my count, has failed to appear twice, I believe on all 3 of these matters. I would also note that the defendant currently has an active warrant out of Lewis County for driving while license suspended 3rd. That was issued quite a while ago, back on 9/23 of 2024. I would also note that the current charge under 531 and 532 involves reckless endangerment as well as reckless driving, hit and run of attended vehicle. The cause number 46, making a false or misleading statement. Both sets of these charges give the state cause for concern that the defendant is going to interfere with the administration of justice, as well as the defendant's failure to appear history in this case. The state is asking for $2,500 bail on each case for a total of $5,000, with cause number 531 and 532 grouped together in that calculus for bail. The state believes that apart from the court imposing some form of bail to get the defendant financially invested in the resolution of this case, the defendant is very likely not going to appear for future hearings.
All right, Forest Park Street Northwest, is that a correct address?
Yes, Your Honor.
Okay.
May I respond briefly, Your Honor?
Sure.
I just wanted to note that he was in person on February 8th, 2025 for the charge that was filed that month. He also called on April 10th asking about a court date. This maybe is not super relevant, but at least in the fall of 2024, it appears there was possibly an address change as the court received a return mail notification. I also just want to note that the case ending in 046 TCP, while it has a date of violation of 2023, it was just filed this spring in February of 2025. Mr. McCrae, apologize. Mr. Irwin brought up on his own accord before I even said anything, the Lewis County warrant. He is aware that that exists, and he knows exactly where the Lewis County Jail is that he has to go to quash that warrant. I also gave him the contact information prior to this court hearing, Your Honor, this morning for the Lewis County facility. I'd also highlight that he's lived in Thurston County his entire life. I can provide Madam Clerk with the phone number of his sister, a close relative, who can assist with him in getting to court. I do believe that is something that the court can consider under the relevant rule. And he works for Stroud Construction. He's worked there for over 6 years, Your Honor, and he has a 2-month-old kid, Annalie, and his partner does not work. And so him being in custody would really potentially jam up the family unit, Your Honor. And then in relation to interfering with the justice, I see the 2023 false statement charge, but I don't see anything in the last 3 or 4 years that would indicate any tendency to interfere with judicial processes. And I don't believe that's a valid concern in this case, Your Honor.
All right, I think I'm out of options with Mr. Irwin. Mr. Irwin was in court on April 8th and he was handed a notice with the court date on it in May. And I really don't know how much more clear we can be. So in 531, bail will be set at $2,500. That was the amount in the warrant. In 532, bail will be set at $2,500. Also, that was the amount in the warrant. In 23M 237, that was a no bail warrant because that's a probation violation, but I'll set that at $2,500 as well. And in 25M 46, also a pretrial case, bail will be set at $2,500. And we'll get Mr. Irwin back on the pretrial calendar with Mr. White. All right, stand by for your court date, Mr. Irwin. Sixth. June 11th. June 11th at 10. Okay. All right, June 11th at 10 o'clock.
That he could get released. Is that
right? He's eligible to do it either way. It's the same order as before.
Thank you, Your Honor.
There's just not a gap in reporting.
Thank you.
Okay, Ms. Myers.
Thank you, Your Honor. I'm ready to call Mr. Anthony Carmona. He's number 2 on the calendar. He's president of the courtroom.
Mr. Carmona, come on up. All right, and Mr. Carmona, today you're here in court for your arraignment for 1 count of driving under the influence alleged by the state to have occurred on May 24th. Ms. Myers?
Thank you, Your Honor. I did have time to meet with Mr. Carmona before this hearing, and I did advise him of his rights. I do believe he understands them as I've read them to him. At this point in time, we'll be entering a plea of not guilty. We will not be contesting probable cause for the purposes of today's hearing. We would ask that Thurston County Public Defense be appointed. I do believe he's statutorily eligible as he is a recipient of food stamps. Additionally, I provided both address and phone number to Madam Clerk.
All right, Mr. Carmona, I will enter your not guilty plea to the charge of DUI. Also appoint the public defender to represent you. And what's the state's position on release?
Your Honor, I'm checking the NCIC report now. I've checked JABS. I'm not seeing any DUI related convictions in the defendant's history on JABS. I'm looking briefly through the NCIC report to see if there's any out-of-state DUI history. Assuming that there's not, as I'm looking through, I would just note that the defendant does have a fairly concerning criminal history, including a vehicular assault that was I'm looking just to make sure that that actually resulted in a conviction or not. I'm seeing vehicular assault in the NCIC for 2003. It does not appear that it doesn't appear to be coming up in JABS. But it is alleged to have happened in Tacoma. So I'm not sure what is going on there. But I would just note the defendant, even aside from that, does have a fairly concerning criminal history and disregard for licensing laws. So the state is not going to be requesting bail at this time. However, the state would request the standard DUI conditions with the additional requirement of pretrial services and an ignition interlock. I would note the BAC in this case was not particularly high. The BAC in this case was a 0.097. So the request for the additional supervision is primarily based on the defendant's criminal history and disregard for driving and licensing laws in general, not specifically out of DUI related concerns.
I don't think I see any need for that. And I think that Mr. Carmona is listed as a victim in that case that you mentioned. Okay. Mr. Carmona, I'm going to release you on your own recognizance. Conditions are: don't violate the law, don't drive unless you're licensed and insured, don't consume any alcohol, marijuana, or non-prescribed drugs, or go to any bars or taverns, and don't refuse a breath test. All right, and I'll get you a date for your pretrial hearing.
And
16th.
And for the record, Your Honor, you are correct. The defendant is listed as a victim in that case. I apologize.
All right, your court date is July 16th at 9 o'clock.
Well, 700.
And we'll, Mr. Carmona, we'll give you a written order there. We're not. All right, make it.
He would like text messages.
Yeah, that's good. We'll give him those. We'd make a note in the docket that he left before he got his order, in case there's any confusion later. Okay, Mr. Stashevsky.
Yes, Your Honor. Present with me is Mr. Kevin Parker, number 14 on the calendar.
All right, and Mr. Parker's here for warrant service return.
Correct, Your Honor.
So that goes back to a failure to appear for a probation hearing in October of 2024.
Yes, Your Honor. Mr. Parker shared with me,
in just a second. Thank you, sir. All right, Mr. Stashevsky.
Your Honor, present with me is Mr. Gerald Vassilatos, and I have not had an opportunity to speak with Mr. Vassilatos, Your Honor.
All right. Well, Mr. Vassilatos is on deferred prosecution for this DUI, and we have not seen him in a while. His sanction hearing was on June 25th of 2021, and that's the court date that he missed. So we need to do two things. We need to get him back on the calendar for that sanction hearing and determine whether he can be released or not. So I'm going to ask you a couple questions about that, Mr. Vassilatos. One is Judge Wilcox ordered you to start attending and providing proof of daily sober support meetings beginning June 15th of 2021. I don't see them in the file. Did you do them?
Yes, I did.
Okay. And why did you miss your court date on June 25th?
Oh, I had to go out of town. There was a death of my friend, and I didn't know who to call. I didn't have the number to call.
Mr. Vassilatos, I'll be honest with you. I have a real hard time believing or accepting that explanation. You knew you were on probation and had an obligation to report for this DUI and a court date. So where have you been during the last just about 4 years since you were supposed to be in court?
I've been living in Tenino. I wasn't aware I was supposed to be in court still.
Did you complete your treatment program?
Yes, I did. Trying to remember.
The last report we had was an inpatient portion of a program that you completed in June of 2021.
Okay, yeah, inpatient, yes. I forget the
Yeah,
name of the
it-
place.
Yeah, that was at Northwest Resources.
Northwest, right.
Yeah. And then after discharge from that intensive, you were supposed to be continuing in your treatment for level 2 intensive outpatient, and we didn't get any reports from Northwest Resources after that.
I was doing outpatient at Seymour.
At Seymour?
Based on what Mr. Vassilatos shared, Your Honor, the defense would just request a date by which he can show to the court that documentation of the treatment at CMAR. He is adamant that he's completed outpatient services at CMAR, but I believe we would need to communicate with the treatment agency to get that documentation.
State of a position.
Your Honor, this is an older case, so I was trying to look back to review the notes. My understanding is that defense back in 2021 at the last hearing, June 24th, just lists the defendant failed to appear, no bail warrant was issued, and defense made a comment about the defendant possibly being in treatment, but no proof of that was presented to the court. And the warrant, I believe, has been outstanding ever since then. My understanding is in reviewing the notes, the state has been seeking to revoke the deferred prosecution for a while, citing treatment issues. So given the state in which the case is right now, with a long-standing pending motion to revoke and a warrant that's been outstanding for years, the state would ask for the court to hold the defendant without bail pending a revocation hearing for the deferred prosecution.
Your Honor, might I respond just briefly?
Sure.
I would just highlight a couple things. That Mr. Vassilatos has been in the South Puget Sound for an extended period of time. I appreciate that he just came off a fairly significant warrant status. I believe, as he explained, and I understand the court has some skepticism there, but that there was confusion as to where he was in the process and whether that had been completed. I would highlight that since 2018, he's had, at least in Washington State, again, I don't have access to anything outside of Washington State, but at least in Washington State, there's been nothing since 2018, Your Honor. Given the representations that he's made today, we just request that he be given an opportunity to be released to go get that documentation from CMAR to provide it to the court. Mr. Vassilatos and I have not had an extended conversation today. I'm not entirely certain what his life circumstances are, but I suspect being held no bail would be very impactful there. And yeah, thank you, Your Honor.
All right. Well, Mr. Vassilatos, I do want to see proof of a couple things. One is the sober supports that Judge Wilcox ordered. Also, any treatment beyond the inpatient program that you completed. You said that was an outpatient program at CMAR, so completion of that absolutely would matter and would count in your favor. But I don't have those things, and you're on deferred prosecution, you're on probation, so you have obligations to the court. I'm gonna recognize that you've been staying out of trouble, which always counts with me, but I will give you an opportunity to post bail instead of holding you no bail. I'm gonna set bail at $5,000 and give you a court date for your probation hearing. Now, I'll tell you this, I give a lot of people this offer and very few of them take me up on it, but I hope that you're one of them. If you, while you're in custody awaiting a hearing, if you can't post bail, if you provide proof to me that you did attend that treatment at CMAR, then I will reconsider your bail or release. But if I don't see anything like that prior to your hearing, then the bail will just remain at what I just set it. So Kylie, let's have a probation violation hearing, and he's still represented by the public defender. Okay. All right, June 26th at 9:30 will be your court date. All right, Ms. Myers. Myers.
Thank you, Your Honor. I'm ready to proceed on Mr. Nava Batista. He's currently present in court. He's number 5 and 6 on the calendar.
Mr. Nava Batista. Good afternoon. All right, and today you're here in court for your arraignment on charges of driving under the influence and minor in possession that are both alleged by the state to have occurred on May 25th. Ms. Myers.
Thank you, Your Honor. I did have time to meet with him before and explain to him his rights. I do believe he understands them as I've explained them to him. At this point in time, we'll be entering a plea of not guilty to both counts. We will not be contesting probable cause as to both counts. We would be asking that our office be appointed. He's currently only 19 years old. He's residing with his parents and he's not presently employed. The last time he was employed was about a month ago and he was working at Amazon, only making about $2,000 a month. His bills right now include his phone bill, which is about $120.
All right, I will enter your plea of not guilty to both counts. Also appoint the public defender to represent you. All right, Mr. Holcomb.
Your Honor, the state has no objection to personal recognizance. I would note that the defendant doesn't have any other DUI history. However, I will note that as defense counsel pointed out, the defendant is underage. The BAC in this case was a 0.110. So it's not a high BAC for the typical DUI case, but it is a significant BAC, particularly for someone who is underage. So at this time, the state is asking for personal recognizance and is also asking for the imposition of a scram device. The defendant not only should not be driving while consuming alcohol, the defendant should not be consuming alcohol at all. And the state believes that a scram device is a good way to protect the community. And since it's going to be provide a county expense, it will also avoid the defendant being required to get an ignition interlock or some other safety device that would not otherwise be covered by the county.
All right, Ms. Myers.
Your Honor, we would object to the scram device. At this point, it's unnecessary. He's only 19 years old. He has no criminal history aside from this. And although he was underage drinking, and BAC is not necessarily alarming in connection to other BAC levels that we've seen. Again, understanding that he shouldn't have been drinking in the first place, the community risk or the community safety is not as concerning as it would be with some of the other cases we've seen pass through Thurston County District Court that have gone without a scram device. In addition to that, and his lack of criminal history, I don't think that it's necessary. I think he'd be pretty reliable to come back to court to abide by the rules, especially considering he's never been in trouble before.
All right, and I don't see anything to indicate that he can't comply with normal release conditions. So, Mr. Nava Bautista, I'll release you today on your own recognizance. While the case is pending, don't violate the law. Don't go to bars or taverns. You're not old enough to do that. No alcohol, marijuana, or non-prescribed drugs. Same thing. You're not old enough for those things. Don't drive unless you're licensed and insured, and don't refuse a breath test. All right. I'm going to give you a date to come back to court for your pretrial hearing. July 16th at 9:30. Okay, we'll give all that to you in writing here in just a second.
Thank you, Your Honor.
You're welcome.
Good day.
Your Honor, well, Mr. Stashevsky is still talking to his client. Do we have any update on Nisqually?
Anything, Kylie? Who's out there that? Placencia Arevalo?
So I can at least attest to his case. Jordan Richardson.
Your Honor, present with me is Mr. Matthew Byer, numbers 1 and 2 on the calendar.
Yes, maybe not number 2. We'll get to that. All right, so Mr. Byer is here today for warrant service. It looks like there was a failure to appear for an arraignment for the driving while suspended under the 070 case number. And then we have this other case that's a Yelm case. And I want to get that sorted out before we go any further with that. Yeah, so this case was initiated by a Yelm police officer filing a citation in court, and it alleges County of Thurston as the plaintiff.
Which cause number is that, Your Honor?
Number, the one that ends at 935. Well, in any case, since the charging document indicates that the plaintiff is Thurston County, we need to change that from City of Yelm to Thurston County. And then are you ready to proceed on arraignment on those?
Yes, Your Honor.
Okay, Mr. Stashevsky, are you ready to? You're still muted over there, Mr. Stashevsky.
Thank you, Your Honor. If this is in reference to case ending 1935.
Both cases.
Okay. Your Honor, I was of the understanding that probable cause had been found in both cases, but we're ready to proceed on the other elements of the arraignment.
Okay. So Mr. Byer, you're charged with 2 counts of driving with a suspended license in the 3rd degree, one alleged by the state to have occurred on December 11th of 2024. The other by the state again on April 3rd of 2025. Mr. Shashevsky.
Your Honor, I discussed with Mr. Byer his constitutional rights. I do believe he understands those rights. We are seeking the appointment of Thurston County Public Defense for both cases and would request that a not guilty plea be entered for both.
All right, we'll do that in our plea of not guilty for both counts and appoint the public defender's office. All right, and Mr. Holcomb, state's position on release.
Your Honor, at this time, the state's asking for bail the amount of $100 on each case. And Your Honor, the reason for that bail request is to get the defendant financially invested in the case resolving. In particular, the cause number ending in 070. I show there are, I believe, 3 failure to appears for that case. The defendant also has a long history of similar offenses. The state would also note some concern regarding the warrant history for this defendant. So given the nature of the charge, though, the state doesn't believe that high bail is at all necessary, but the state is asking for bail in the amount of $100 on each.
Okay, it looks like Mr. Bayer was taken into custody for a matter that's pending in Superior Court. Do you have any information about that?
I do not, Your Honor.
Okay, I pretty much always ask, but Mr. Stashevsky?
Your Honor, I would note that both of these charges are relatively new charges, particularly the charge ending in 1935. Mr. Bayer communicated with me that the address on file is a good address, but the situation for that, Your Honor, is that it's a P.O. box that his grandparents have access to and that he communicates with his grandparents, but sometimes they don't check it regularly. In response to that, Your Honor, Mr. Byer has provided a phone number for his mother, another close community contact that he has that this court could consider under Rule 3.2. And the mother's number can get text messages, and he's in regular contact with his mother. So I do think he would get notice today, Your Honor. He now has a communicative system with both his mother and his grandparents, and noting the nature of these charges and their recency, would request no bail, Your Honor.
I'm going to release him on personal recognizance on both of these conditions, or don't violate the law, don't drive without a driver's license and insurance. And if the state wants to hold him, they can do it on the Superior Court case number. All right, let's have a pretrial hearing date with the public defender for both. July 16th. All right, July 16th at 9:30.
Thank you, Your Honor.
All right, Mr. Stashevsky.
Your Honor, present with me is Mr. Blaine Ness, number 12 on the calendar.
And Mr. Ness, today you're here for your arraignment on a charge of driving under the influence alleged by the state to have occurred on May 25th. Mr. Stashevsky.
Your Honor, I discussed with Mr. Ness his constitutional rights. I do believe Mr. Ness understands those rights. We are seeking the appointment of Thurston County Public Defense. For the purposes of today's hearing only, Your Honor, we are not contesting probable cause, and we would request that the court enter a not guilty plea on Mr. Ness's behalf.
I will enter that plea of not guilty. I have a pretrial services report, but not a public defender application. So I will defer a decision on the appointment of counsel. All right, what's the state's recommendation on release?
Your Honor, the defendant doesn't have any warrant history in the state of Washington. However, what the defendant does have is a DUI, again, out of California. It says the final disposition date was January 21st of 2015. Under the DUI charge, it lists convicted. The state therefore is seeking both the standard DUI conditions as well as the imposition of the interlock device that's required by statute. The state is also requesting the imposition of a SCRAM device. The defendant in this case had a BAC of 0.244, which is well in excess of the 0.15 BAC enhancement. Given this is not the defendant's first DUI and the elevated BAC, the state believes that the defendant does represent a unique danger to public safety and believes that the imposition of an ignition interlock device and SCRAM is the least restrictive means to ensure the defendant isn't a danger to the community while in pretrial release.
Mr. Stashevsky?
Your Honor, I would highlight a couple things. First, as my colleague Attorney Myers shared, public defense does not have access to that out-of-state information. In regards to what was relayed to the court, I would note that that is almost 10 years that have passed. In Washington State, Mr. Ness has no criminal history whatsoever. This is his first charge. Your Honor, if the court was inclined to do a heightened condition, defense would respectfully request that that condition be limited to an ignition interlock device, as I believe that would satisfy any community safety concerns and would be the most least restrictive method of release under Rule 3.2, and that a SCRAM not be imposed in this instance, Your Honor.
All right. I need to clarify Mr. Ness's address. The citation gives an address on Elmar Drive in Winchester, Oregon. The address of record is on Fort Street in Seattle, and that's what DOL has. So which of either of those is correct?
Your Honor, I provided, and Mr. Ness, please clarify, but I provided Madam Clerk with a P.O. box in Winchester, Oregon. Is that the best way for mail to reach you?
Yes.
Okay.
I mean, both addresses are fine.
Both work, okay.
But
As long as we can get mail to you if we need to.
yes, sir. My mail goes to a P.O. box. The home itself is just a physical address that doesn't receive mail.
Gotcha. Understood. All right, Mr. Ness, I am going to release you today on your personal recognizance conditions while the case is pending. Don't violate the law. Don't drive a vehicle without an interlock. Don't go to bars or taverns. Don't drive unless you have a driver's license and insurance. Don't consume any alcohol, marijuana, or non-prescribed drugs, and don't refuse a breath test. I'll give you a court date to come back for your pretrial hearing. And I haven't screened you for public defense yet. So if you want the public defender to represent you, you can fill out a confidential financial screening form at any time and submit it to the court. Okay.
Okay, thank you.
All right, let's set a pretrial date for him. Yeah. All right, June 25th at 2 o'clock is your pretrial hearing. Okay. Okay. All right, we'll go back to you, Mr. Stashevsky.
Thank you, Your Honor. I'm here with Mr. Christopher Olson, number 13 on the calendar.
Mr. Olson, today you're here in court for your arraignment. It's on one count of driving under the influence that is alleged by the state to have occurred on May 24th. Mr. Stashevsky.
Your Honor, I spoke with Mr. Olson and we discussed his constitutional rights. I do believe Mr. Olson understands that he benefits from certain constitutional protections. We are seeking the appointment of Thurston County Public Defense in Mr. Olson's case. We are not contesting probable cause for the purposes of today's hearing only, and would request that the court enter a not guilty plea on Mr. Olson's behalf.
Okay, I will enter his not guilty plea. All right, again, I just have a pretrial services report, but not a public defense screening information sheet. All right, what is the state's recommendation on release conditions?
Your Honor, the state has no objection to first order cognizance at this time. I would note the defendant doesn't have any warrant history in the state of Washington. I would, however, also note the defendant does have a DUI from 2016, which makes the ignition interlock device mandatory. I would also further note that the BAC in this case is a 0.332 on the low end to a 0.346 on the high end. Given the and also the defendant's driving pattern was severe enough that it drew the attention of 911 callers, so a civilian witness calling into law enforcement. So, Your Honor, the state sees the defendant as a unique danger to the community, given the elevated BAC and the past DUI history. So the state is asking for the imposition of the SCRAM device, as well as the state mandated interlock and the standard DUI conditions.
Mr. Stashevsky.
Thank you, Your Honor. I would just highlight the amount of time that has passed between the 2016 DUI and here today in the spring of 2025. I'd also note, Your Honor, that the allegations included in the police report included some interesting factual recitations about an error reading in the Draeger room prior to the test being administered about ambient error. I'll be perfectly frank, Your Honor, I don't know what that means exactly. It would be an issue I'd have to look into further, but wanted to highlight, as I've never seen that before, and given the BAC in this case, if there was potentially some environmental factor possibly playing a role. And then, Your Honor, I would just, a final point would be that the ignition interlock, I do believe, would be the least restrictive method of release in this case, and that a SCRAM would not be necessary, Your Honor. And then that's all, Your Honor. Thank you.
All right, Mr. Olson, I will release you today on your personal recognizance. While the case is pending, the conditions of your release are: don't violate the law, don't drive without an interlock, don't drive without your driver's license and insurance, don't go to bars or taverns, consume any alcohol, marijuana, or non-prescribed drugs, don't refuse a breath test, report to pretrial services, you're to obtain a SCRAM alcohol monitoring bracelet, and you're approved for the county substance use monitoring program to pay for that. The allegations of the level of the breath test are at the extreme, probably 1% of the bell curve. So I agree with the prosecutor, that is something to be concerned about, and it will assist you in complying with the court's release conditions of not consuming alcohol or driving while after you've consumed any. All right, well, now I have not screened you for a public defender. You can fill out a screening sheet at any time and bring it to the court, and we'll determine if you're eligible for appointed counsel. Let's have a pretrial hearing date. All right, June 25th at 2 o'clock will be your hearing date. Okay. And